Open.
Open. ಹೇಳಿ ಅವ್ರಿಗೆ ಮೈಕ್ ಆನ್ ಆಗಿದೆ, ಅವರು ಆಫ್ ಮಾಡಿದ್ದಾರೆ. ಕೋಟಿಗೆ ಇಳಬೇಕು.
ನಾನು ನೋಡ್ತೀನಿ ಗೊತ್ತು.
Notice is served on the
Give it,
parties
sir.
of counsel.
No, there's no stay in the matter, my lord.
Give it. 2:30 ga ಯಾಕೆ ಹಾ
$230.
My lords, it's a GMCPC fresh matter, my lords.
Fresh.
My lords,
GMCPC, please give.
we have made an application for cross-examination, my lords. They've rejected the application. It is posted today, my lords. They're giving frequent days, like in 2 days, my lords.
All right, 230. ಕೊಡಿ ಅದು ತಗೊಳ್ಳಿ ಮೇಡಮ್, ಎಂಟ್ರಿ ಮಾಡ್ರಿ, ಏನು ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ. ನಾಳೆ ಬೆಳಗ್ಗೆ ಹಾಕಿ ಮೇಡಮ್, ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ಬೈ 230. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಟುಮಾರೋ ಆಗಲ್ಲ, ಗಿವ್ ಇಟ್ Friday ಅಷ್ಟೇ, Friday or Monday, give it is. Friday ಹಾಕಿ ಮೇಡಮ್.
Sir, this matter is for hearing, my lord. The notice is out on both the parties, my
Give
lord.
it, sir. Yes. Wednesday. I have released all of them from part heard. Yes. ನೀವು ಹೇಳಿದ್ ನಿಮಗೆ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ, ನನಗೇನು ಕೇಳಿಸ್. ಮಂಡೇ ಲ್ಯಾಂಡ್ acquisition, CPC, give it. It will come next Wednesday.
My lords. My lords, this is criminal petition, my lords.
Friday.
The matter was
Friday.
GMCPC ಇಲ್ಲ, ಇವತ್ತು ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೇಸ್ ಇದೆ ಸ್ವಾಮಿ, ಅಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಮಾಡ್ಬೇಕು. ನಾವು ಎವಿಡೆನ್ಸ್ ಮಾಡ್ಬೇಕು.
230
ಇಲ್ಲ, ನಾಳೆ
ಮತ್ತೆ ನಾಳೆಗಾಗಲ್ಲ, ನಾಡಿದ್ದು. ಎಸ್, ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಕೊಡಿ. ಸೇಲ್ ಫಾರ್ ವಾಟ್? Commercial execution. No, 230. Give it, please. Day after tomorrow. Day after tomorrow. Which order? ಅದು ಫ್ರೈಡೇಗೆ ಹಾಕಿ ಮೇಡಮ್. ಆಯ್ತು, ಕೊಡಿ. ವಿಲ್ ಟೇಕ್ ಇಟ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ವಿಲ್ ಟೇಕ್ ಇಟ್. ಗಿವ್ ಇಟ್. ಎಸ್, ಮೆಮೊ ಕೊಡೋದು ಕೊಡಿ ಅಷ್ಟೇ. ನೋ ಡೇಟ್ ಆನ್ ದಟ್. ಎಸ್, ಕಾಲ್ ದ ಕೇಸಸ್. ಶಿವನಿ ಅವ್ರಿಗೆ ಪಾಸ್ ಓವರ್ ಮಾಡಿ. ಮೇಡಮ್, ಎಲ್ಲ ಕೇಸು ಕ್ಲೋಸ್ ಆಗಿಲ್ಲ. ಐ ಹ್ಯಾವ್ ಟು ಡೂ ದಿ ಥಿಂಗ್ಸ್ ಅಂಡ್ ಸೇ, one BDA case you have sought for masking, one LB BMP you have sought for masking. What is all this? You should do your diligence and then file a memo at the pending cases. BBMP case allo masking beka? What is this? What revised memo? Nothing in the revised memo. All same things. This is not the way to file a memo. Check every case, status of every case, and file it before the court. Seeking mask. Criminal case I can understand. ಒಂದು ಯಾವುದು BDA ಇದೆ, ಒಂದು BBMP ಇದೆ, ಅದೆಲ್ಲದರಲ್ಲೂ ಮಾಸ್ಕಿಂಗ್. You don't want to be shown as a litigant at all, is it?
My lord, may I make a mention, my lord?
We'll take it day after tomorrow. Do the needful and get it. Yes, next.
My lord, may I mention one matter, my lord?
Adjournment.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಮೆಮೊ.
My lord, this is a matter in further hearing, my lords. It's a criminal matter. It is connected with the issue, my lords, yesterday, that NCLT matter, my lord.
ನೋ, ಅದು ಡಿಸ್ಮಿಸ್ ಮಾಡೋಣ, ಕೊಡಿ ಎಲ್ಲ.
ಹೌದು, ಅರ್ಜೆಂಟ್ ಇದೆ ಸ್ವಾಮಿ ಅದರಲ್ಲಿ. ಬಿಕಾಸ್
ಅದು ಫ್ರೈಡೆ ಹಾಕಿ ಮೇಡಮ್.
GMCPC, my lord.
ಮೆಮೊ ಆಯ್ತು. ವಾಟ್ ಇಸ್ ಗೋಯಿಂಗ್ ಆನ್? ದಟ್ಸ್ ಓವರ್.
Monday, my lord.
Give the memos. Give all the memos. Give the memos. GMCPC. ನೆನ್ನೆ ಇತ್ತಲ್ಲ ಅದು. ಆಲ್ ರೈಟ್. ಎಸ್. Cell number 2. Yes, government. You were to make a statement.
Brief synopsis, date-wise prepared. Could I kindly pass on?
Yes, who is?
1960.
What is the relief sought? There is an interim order, right?
There is an interim order.
Yes.
And the detailed orders from time to time it is passed and directions are issued. Now in my synopsis, the last portion, my lord, is the verdict of the sample court where the extent they have acquired and what is the extent they are retained in Dodda Karlasandra. That's item number 12, my lord.
Is it covered by this?
Yes.
Huh? Yes. ಓದಿದ್ರೆ ಹೇಳಿ, ಇಲ್ಲ ಅಂದ್ರೆ will grant you time till day after tomorrow. If you fumble, then I will not grant time. Yes, ನೀವು.
Some of the areas, there has been a development by the cooperative communities where there was a parallel acquisition by state government. Under those circumstances, to see whether the substantial implementation.
Government was asked to do, it's your job now.
And even the.
ಇದು ನೋಡ್ಕೊಂಡ್ ಬರ್ತೇನೆ ನಾವು.
Please, my lord. Entire.
Let's day after tomorrow,
plan
same stage.
And whether they have taken possession or not, all those things on the previous date, the sample court directed them to produce.
Yes, madam. If you're not ready, I'll allow the petition. Yes. List on this day after tomorrow in the same stage.
Please, my lord.
Interim order subsisting will absolute idea?
Yes.
Absolute idea.
Absolute.
Interim order
Absolutely,
subsisting will
they-
continue till the disposal of the petition.
Oblige.
Yes. The rule issued on 17/3, why is preliminary hearing? You have not utilized the road.
No, on 6/6/2023, this lordship has ordered to conduct a survey
Huh.
and prepare the Mahajar.
Huh.
As for the.
Mic ತಗೊಳ್ಳಿ, mic ಇಲ್ವಾ ಅಲ್ಲಿ?
I'm sorry. As for the survey sketch, they themselves stated that they are utilized the four guntas of land in survey number 137.
ಅದು ತೋರಿಸ್ಬಿಡಿ
Yes,
ಸಾಕು.
madam. Yes. This is their own statement. Joint memo, spot inspection also.
No, see, ಈ ಕೋರ್ ಡೈರೆಕ್ಟ್ ಮಾಡಿದ್ಮೇಲೆ ಸರ್ವೆ ಏನಾಗಿದೆ ಅದು ಹೇಳಿ.
Yes, they filed the survey report also.
Which is that ಕೊಡಿ ಇಲ್ಲಿ.
Survey report ಹಾಕಿದ್ದಾರೆ. Yes, survey report.
11/6/24. Where is that, madam? ಕೊಡ್ತೀರಾ? 11/6/24. ಇಲ್ಲಿ ಇಲ್ವಾ? ಅಷ್ಟೇನಾ? Yes. ಆಯ್ತು ತಗೊಳ್ಳಿ. ಅವ್ರು ಕೊಡಿ. ಇದು ಬ್ಲೂ ಅಲ್ಲಿ ಇರೋದು ಯಾವುದು ಬಿಡಿ ಅದ? ದಟ್ ಈಸ್ yours. ಜಾಯಿಂಟ್ ಸರ್ವೆನಾ ಇದು?
In the absence of me, madam. No, sir.
What survey is that in the absence? It is better to joint survey ಮಾಡಿದ್ರೆ he would have no case now. How many times? The petitioner is claiming a certain portion of land of his being used by the BDA for the formation of road without paying any compensation. The extent of land is said to be 4 guntas. To be precise, 3.62 guntas. 62 alla. 62 na? 4 guntas of land. This court, in terms of its earlier order, had directed conduct of a survey by the BDA. The survey sketch and the report is placed before the court. The learned counsel K. Krishna, appearing for the BDA, submits that that what is claimed by the petitioners is a private layout and no portion of the said layout or the property that the petitioner is claiming is used by the BDA. The survey sketch is in vindication of the said contention is the submission of the learned counsel for the respondent BDA. The learned counsel for the petitioner now submits that the survey did not take place in the presence of the petitioners. Therefore, what they have done is on their own volition. In that light, to steer clear the controversy, I deem it appropriate to direct the BDA to conduct a joint survey in the presence of the petitioner. Yavat ಮಾಡ್ತೀರಾ? In the presence of the petitioner, the survey shall be conducted on the 25th of June at 11 a.m. No separate notice need be issued to the petitioner as the petitioner is now represented by the counsel. The report of such survey will be placed before the court on the 1st of July 2025. List the matter on 1st of July. ಅಲ್ಲಿ ಜಾಯಿಂಟ್ ಸರ್ವೆನಾ?
ಅದರಲ್ಲಿ 2 quintas they are utilized even without initial acquisition proceedings.
ಅಲ್ಲ ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದೀರಾ? ಅದೇನಾದ್ರು ಕಾಂಪನ್ಸೇಷನ್ ಕೊಡ್ಬೇಕು. Correct. Aith, we'll see on the same day we will see.
In similar matters, they were provided 100% of this.
The learned 3.1 al barkoli. Learned counsel K. Krishna submits that a portion of the property of the petitioners have been 2.5 guntas, i.e. 2.5 guntas has been utilized by the BDA, and therefore the petitioners are entitled to compensation qua the usage of land, i.e. 2.5 guntas. He would submit with regard to the compensation on the next date. List on same day. Then first 4 ಏನು?
Last cases, this lordship has directed to place the SLP order.
Please, may I pass on notes?
ಕೊಡಿ. ಇದು division bench.
Plus, this order was taken in appeal before the Honorable Supreme Court. my lords.
Yes, what happened?
Plus, there the order was set aside.
And
My lords, it was held, my lords, that there can't be direction, my lords, to the BDA asking to collect 21% interest as regards allottees who don't pay the amount in time. This is also the same case, my lords.
No, this is a different case. my
ಅಷ್ಟೇನಾ?
lord. No, this is a different case, my lord. This is not arising out of the SLP, my lord. This lordship has ordered on.
division bench covered ಅಂದ್ರೆ?
No. See,
Division bench, my lords, had held, my lords,
my lord,
that
after cancelling the order.
ಆಯ್ತು ಹೇಳಿ. Come on, merits.
Yes, ma'am. Then kindly annexure E may kindly be seen, my lord. Page 23. Therein, my lord, he was allotted a site in the 2003.
2003
3.
ಅಂತೀರಾ ಇಲ್ಲಿ?
ಅಲ್ಲ 3 ನಲ್ಲಿ ಅಲಾಟ್ಮೆಂಟ್ ಆಯ್ತು 3 ನಲ್ಲಿ ಅಲಾಟ್ಮೆಂಟ್ ಅದು 4 ಅಲ್ಲಿ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದೆ.
Page.
Page 29, ink page 29. He was in he was service in the army. He could not pay the balance settle amount. He was in out of state for his service.
Oh, this.
Yes, my lord. Yes, my lord. After retirement, my lord, he came to know that cancellation order came to be passed. Now he has challenged the cancel order before the lordship. After hearing both the parties, the lordship has set aside the cancellation order and directed the petitioner to pay balance settle within a period of 4 months. So due to pandemic COVID-19, he could not able to pay the balance settle amount. Hence, it has been cancelled. And I filed the content petition. Content petition was clearly pointed out that, my lord, page 40 may kindly be seen, my lord. Page 40. May I read, my lordship? It is pertinent to observe that here the BDA, being a statutory authority, should act as a mother to all the allottees and should not treat as a person who approaches his enemies. Because, my lord,
ಯಾರು ಹೇಳಿರೋದು?
contempt court.
Correct.
And court has imposed the 50,000 cost also. Because, my lord, they say, I was directed to pay the balance within a 4 month. And cancellation order has been set aside. So I could not pay because there is a pandemic COVID-19 in the year 2021.
ಹೇಳಿದ್ರಲ್ಲ?
Yes, ma'am.
ಮತ್ತೆ
But
pandemic
is the reason, my lord, he has cancelled the once again.
Correct.
He has not paid the amount within as per the direction of the Supreme
This
Court.
was challenged before the Supreme Court.
This order has not been challenged.
ಇಲ್ಲ,
my lord.
identical orders were challenged.
No, that is, my lord, in the 40, 20, 30 sites, the circular was issued in the 2011.
Now, 1 minute, sir.
Please,
You come to the order that you are placing reliance upon of Justice Krishna Kumar.
yes, my lord.
ಅದರಲ್ಲಿ ಏನ್ ಬರ್ದಿದ್ದಾರೆ ಹೇಳಿ? You said this is identical, all right. Now, you come to, ನಿಮ್ ಕೇಸಲ್ಲೇ ಬರ್ದಿರೋದ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ನಮ್ ಕೇಸಲ್ಲಿ ಬರ್ದಿಲ್ಲ.
ಯಾರು?
This is, my lords has page
Kemparaju.
23. ಹೌದು.
ಕೆಂಪರಾಜು, identically placed?
Please, my lords, please. In fact, my lords, this
ಕೆಂಪರಾಜು
order,
SB ನಿಮ್ದೇ.
in fact, my lords, this order is also under challenge.
Justice Krishna Kumar ಅವ್ರದ್ದು ಆರ್ಡರ್ ಏನು?
ಹೌದು ಸ್ವಾಮಿ.
ನಿಮ್ದೇ ತಾನೇ ಅದು?
ನಂದೇ ಅದು.
ಅದೇ ಹೇಳಿದ್ದು. ಅದ್ರಲ್ಲಿ ಏನ್ ಅಲೋ ಮಾಡಿದ್ದಾರೆ ಹೇಳಿ?
ಅದು ನಮಗೆ ಸೈಟ್ ಕೊಡಿ ಅಂತ ಆರ್ಡರ್
ಅದೇ
ಮಾಡಿದ್ರೆ.
ಯಾವ ಕಾರಣಕ್ಕೆ ಕೊಟ್ಟಿದ್ದಾರೆ?
Because he was-
Come to paragraph 8, sir, because he was ಅಲ್ಲ. Come to paragraph 8. The petition is allowed in terms of decisions of this court in
Yes,
4 ಕೇಸ್ ಹಾಕಿದ್ದಾರೆ.
ಹೌದು.
Impugned order is quashed. In terms of the orders passed, he has directed payment in 21% also.
Please,
Now, these orders were taken to the Supreme Court, correct?
please, my lords, may just see the writ appeal order page, my lords.
No, because the special provision, section
Special
5,
provision.
section 5 of
Sir,
the.
I am bound by what Supreme Court says or the division bench says. Even the coordinate bench, but coordinate bench, yes, that is now set aside.
No, apart from that, not section 5 of the BDA Act, there's a specific provision to allot the site to ex-servicemen. In that category also is entitled to get the site.
That
also.
category you apply and take. But in the category that you are now seeking, Supreme Court has set everything aside. ಇದು ಯಾವ್ದು orders?
Page 15, my lords, of the memo which I just submitted.
Yes,
There, my lords, all these orders, my lords, were taken into consideration.
page 15.
Page 15, it commences with that. Right? If my lords have, my lords.
Page
just
15 is the division bench order.
Please, my lords, because all these were considered by the division bench and then taken to the
So,
Honorable Supreme Court.
ಗೊತ್ತಾಯ್ತು. What is the direction by the division bench?
Let's, direction by the division bench, my lords, page 156, my lords, 155 onwards, para 133.
155,
Please, page 155,
ah.
para 133, if I may just. May I just read?
133.
Please, I
Yes.
just read. For the reasons stated above, the first point raised for consideration in the present intra-court appeals has to be answered in the negative, holding that BDA has not made out any case to interfere with the impugned orders passed by the learned single judge, directing BDA to allot alternative site after receipt of remaining settled value with 21% interest in terms of circular issued by BDA. Accordingly, second point is answered in the affirmative, holding respondents' allottees are entitled for relief sought in the writ petitions as contemplated under Articles 14 and so on. So, at para 135 is the operative portion, let's. The second portion of it, the orders passed by the learned single judge allowing writ petitions in terms of decisions in the cases of Jay Kumar Shetty, Kempamma, Mohan Kumar, Manjunath are in WP number so and so, respectively, directing the Bangalore Development Authority to take steps to allot sites, subject sites or alternative sites in favor of the respondent writ petitioners within a period of 3 months from the date of payment of remaining settled value with 21% interest are hereby confirmed. This was the order which was taken in appeal.
To direction to take necessary steps to allot the site, not.
Yes, sir.
In fact, even division bench, my lords, the previous para 131.
That's all right. Now, ನಿಮ್ಮ ಡೇಟ್ ಹೇಳಿ 2004, what is the date of allotment?
Please.
6th February 2004, correct?
6 February 2004, my lords.
What is the amount to be paid?
49,900, my lords.
What did he pay?
He did not pay the amount, my lords, other than the initial deposit which he is required to make at the time of filing the
Initial
application.
deposit ಎಷ್ಟು?
That has been paid, no. Initial deposit of 7,100 was paid.
7,100.
100 was paid.
ಆಮೇಲೆ
ಆಮೇಲೆ ಅವರು ಕಟ್ಲಿಲ್ಲ, ಯಾಕಂದ್ರೆ ಬೇರೆ ಸ್ಟೇಟ್ ಟ್ರಾನ್ಸ್ಫರ್ ಆಯ್ತು. he was in service in army. So ಹಾಗಾಗಿ he was servicing in various.
So that is rejected by this order.
Yes, my lord.
Page 31.
Yes, my lord.
So after 18 years, you remembered that you had paid something for a site in BDA.
Due to that reason, my lord, he was not aware of the proceedings.
Correct. What proceed? No proceeding has happened.
ಅಲ್ಲ, the cancellation order has came to be passed.
Cancellation order ಯಾವಾಗ ಪಾಸ್ ಮಾಡಿದ್ರಿ?
Cancellation
on
order
Annex
was
D
passed
on 12 to
17
2006.
to 2006.
ಅವಾಗಲೇ
Within a-
ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ವಿ.
Yes, madam, within a period of 2 months, 2 years, madam, as per the allotment rules,
ಕಂಡೀಷನ್ ಅಲಾಟ್ಮೆಂಟ್ ಕಂಡೀಷನ್ ಪ್ರಕಾರ ಯಾವಾಗ ಕಟ್ಟಬೇಕಾಗಿತ್ತು?
3 years ಇರುತ್ತೆ ಸರ್.
ಎಲ್ಲಿದೆ?
2030 ಗೆ
1 minute, ವೇರ್ ಇಸ್
Rule 13 months.
ರೂಲ್?
Rule 13.
Rule
ಕೊಡಿ
13.
ಯಾವ್ದ್ರದ್ದು?
Please.
Rule 13 of-
ವಿಲ್ ಕ್ಲೋಸ್ ಇಟ್. ಏನಿಲ್ಲ.
No, madam. Rule 13(1) says, my lord, the who person is allotted under the economical
Rule
vehicle.
13 of what rules?
No, it's Bangalore allotment of site rules 1984.
ಅದ್ರಲ್ಲಿ ಇದೆಯಾ?
It is 3 years. The person allotted under the economical vehicle section to measure in 20 into 30, the balance amount is required to be
Oh,
paid within a period of
yes.
3 months from the date of allotment.
My lords, he was given opportunity, my lords.
ವೇರ್?
My lords, Annexure D,
Annexure,
Annexure D,
page.
page 22.
My lord.
In fact, my lords, I need to bring to my lords notice, writ appeal has been filed as against the order at Annexure E.
13B may read.
Anyway, Supreme Court has now.
Please,
Well, 13B may read, my lord.
ಯಾವ
30.
19/7/2005
Ru-
ಏನ್ ನೋಟಿಸ್ ಕೊಟ್ರಾ? ಆಮೇಲೆ
please. 19/7/2005 notice was issued. Since he did not comply with the same, my lords, thereafter the cancellation order came to be passed.
ಈಗ 3 years ಬಾರ್ ಇದೆಯಾ ಅದ್ರಲ್ಲಿ?
ಹೌದು ಸ್ವಾಮಿ ಇದೆ.
ಒಂದ್ ನಿಮಿಷ, ಯಾವ್ದ್ರಲ್ಲಿದೆ?
ಇಲ್ಲ. ಬಂದ್. What's the,
Rule 13B.
please. What's 13 is the conditions of allotment and sale, my lords. Rule 13(1), the allottee shall within a period of 60 days from the date of receipt of notice of allotment paid to the authority, the balance title value deducting the initial deposit. If the balance title value is not paid within a period of 60 days, the authority may on application of the allottee extend the time for payment for a further period not exceeding 120 days as a final chance. And the allottee shall pay an additional interest at the rate of 18% on the balance title value for the first 30 days of the extended period, and at the rate of 21% for the next 90 days of the extended period. Here is the where the 21%.
13B is
interest
very
concept
clear,
come
madam.
up,
To
madam.
my case,
90
madam,
days 21%.
Beyond the period, my lords, it will be 21%. That is where the 21%.
Beyond
interest given.
beyond 90
One
days.
moment.
Beyond 90 days.
Please, my lords. If they don't, for the additional period of 30 days, my lords, then the 21% interest is what was fixed. Not otherwise.
Lordship, 13B is very clear, madam. 13B may kindly be seen. madam.
Apex Court has held. sir.
No, madam.
My lords, the allotment may kindly,
Cancellation
the
order
allotment letter may kindly.
is
be seen
duly
at Annexure
violated the
D,
rule
my lords, for a
13B.
moment.
13B may kindly be seen for a moment.
One moment, sir.
Yes.
Annexure
13B,
A,
my lord.
page 11, my lords.
I am there.
Please, my lords. This is
Yes.
the allotment letter.
Hmm.
Please note, my lords, this is a general allotment made.
Hmm.
This is not
13B,
an
my lord.
allotment made under the separate category of SC or ST, my lords. What my learned friend is now trying to refer to is not the general rules.
No, who has allotted this site measure 6 into 9 meters?
1 minute, sir. What allotment rules are these? Why SC, ST you bought?
Plus, they wise, they're trying to say, my lords, 3 years and above. And there's an additional period which is fixed so far as the persons of SC or ST is concerned, my lords.
Hmm.
Not for the general category. This is a general category allotment.
So that 21% is for a,
Yes, that is for the general ones. 13(1), which I read before, my lords.
13B may kindly be seen.
wait, sir. 1 minute. Conditions of allotment.
Please, madam.
13(1) ಏನು?
That is one is.
ಎಸ್
not a-
ಅಜಯ್ ಕುಮಾರ್,
Yes,
ಬುಕ್
please.
ಇಲ್ವಾ?
The book have given.
ಯಾರ ಹತ್ರ ಬುಕ್ ಇಲ್ಲ? ಸೀರಿಯಸ್ಲಿ? ಎಸ್. ಬುಕ್ ಇಲ್ಲ ಅಂದ್ಮೇಲೆ ಕೇಸ್ ಇಲ್ಲ. ಎಸ್. ನಾವು ರೀಡ್.
Please, my lords. 13(1).
Allottee shall within 60 days from the date of receipt of notice pay so and so.
Please.
Provided that a scheduled caste and scheduled tribe so and so economically, balance site will pay to sub rule within 3 years from equal installments. ಇದು ಯಾವ್ದ್ರಲ್ಲಿ allot ಆಗಿರೋದು?
ಇದು economical weaker section.
Economic,
Yes,
Page 11 my lord.
ಅಲ್ಲ,
number 6.
economic weaker sectionಗೂ 3 months ಇದೆಯಲ್ಲ?
3 years ಇದೆ sir,
3 years ಇದೆ.
3 years ಇದೆ.
Balance of the value
But
required
at
to
the
be
site
paid.
measure
ಅಲ್ಲ,
six-
balance ಬಿಡಿ, ಇವತ್ತು 20 ವರ್ಷ ಆದ್ರೂ ಕಟ್ಟಿಲ್ಲ, 3 years ಬೇರೆ ಮಾತು. Yes.
Notice was issued my lords calling upon my lords. Had he replied to that perhaps
ಆ ನೋಟಿಸ್ ಎಲ್ಲಿ ಕೊಟ್ರಿ?
17 the last known address.
Why did you cancel even before expiry of 3 years?
Because he has not responded to the same.
No, because
He has not responded to the
if
same.
you're not responded, the rule is very clear. My lord, the
19/7,
balance amount is
2005 I
required
have-
to be paid
When wait, sir. When did you cancel it?
Was 17 to
2006, sir.
2006.
within 2 years.
After
But it would be an exercise in futility to send it back today, only to get an order that you are not entitled. Yes, sir.
Pardon me?
Supreme Court has now said you can't do it.
No, my lord, the act is very clear. He has violated
Even if
the,
I have not
violated the
cancelled,
rule.
my lords,
See,
even if I have not
who has
cancelled, at
allotted
this
the
stage
site,
it can't be done is what the order
who
says.
has allotted the site within
What
6
we
into
cancel
9 meters, the balance amount is required to be paid within a period of 3 years from the
No
date
problem.
of allotment.
Did you pay,
Even
sir?
without giving the opportunity.
Did you pay, sir?
No, because there was a time he has cancelled within 2 years. He
ಅಯ್ಯೋ,
has violated
ಆಮೇಲೆ
the
ಆದ್ರೂ
rules.
ಏನಾರು ಕೊಟ್ಟಿದ್ದೀರಾ, ಕೊಡ್ತೀನಿ
ಆಮೇಲೆ
ಅಂತ.
ಸ್ವಾಮಿ ಸರ್ವಿಸ್ ಮಾಡ್ತಾ ಇದ್ರಿ,
Ah,
ನಮ್ಮ
no.
ಆರ್ಮಿ ನಾನು ಬಾರ್ಡರ್ ಇದ್ದಾಗ ನಾನು ಅಲ್ಲ ಅವ್ರ ಬಾರ್ಡರ್ ಇವತ್ತು ಯುದ್ಧಕ್ಕೆ ಹೋದಾಗ ನಾವು ಇವತ್ತೆಲ್ಲ ಆರಾಮ್ ಕೂತ್ಕೊಂಡಿದ್ದೀವಿ AC ನಲ್ಲಿ.
ಆಯ್ತಾಯ್ತು.
So because he is unable, he could not pay because he is.
Ex-service man apply ಮಾಡಿ. If you are getting it, take it. In this we will not. One who has forgotten.
It's not forgot, it's not on the
What else,
not on the negligence part of the.
ಇನ್ನೇನಿದೆ ಸರ್,
No,
ಒಂದು
after retirement.
ಒಂದ್ ನಿಮಿಷ, ಒಂದು ಕಮ್ಯುನಿಕೇಶನ್ ನಿಮ್ ಸೈಟ್ ಬಗ್ಗೆ ನಿಮ್ ಸರ್ವಿಸ್ ಅಲ್ಲಿ ಮಾಡಿದ್ರೆ ಹೇಳ್ಬಿಡಿ. ಒಂದೇ ಒಂದು ಕಮ್ಯುನಿಕೇಶನ್,
Communications.
ಒಂದೇ ಒಂದು ಕಮ್ಯುನಿಕೇಶನ್ ತೋರಿಸಿ.
Service reports ಎಲ್ಲ ಹಾಕಿದ್ದೀನಿ.
ಸರ್ವಿಸ್ ರಿಪೋರ್ಟ್ ಬಿಡಿ, ಐ ಆಮ್ ಆಸ್ಕಿಂಗ್ ಫಾರ್ ಅ ಕಮ್ಯುನಿಕೇಶನ್.
Because I was not there at the
ಯಾಕೆ
time.
ಅಲ್ಲಿಂದ ಲೆಟರ್ ಬರಲ್ವಾ ಇಲ್ಲಿಗೆ?
ಇಲ್ಲ ಮನೆ ಕಳಿಸಿದ್ದಾರೆ. I was in the rented
ಅಲ್ಲ,
house.
ನಿಮಗೆ ಎಲ್ಲಾರು ಇರಿ, ನೀವು ಅಲ್ಲಿಂದ ಕಳ್ಸಕ್ಕೆ ನಿಮ್ಗೊಂದು ಕಮ್ಯುನಿಕೇಶನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಬಿಡಿಗೆ.
RB border.
ಮರ್ತ್ ಬಿಟ್ಟಿದ್ದೀರಾ. Now the value is very high, you want it.
No,
That's
not
all,
like that.
nothing
Only
else.
after retirement I came to know that site was allotted under that category. Immediately I approached the court,
Whose phone is
approached the
that?
honorable this court for challenging the cancellation order, and this had the cancel order has been set aside, directing me to pay the balance settle amount. Because he has violated, the rule is very clear, 13B, the who has allotted the site with 6 into 9 meters, the balance amount is required to be paid within 3 years from the date of
Have
allotment.
you paid?
No,
Your
Malad,
cancellation ಗೊತ್ತೇ ಇರಲಿಲ್ವಾ ನಿಮಗೆ?
no, because
know.
that's what Malad has.
Sir, 1 minute.
Yes,
You didn't know cancellation.
please.
You could have paid.
No, cancellation
You
order
didn't know,
itself.
you forget cancellation ಗೊತ್ತಿಲ್ಲ ನಿಮ್ಗೆ. ಗೊತ್ತಿಲ್ಲ, actually ಗೊತ್ತಿಲ್ಲ.
Yes, yes, yes.
ಅಲ್ವಾ?
Only
ನೀವು
after retirement.
ಎಲ್ಲೋ
Yes.
ಇದ್ರೆ ಗೊತ್ತಿಲ್ಲ.
Yes, yes.
ಪೇ ಮಾಡ್ಬೋದಿತ್ತಲ್ಲ.
Yes, my lord.
ಪೇ ಮಾಡಿದ್ರೆ ಅವ್ರು ಕ್ಯಾನ್ಸಲ್ ಆಗಿದೆ ಅಂತ ಅವಾಗ ಹೇಳ್ತಾರೆ.
But before cancelling, so cause note has to be issued. No
That is
notice-
issued, sir.
No note has been issued. So they are violated the rules, the rule
ಇದೆ, ಇದೆ
13B.
sir.
You violated the 13 rule B because only after lapse of 3 years,
No, no,
the
sir.
cancellation order came to be passed. Within 3
Yes.
years, the cancellation order has
Anything else,
been
we
issued.
spent lot of time on this. You apply under the ex-serviceman quota, if you
Grant
get
me
it, you
liberty
get it.
to approach that category. my lord.
Yes. Order ಮಾಡ್ಲಾ, withdraw ಮಾಡ್ತೀರಾ?
Order, madam.
Madla? Yes. The petitioner, an ex-serviceman, is before this court calling in question an endorsement dated 11/1/2022 by which the representation of the petitioner dated 24/11/2020 comes to be rejected for allotment of a site. The heard so and so. Facts enumerated are as follows. The petitioner was allotted a site bearing 2316 in Sir M. Vishweshwaraya layout, 8th block, Bengaluru, on 6/2/2004. The petitioner is said to be, petitioner claims, petitioner avers that he was appointed in the Indian, whose telephone is that? Appointed in the Indian Army as a fitter on 17/5/2003, and he served the Indian Army and comes back after 17 years and comes back on retirement on 28/2/2009. 2019, sorry, comes back on 28/2/2019. In the interregnum, certain developments take place. The allotment In terms of the allotment letter or the rules of allotment, the petitioner had to fulfill the conditions of allotment as ordained in the conditions appended to the letter of allotment. 7,100 rupees was paid by the petitioner, paid by the petitioner along with the application for such allotment and at the time of allotment. Later, he appears to have forgotten about the site that he had been allotted by the BDA and the amount that he had to be paid. The BDA then issues a show cause notice on 19/7/2005. The notice reads as follows. Page 21. Ostensibly, since the petitioner was not available, he did not reply to the said notice. Non-reply of the said notice and non-payment in terms of the conditions of allotment leads to cancellation of allotment on 17/2/2006. The order of cancellation of allotment reads as follows. 16 years pass by. The petitioner then retires from the Indian Army as a fitter, Indian Army, on 28/2/2019, returns back home, realizes that he had been allotted a site in BDA, by the BDA in the aforesaid layout in the year 2004. Then approaches this court on the score that he is identically placed to all those persons who had been directed allotment of site on receipt of 21% of penalty.
Sorry, the allotment, the cancellation order passed on not on a delay payment. He not paid the amount. Yes, I am not made 3 attempts. In the division bench also.
Court ಮಾಡಿದಲ್ಲ ಬಿಡಿ ಪರವಾಗಿಲ್ಲ. Yes, the coordinate bench in the case of the petitioner allows the petition by the following order, page 28 and 29. The coordinate bench allowed the petition in terms of the order passed by the 4 coordinate benches, which were taken in appeal by the BDA to the division bench, before the division bench in writ appeal.
49 of 2022 and other.
49 writ appeal 518 of 2016 and connected cases. The division bench dismisses the appeal filed by the BDA by the following order, page 1, memo alli, para 133 to 157. The petitioner is before the court claiming the same benefit as is directed by the learned single judges and as affirmed by the division bench. Counsel for the respondent submits that those orders were carried in appeal, in special leave before the apex court, and the apex court has upturned the order passed by the division bench and all other connected cases in terms of its judgment dated
14th May 2025.
25.
Please.
14th May 2025. The order of the apex court is as follows. Page 161 to 166. The apex court clearly observes that persons who have been allotted sites and have failed to pay the amount or sat at home silently for over 6 years and then approach the High Court for obvious reasons of hike in the market value should not be entertained, and all those directions issued by the learned single judges and the division bench is set at naught. The further direction is that whoever has deposited the amount, their amounts would be refunded by the BDA with interest at 7% per annum from the date of deposit till the actual payment thereof. In that light, the judgments with regard to the allotment being handed over to the allottees who have not been diligent is steered clear by the apex court. The petitioner is one of those allottees who pursuant to the allotment had forgotten about his allotment, not for a year or two, but close to 16 years from the date of allotment. After 16 years comes and files a petition seeking the same benefit that was granted to all other allottees. The benefit that is granted to all other allottees in terms of what is found in the judgment of the coordinate bench today is no longer in subsistence, as the apex court has set all the orders aside and has directed refund of the amount from the hands of the BDA to the BDA to those respective allottees. The petitioner comes, the judgment rendered by the apex court would cover the issue at hand on all its force, FOURS, on all its force. The petitioner seeks to distinguish the same on the score that in terms of the allotment rules, so and so, allotment rules with particular reference to allotment 13(1)(b), he would contend that the cancellation of allotment could not have happened prior to the expiry of 3 years. While that may be correct, the learned counsel at the same breath would contend that he was not aware of the order of cancellation. There is not a titter of paper produced by the petitioner to demonstrate that he was in communication with the BDA and he was communication with the BDA that he is willing to pay the amount. It is for the first time he files a petition before this court, before this court as quoted herein above, 16 years after the allotment, or after the allotment. The issue standing fully answered by the judgment of the apex court, the petition would necessarily fail and is accordingly rejected. Accordingly to be rejected. The learned counsel for the petitioner at this juncture submits that he is an ex-serviceman and is entitled to a site being an ex-serviceman. If he is so entitled to under the relevant rules, it is open for him to submit a representation on that quota, in terms of that quota. The petition, insofar as his claim is to the allotment of the 2004 site, fails in the light of the apex court, judgment of the apex court. Finding no merit, petition stands rejected.
5.
This my lord, this one also has questioned me to trace the file which is of the 62, 63. Why the compensation is not paid, my lord? I have
Not paid.
not paid.
Huh.
But here, my lord, the payment by them after the occupancy right was granted in the year 68 and 69 in HOA was also not found, and it was set off.
Not found on the yartappu.
It was not found in the record itself. They have not given, and further they have not produced.
So
here
it is an admitted fact, no compensation is paid.
The compensation is set off as their application.
Set off for what?
Set off for the grant itself, my lord. The acquisition.
Where
was
is that?
made-
Where is the grant order?
My lord, 25 may be great. Page number 25, my lord. Page number 25, typed copy of the application, what they have made.
25.
Yes, ma'am.
Huh.
In that, the occupancy price may be adjusted out of the compensation to be paid under section 9 of the act. In the
Yava grant agide idu?
grant in the year 1968, 69, my lord.
What grant is this?
Inam grant. And the acquisition was made in the year 62, 63, my lord. That is also forthcoming in page number 22, may be turned, my lord. Serial survey at the first column, second column, row.
Ellide?
Extent of 1 acre, page number 22, top page number in page 3, madam. Running page 22. Survey number 22 of Allur, extent of 1 acre, 3.5 has been acquired under the government notification, so and so, madam. It was acquired, and the notification is also specified. There it is not fully, but in the page number 18 it is clear, madam. The typed portion has missed out the
Yes, sir.
notification dated.
It's kindly
And
happen day after
till-
tomorrow.
Illa, if you have accepted setting off,
No, my lord, sir. Kindly have.
And from-
Ivaga, why the petition is filed now in 2022?
Yes. And 68 till this filing of the petition, there is no claim, there is no representation, there is no agitation, nor anything. Only
Declare the
after
scheme
the
of
lapse
acquisition. 1964 scheme you have challenged now.
Yes, ma'am.
After the lapse of about more than 55 years,
He has come before this honorable court challenging the same. And his grant is in the year 68, 69 itself.
Is senior ಬರ್ಬೇಕಾ?
Senior work. Kindly after, day after tomorrow.
Day after, next Tuesday.
Yes.
ಕಷ್ಟ ಇದೆ. Yes. Next.
For the petitioners, my lords, matter pertains to JP Nagar 9th stage. The objections we have received now by the BDA.
Learned counsel for the petitioner submits that the objections are handed over now, just now, and would seek a week's time
Please, my
to go through the same, make his submissions or file a rejoinder as the case would be.
Please.
Therefore, list the matter on 1st July.
Great.
File it in the registry. Yes. Union of India ಯಾಕೆ?
My lord, in this, my lord, last time this honorable court questioned me that why the notice has, with respect to the unauthorized construction which is made adjacent to the
Highway.
city was not removed. Notice has issued, they have obtained stay, few of them have obtained stay in the.
ಇದು.
Yes,
Ah.
original suit ನಲ್ಲಿ stay ತಗೊಂಡಿದ್ದಾರೆ. But here the subject matter is totally different as such of that, my lord. ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ವಿ, ಅದು ಸ್ಟೇ ತಗೊಂಡಿದ್ದಾರೆ, ಅವ್ರು ಹೊಡಿಯಕ್ ಬಿಡ್ತಾ ಇಲ್ಲ ಅಂತ ಹೇಳಿ, ಅದಕ್ಕೆ ಹೊಸ ನೋಟಿಸ್ ತಗೊಂಡು ಪ್ರೊಸೀಜರ್ ಆಸ್ ಪರ್ ದ ಲಾ ಇಟ್ ವಿಲ್ ಬಿ ರಿಮೂವ್ಡ್. And here they have challenged the notification of a national highway for formation of the separate, means bypass. With respect to that, last occasion I have pointed out page number.
Yes, sir.
119.
ಶಿವಪ್ರಕಾಶ್ ಸರ್.
My lord, but
ಹೇಳಿ.
70.
ಅವ್ರು ಹೇಳ್ಬಿಡ್ತಾಳೆ.
This is a stretch of land between this Talaguppa village panchayat to the Martur. It's about 1.5 to 2 kilometers hardly, not even 2 kilometers. My lord, this road formed in the year 1915 by Dadan Saram Vishweshwara, a straight road. But to facilitate for the Sharavati power station.
Yes.
Afterwards, in the year 1975, it has been upgraded as a state highway. Further, in the year 1995, the road has been upgraded as national highway. Well, at the time of upgrading this straight road for national highway, they have demarcated from the center of road 45 meters. This side and that
75
side.
feet.
75 feet. And they are demarcated and the boundary is also fixed. Now the government hospital, railway station and the government veterinary hospital, library and all government offices are all behind this boundary. For a few photographs also are produced, my lord. Now the issue is they want to form this bypass. Whether this bypass, is it feasible or not, is the thing which even earlier date also this honorable court direct, because these are the fertile and potential lands where they want to form this bypass, whether it is necessary or not. Already one railway bridge is there. Earlier in the year 2022, the proposal was to build this railway under bridge. That's the only one the proposal. Then afterwards, these persons, they have come and now they have come up with this bypass. My lord, the entire photographs, my lord, can also look into it, the way in which these scrap, even on the last date
ಇಲ್ಲಿದೆ
also,
ಕೊಟ್ಟಿದ್ದೀರಾ?
yes, last date also scrap materials and all other small junk sheds are put up. Now, it is the
So
boundary.
instead of that, you want these fertile lands.
It is not.
ಅವ್ರನ್ನ ತಗ್ಸಕ್ ಆಗಲ್ಲ, ಅದಕ್ಕೆ you want these fertile lands to do it.
There are two hurdles, my lord. The map may be looked into, my lord, at page number 25, my lord.
Hurdle number 1.
Yes, ma'am. The hurdle number 1 is it's a curve. And the other one is the water resources is there. And the third one is the speed inside the city.
No, lands belonging to these people are fertile lands on the river bank.
Undoubtedly, it is a fertile land until and this. Only one land, the petitioner's land is only a garden land. The rest of the lands are all converted land is there. The other land are all plain lands which have been for cultivation. Yeah, to crop cultivation it is there. The only petitioner land is only a garden land. And further, my lord.
Why have you not made efforts to get those unauthorized occupants evicted and form the road there?
That is all, if that is also from, my lord, page number 25 may be looked into, my lord.
Of
Of petition itself, as objection. last occasion, they have relied on the petition itself.
Hmm.
It is colored, it seems. There are three options which
Correct.
have been recommended for the feasibility report.
Hmm.
In option number 1 and 3, it is the speed of the vehicle will be 100 kilometers per hour, minimum.
Hmm.
In option number 2.
Option number 1 ಅಲ್ಲಿ ಏನ್ ಹೋಗುತ್ತೆ?
Option number 1, what they have now challenged.
So ಅದು 100 ಕಿಲೋಮೀಟರ್ ಸ್ಪೀಡ್ ಬೇಕು ಅಂದ್ರೆ ಇವ್ರ ಲ್ಯಾಂಡ್ ಹೋಗುತ್ತೆ.
Your land over.
ಆಯ್ತು.
ಎರಡನೇದು, the inside the city, if it is
It's not inside.
Inside the city ಅಲ್ಲಿ ಬಂತು. Unauthorized occupants on the main road, national highway.
Yes, ma'am.
ಅದು inside the city ಆಗಲ್ಲ.
Kind intelligence, it's not city, it's a gram panchayat, it's a gram
The map
panchayat.
may be looked
ಆಮೇಲೆ?
into. The map may be looked into, my lord. It is only 50 kilometer speed if
You want to build road on this land? 100 kilometer speed ಬೇಕು ಅಂತ.
or else if we can't remove.
What can't?
all, the next hurdle is, my lord, I will just
ಇಲ್ಲ
explain.
ರೋಡ್ ಅಲ್ಲಿ ಯಾರೋ ಅನಥರೈಸ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದಾರೆ ಅನ್ಬಿಟ್ಟು ರೈತರ ಜಮೀನ್ ತಗೊಂಡು.
ಇಲ್ಲ, ಇದ್ರಲ್ಲೂ ಸಮೇತನು 3.16 kilometers ನಾವು ರೋಡ್ ಮಾಡಿದ್ರೆ it will be disturbed. The every vehicle which has to be means from this side to that side, they have to cross that national highway itself. There will be no such
ಇದ್ರಲ್ಲೇ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅಂತ ಹೇಳಿದ್ದು ಇದ್ರಲ್ಲೇ.
urgency there, because all the entire road stretch is over only.
ಈಗ ಅದನ್ನ ಯಾವಾಗ ತೆಗೆಸ್ತೀರಾ? ಅನಥರೈಸ್ಡ್ ಆಕ್ಯುಪೇಷನ್.
My lord, the deadline may be fixed of about 3 months because
ಅಲ್ಲ ಅಲ್ಲಿ ಸಿವಿಲ್ ಸೂಟ್ಸ್ ಆರ್ ಪೆಂಡಿಂಗ್. ಐ ಕ್ಯಾನ್ ಯು ಶುಡ್ ಮೇಕ್ ಯುವರ್ ಎಫರ್ಟ್
yes,
ದೇರ್.
efforts are like that. It can be.
You make your efforts there, ಆಮೇಲೆ will permit you to do
My
this.
lord, it's 3.1.
Oh, no.
Or else the second option may be looked into, my lord, or else third option which is not possible at all because.
ಅದು
from
50
that-
ಕಿಲೋಮೀಟರ್ ಸ್ಪೀಡ್ ಆಗುತ್ತೆ.
Huh?
50 ಕಿಲೋಮೀಟರ್
No,
ಸ್ಪೀಡ್
no,
ಆಗುತ್ತೆ.
second option is 50 kilometer speed. Third option is also 100 kilometer speed. There, railway station is there, which is now extended to Honnavara. So that is also not possible. And in the second option, why it is not possible means the railway bridge has to be realigned. It
So
has
we
to be
will
realigned. There
not
also-
direct you to realign railway bridges. But those unauthorized occupants, you take them off, you will get the land.
That
You will get the land that is necessary, which this farmer's land can be saved.
despite that also, despite that also, if unauthorized occupants are also removed, then also we will not be having a speed of about 100 kilometers. We will have the 50 kilometers speed. And the crossing over the vehicles and also persons who will be crossing from that side of the road to this side of the road. Because both the sides there is a.
But the
house.
whole thing is, how can you stop the
Yes.
roads?
My lord, because there is no application of mine, is my humble understanding. Second thing is, now from the center of the road, now 45 meters means almost it is 120 feet. They can have 6 ways there itself, because I have also taken, so he visited the spot and taken consultation of the National Highway senior engineer. Now, the project, what is the cost? Now for removal of these unauthorized persons, it may cost about few lakhs. Now they are coming up with a proposal of 1.5 to 2,000 crores. Nowhere they have disclosed about this budget. Is it not a exchequer and taxpayers' money? They can say, the only thing is mechanical way of bringing these schemes, they are doing it. Let them apply their mind. ಈ ಹೊಲ ಈ ತೋಟಗಳೆಲ್ಲ ನಿತ್ಯ ಹರಿದ್ವರ್ಣ 3 ಕ್ರಾಪ್ ಬರ್ತದೆ. ಇದೆಲ್ಲಾನು ಆವಾಗ ಕಾಗೋಡು ಮೂವ್ಮೆಂಟ್ ಅಲ್ಲಿ ತಗೊಂಡಿರುವಂತ ಟೆನೆನ್ಸಿ ಲ್ಯಾಂಡ್ಸ್ ಮೂರ್ ಕ್ರಾಪ್ ಬರ್ತದೆ ಇಲ್ಲಿ. ಆಮೇಲೆ ಇದು ಎಂತದ್ದು ಅಡಿಕೆ ತೋಟ ಇದೆ, ತೆಂಗಿನ ತೋಟ ಇದೆ. ಇವರು ಇಲ್ಲಿ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಆಫೀಸರ್ ಲಾಸ್ಟ್ ಪೇಜ್ ನ ಮೇಲೆ he has written, I don't know whether he is a literate or illiterate, dry lands ಅಂತ ಬರ್ದಿದ್ದಾರೆ. May I kindly take my lord to the
ಡೆಲಿಬರೇಟ್ಲಿ ಮಾಡೋದು.
My lord, it is not so.
page number 65.
duly
65
ಎರಡು
ನಲ್ಲಿ-
ಕಾರಣ.
I accept that.
ಕಾಂಪನ್ಸೇಷನ್ ಡ್ರೈ ಲ್ಯಾಂಡ್ಸ್ ಕಮ್ಮಿ,
ಇಲ್ಲ, ಇಲ್ಲ.
ಎಕ್ವಿಸಿಷನ್ ಈಸಿ.
ಅಲ್ಲ ಆದ್ರೂನು the policy of the government from the first 5 years plan and Dr. Swaminathan
ಅಯ್ಯೋ
report
ನೀವು
is
ಎಲ್ಲೋ ಅಲ್ಲಿ ಹೋಗ್ಬೇಡಿ, ಇವತ್ತು
ಅಲ್ಲ,
ನ್ಯಾಷನಲ್ ಹೈವೇ ಹೇಳಿ ಸರ್.
not to acquire these fertile
ಆ ಕಾಲ
potential
ಹೋಯ್ತು.
ಇದೆ, ಆದ್ರೆ ನೆಸೆಸಿಟಿ ಇದ್ರೆ ಮಾಡ್ಕೊಳ್ಳಿ, ಇಲ್ಲಿ ನೆಸೆಸಿಟಿ ಇಲ್ಲ.
My lord, all these lands are belonging to the family from 64 and 68 unauthorized occupants, all they have been received the compensation, grants, and they are in the occupation, they are the owners. All these lands are bifurcated, they are split into 2, and all these lands are been khatedari. But here also all the lands which have been on their strength, one road is found, either side there is a road. In page number 82 of my objection may be looked into, my lord.
Let's see.
There I have,
We'll go through it and pass some more.
and
Let the
ಕೊಡಿ.
deputy commissioner and tahsildar, it's a village panchayat, let them take action or let them initiate proceedings so as to remove them.
But stopping of roads
Well, I am not for
difficult.
stopping, but the way in which it is hard burning, because though they have that land reserved and it is during the period of 1915, the road is a straight road planned by Sir Vishwesvaraya. Now they can, no, these are things we have to give sanctity, my lord.
All
I have 2 points.
I can
One is-
understand if it is a curve road.
highways of this nature were never envisaged earlier.
My lord, I have 2
We'll
points.
see.
One is
It forethought and vision, Sir Vishwesvaraya planned it for Sharavati power plant.
Correct, sir. We'll see, yes.
Please, my lord, please, my lord.
My lord, I have around 2 points. One is railway bridge which has to be realigned.
We'll see, yes.
Realignment, we have to demolish lot of houses.
Wait.
That
we'll see.
compensation itself will exceed this. And further, my lord,
Yeah,
we
no.
have also given, they exceed the compensation.
Railway
what we
bridge,
are paid.
let's, yes.
And further, we have also paid compensation for the sites which have been found in this survey number, what they are agitating with the
Next.
option number 1.
Next Thursday act will dictate.
Please, my lord, please, my lord. Interim order is to continue.
Intermodal continues.
Oblige, my lord.
And
Dictating and
further,
Thursday. Next Thursday.
nullified is also not put forward.
Next Thursday, 4:30 PM ಅಂತ ಹಾಕಿ. Yes. Yes, sir.
This case, I pay for petitioners, my lord. But the petitioner herein is seeking for the reference.
Reference.
Reference by the deputy commissioner to the civil court.
My lord, state government has to.
Yes, sir. When do you do it?
Lord, I'll have to take instructions.
Eh?
Literally, last hearing date, this court told R2 to file statement of objection. So subsequently, I have also.
Reference under 28 to ನೀವು ಮಾಡಬೇಕಾಗಿರೋದು.
I have already sent them, Lord,
18
next Tuesday, I'll.
List the matter on Tuesday at the request of the learned AGA as a last chance. We'll dispose it on that.
Date,
Tuesday,
please.
ಬೇಡವಾ?
Wait.
Next Tuesday, date not 17th. Oh, sorry, 24th.
24.
Yes.
Lord, I appear for the petitioner, please.
Kindly grants 2 weeks time.
For what?
Some inconvenience.
Enter ಮಾಡಿದ್ಯಾ?
No, there is no interim order, please.
ಏನಿದ್ matter?
Lord, this is a matter wherein the land which is in the occupation of the petitioners has been denotified by virtue of annexure A in the year 93. And we were in possession right up to, my lords, 21/1/2025.
ಈಗ ಮತ್ತೆ notification ಮಾಡಿದಾರ?
No, they have come and occupied they are trying to occupy the land on the basis of
Trying
a
to occupy.
notification.
But it is not denotified. His great grandfather challenged acquisition proceedings. His grandfather challenged acquisition proceedings. Recently, their father also challenged the acquisition proceedings.
Lords.
All those things are recorded. Kindly grants.
No, I will make a submission with respect to that.
Information under the right information. Act.
Learned council, ನೀವು ಬಿಡಿಯಾಗ?
No,
ಅಲ್ಲ,
the government acquired on behalf of the private society, government house building.
Private society.
House building.
When was, what, date of acquisition?
Dated of acquisition in the year 1986, man. 86.
87 preliminary
Who
notification.
challenged it?
1993, my lord, their grandfather challenged the writ petition.
Ah.
That 2000.
Same acquisition.
Please, my lord.
Same.
Then this was came to be dismissed. Again, 2003, again their grandfather challenge, it is dismissed. Recently in 2016, 17, this father challenge, and after filing this writ
16,
petition.
17 also dismissed?
Please, my lord. They
No, it is
only
withdrawn.
withdrawn. After
Withdrawn.
filing the writ petition.
My lords,
they-
may appreciate, my lords.
After
My
filing
lords,
that, my lord.
the
I will
government
place-
takes, my lords, it is alleged that the government
Where
takes
is the order
possession.
withdrawal?
Annexure A, please, my lords.
Withdrawal on what ground? Why did you withdraw?
Denotification, please. my lords.
Why did you withdraw, sir?
No, it was a different petition by a different council, please, my lords. They
Council
have withdrawn
bidi,
it.
petitioner same.
My lords, petitioners are not the same. The
Father.
my lords, some of them had died. They had not replaced them also. They had not brought the LRs on record. And my lords, then they withdrew the writ petition. And the ground of challenge was that there was no notification or there was no consent accorded under section 5 of the Land Acquisition Act when it was given to the society. This was, my lords, the contention there. And
93 ಅಲ್ಲೇ ಆ contention ಹೋಗಿರುತ್ತೆ.
my lords, may appreciate this. 93 nalli, what they do is, firstly, they file a writ petition. Respondent number 3
Produce
files a writ
ಮಾಡಿದ್ದೀರಾ?
petition.
All those orders you produced 93.
They have produced it, my lords.
They have not-
All I say is
even
this
not
much.
Why have you
disclosed
not
also.
produced everything?
My lords, we were not party to it. We did not know it at all.
Your grandfather ಮಾಡಿದ್ ಗೊತ್ತಿರ್ಲಿಲ್ವಾ?
Did not know it. For the reason, I will say this, my lords. 93 nalli ಏನಾಗುತ್ತೆ, they file a writ petition saying that the government has taken possession of the land. They have not handed it over to the society. On that basis, they keep on contending whenever a writ petition is filed. And those writ petitions are not filed by me. My lords, may kindly see this. The award is of the year 19.
Let him file whatever he wants.
Already placed all the records before the court.
Place.
Kindly have it on first.
List the matter on 1st July at the request of the counsel appearing for the third respondent, yes.
In the preliminary hearing, please.
Preliminary hearing.
Readings are completed, may become.
B group, yes.
B group.
Alla,
Readings complete agide.
alla.
File the
My lords, I
detailed
will not
objection.
have an
I
interim
served
order
that.
also, my lords. This is-
Interim order idralli ಏನು ಬಂತು sir?
My lords, on 21, when they come and take possession of the land, my lords, it is date.
2021.
2025, 21/1/2025.
All right.
My lords, there are photographs prior to that. I'm being in possession. There is an endorsement to that effect.
Civil
Those
suit
such
also
being,
filed.
my lords,
Civil suit
if I may,
also filed.
if I may
Civil
permitted to
suit
say
also,
this.
my lord, they
On
did
21, when I go before the respondent police, my lords, they tell me that it cannot be done anything. That's why I have made them also a party.
1st July, yes.
My lords, the present counsel petitioner has been given Wakala NOC, my lords. Tentative to file the NOC Wakalat, my lords. And there is similar matter in the writ petition number 1110/425, my lords. Can it be tagged along with this?
Same ಈಗ objection ಹಾಕಿದ್ರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, I seek an indulgence of the court for that.
Learned counsel for the respondent seeks 2 more weeks time to file statement of objections. List the matter on 8th July. Objections if any by then.
My lords, a similar matter in writ petition number
ನೀವು
1110.
ಅನ್ನೋಸಿ ವಕಾಲತ್ ಕೊಟ್ಟ ಮೇಲೆ similar matter ಹಾಕ್ಬೇಕು ನಿಮ್ಗೆ.
1110?
Yes.
1110/425.
Next.
Oblatements.
Petitioner, my lord. It's a land which has not been acquired, yet they have approved the layout plan, my lord.
Ajay Kumar. Ajay Kumar is here. Learned counsel Ajay Kumar is directed to accept notice for the respondent BDA. Aircraft employees.
Oh,
Emergent notice to respondents 3 and 4, yes.
interim order of this.
No, sir, yes. Next.
For the petitioner's counsel, that's this layout, my lord's acquisition was for a layout.
Bangalore Soft Drinks Private Limited.
This is where the Torino factory was in place. My lord. Of course, at annexure E, my lords, your lordships would get at page 49. My lords, this honorable court has already held that the acquisition so far as Venkateshwara layout, the scheme itself has lapsed. Now, my lords, the records are in our name, conversion is in our name, RTC also is in 49.
What has happened now?
Now, my lords, when I apply for when I want to sell the land, I apply for EC and other things. Now I come to know from BDA that land had been acquired for Venkateshwara. Though no doubt that point of time I had challenged it, but the scheme itself is lapsed. That's the declaration of this court. In fact, this honorable court, while issuing notice on 9/4, has recorded that statement.
B.S. Sachin is directed to accept notice for.
Vachan anta bandide ada.
Vachan
Actually,
idea.
lords, it had come
Vachan,
up.
where is Vachan?
It was on 9/4/25, the notice was.
You're appearing for Vachan?
I beg your pardon, my lord, I was not aware that the notice was not.
This is still number 12. You don't have the list?
12, my lords, 12, please.
Ah.
Sorry, my lords, I was held up to another
Ah.
court. Lord, this matter, my lords, I'll file my objections, my lords. So kindly grant me a week's time.
Learned heard the learned senior counsel, K. N. Panindra appearing for the petitioner. The learned senior counsel submits that the factum of the property belonging to the petitioner being the subject matter of acquisition comes to light only now when he had applied for grant.
Lords, acquisition, I knew I had challenged it.
Then
Thereafter, my lords, in separate proceedings, there are 3 pieces of land of mine. 2 pieces they did not acquire, though it was
I'll
notified.
let him file his objections.
Lords, it's
Interim order
covered.
in Bandel.
Next week, your lordship, I have 49. This court has said that the scheme itself has lapsed in
This
so far as this
the learned counsel B. Vachan seeks 10 days time to file statement of objections. Objections, if any, by the 1st of July. List the matter on 1st of July in preliminary hearing. Previous matter, preliminary hearing.
preliminary hearing.
Previous matter, no then.
13.
Lords, when my land was acquired, my lords, a higher extent of land was shown as Kharab. Thereafter, my lords, I've got a survey done by the ADLR. That survey, my lords, will see at page 68. This has even been communicated to BMR's.
Notice ಆಗ್ಬೇಕು.
Not how some. My lords, I had one suggestion subject. I checked on this. My lords, ADLR has conducted a survey. The KIDB's objection only would be that KIDB is not party to the survey.
ಇನ್ನೊಂದು ಸರ್ವೆ ಮಾಡಿಸ್ಬೇಕು ಅಂತ.
KIDB ನ ಪಾರ್ಟಿ ಮಾಡಿಸಿ ಇನ್ನೊಂದು ಸರ್ವೆ ಮಾಡಿಸ್ಬಿಟ್ರೆ ಡಿಸ್ಪೋಸ್ ಆಗ್ಬಿಡುತ್ತೆ ಅಷ್ಟೇ.
ಮೆಟ್ರೋ ಅವರು ಇದ್ದಾರೆ.
ಮೆಟ್ರೋ ಸೇರಿಸಿ.
Metro may be notified. Notice will be issued.
All the stakeholders to this we will direct joint survey.
ಅಷ್ಟೇ ಸ್ವಾಮಿ.
ಅದಕ್ಕೆ ಈಗ ಮಿಲಾರ್ಡ್ now as of now ಮಿಲಾರ್ಡ್ there is one survey whether my lord, the SLO, my lord, accept my lord, the survey, my lord will. No, no, nothing.
ಅಲ್ಲ ಎಲ್ಲರೂ ಸರ್ವೆ ಮಾಡಿ will close the petition itself.
ಹೌದು ಅಷ್ಟೇ. Next week
The-
ಹಾಕೊಂಡ್ರೆ meanwhile we'll get
The
it.
petition, the issue in the list is with regard to compensation to be paid by the KIDB for the remaining portion of the property measuring 103.6 square meters. The learned counsel for the petitioner submits, Ajay Nandalike submits that the SLAO has conducted a survey which,
ADLR has
or the ADLR has conducted a survey which the KIDB may not agree, as they were not a party to the said survey. Therefore, in the circumstance, I deem it appropriate to direct the state, the KIDB and the metro, for which purpose the acquisition is made, to jointly conduct a survey.
So the survey has to be conducted only by ADLR. They
The
cannot
present
participate.
joint survey, correct, adane ಹೇಳಿ.
Lord,
A joint
direction, my
survey,
lord, is to be
in a
ADLR.
joint survey in the presence of the officers of the aforesaid Bangalore Metro, the KIDB and the ಎರಡೇ ಅಲ್ವಾ?
Our
KIDB and the petitioner. And the petitioner, the said report of the said survey be placed before the court on the next date. The survey, the aforesaid joint survey be conducted on 26th at 11 AM. No separate notice need be issued to the petitioner. The report of such survey be placed before this court on 3rd July.
So, Swami, sorry, one ನಿಮಿಷ. ತಾವು BMRCL notice accept ಮಾಡ್ಕೊಂತಾರೆ.
BMRCL ಯಾರು? ನೀವೇ ತಗೊಂತೀರಾ?
ಹರೀಶ್ sir.
ಅಲ್ಲ ಅವರೇ ತಗೊಂತಾರೆ ಅಂದ್ಮೇಲೆ. Pradeep Kumar accepts notice for 1, 2, 3, 1 AGA, 2, 3, 4, all Pradeep Kumar.
Harish, my lord, is online. I don't know whether he's waiting for BMRCL.
I will take accept notice on behalf of BMRCL.
ಆಯ್ತು, BMRCL. You heard the order?
Yes.
Yes. ಅದಕ್ಕೆ NN Harish ಅಂತ ಹಾಕ್ಬಿಡಿ 4ಗೆ. 4 NN Harish, 2 and 3 Pradeep Kumar, 1 AGA. Yes. List on 3rd July. Next.
14, compensation amount they have already deposited in the bank, but my representations are pending since for 2 years now.
Who has to consider it?
Housing board.
Housing board. Next week.
ಯಾಕೆ ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇರೋದಾ?
ಹೌದು.
Learned counsel Pradeep Kumar is directed to accept notice for the respondent. Petition, copy ಇದೆಯಾ?
Copy.
Petitioner to serve set of papers upon
Separate.
the said counsel. The issue is only with regard to consideration of the representation submitted by the petitioner 2 years ago. Therefore, the learned counsel shall place on record as to what has become of the representation on the next date. List on 1st July.
Respondent 1. Respondent 1 for state.
AGA
Housing.
1, Madam AGA 1. Next.
15.
Lord, I appear for the respondent. I have not filed a statement. I seek some time to file a statement.
Lord, it is a writ for certiorari to set aside the order dated 24/1 and 2024. Passed by the third respondent, my lord.
Let him file his objections. The learned counsel MV Kini representing 1 and 2 seeks 10 days time to file statement of objections. 3rd July, objections if any by then. Next.
Obliged.
Next.
This is a matter, my lord. Lords had passed an order on 2nd May. On 2nd May, my lord had passed an order taking note that all the petitioners, my lord, are blind. They are 100% blind.
Correct.
And they were thrown out of their houses, my lord, where the collusion of the police has been alleged, my lord. My lord had directed that they may place on record instructions, my lord. They may secure instructions as to when they're going to put the petitioners back in their homes.
My lord, in this matter, there is a civil suit which is pending, my lord.
Against whom, sir?
Against brother and sisters.
Which brother and sister? These blind people were the occupants in which property?
My lord, this property is Jayanagar, my lord.
Alla,
There is
yeah.
1748.
civil suit is pending. There's no doubt, my lord. We have an ex parte injunction. Despite that, the police has colluded with them and thrown us out. And this, my lord, is
When
an
will you put them back?
extraordinary situation.
Direction, my lord, 2 days.
The petitioner, how many of you are here?
3 petitioners, my lord. All 3 are blind.
The petitioners, 100%.
All 100%.
The
Annexure A may be seen, please.
petitioners before the court are 100% blind. They are at the doors of the court seeking restoration of their possession, which the police have allegedly in collusion with other parties evicted these people. The petitioners have filed a civil suit seeking injunction against, who are these?
All family members, my lord.
Injunction against several persons. And the allegation is, notwithstanding the injunction being granted in favor of the petitioners, the police in collusion with the defendants in the suit have evicted these petitioners. Therefore, the present petition is preferred. The learned AGA to secure instructions as to when the petitioners would be put back in their possession in the teeth of the injunction that is operating in their favor. If the police would again display collusion, alleged collusion with the defendants in the suit and not put these petitioners back, the matter would be viewed seriously. List the matter on next Tuesday.
Executable, maybe put into within 2 days.
ಆಯ್ತು ಸರಿ ಅಲ್ಲ ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ.
Grateful.
17.
Matter, my lords, I've sought for instructions, my lord. Lordship may kindly grant me a week's time to complete my instruction.
ಏನ್ ಮ್ಯಾಂಡಮಸ್
Mandamus.
ಶಿವರಾಮ್ ಕಾರಂತ್ ಇದ್ದಂಗಿದೆ.
Please, my lord.
ಶಿವರಾಮ್ ಕಾರಂತ್ ಲೇಔಟ್ದ
ಅದ್ರಲ್ಲಿ ಕಾಂಪನ್ಸೇಷನ್
ಕಾಂಪನ್ಸೇಷನ್ ಇಲ್ಲೇ ಬರೋದು ಬಿಡಿ. Learned counsel B. Vachan seeks 10 days time to secure instructions and make his submissions. 1st July and preliminary hearing. Yes.
This matter, my lord. I believe that notice has not been issued. It was advance notice was served. But my lord, the petition copy is not, that copy served is not complete. So impugned order is not.
Impugned order is not there.
No. And
That's
there is
it.
an objection also with regard to annexure A, my lord.
Complete copy ಒಂದು ಕೊಟ್ಬಿಡಿ. Yes. ನಿಮಗಿದೆಯಾ? ಕೊಟ್ಟಿದ್ದಾರ? Learned counsel for the petitioner to serve complete set of papers upon Srimati Shilpa Shah, the representing the National Highway Authority of India. 1st July. Yeah, Shobhit Shetty ಅಲ್ಲ? Oh, sorry. Our respond number 3, print his name. Yes, list on 1st. First Saka?
No, one more week maybe.
8th, yes.
Okay.
19. I appear for
Dispose the application.
Please, your lordship. Annexure E is the application filed before the first respondent, which is pending from past 3 years, my lord.
Deputy Commissioner. ಒಂದು ಅಪ್ಲಿಕೇಶನ್ 3 ವರ್ಷ ಪೆಂಡಿಂಗ್ ಇಟ್ಕೊಂಡಿದ್ದೀರಲ್ಲ. The petitioner is before this court seeking the following prayer. The land of the petitioner became subject matter of acquisition by, in terms of a final notification dated 23/9/2016. Identical order ಮಾಡಿದ್ನಲ್ಲ ನಿಮ್ದು?
Yes, your lordship.
Which is that?
My
ಎಲ್ಲಾದ್ರಲ್ಲೂ ಹಿಂಗೆ ಬಿಟ್ಟಿದ್ದೀರಾ? Deputy Commissioner kept it for 3 years. An award was passed on 1/2/2017 and the petitioner being dissatisfied with the compensation awarded has filed an application under section 3G5 of the National Highways Act seeking enhancement of compensation. The said application is preferred on 23/6/2021 and we are in 2025. For the last 4 years, the Deputy Commissioner has kept the application pending of this land loser who is seeking enhancement of compensation. The act of the Deputy Commissioner is rather appalling as to how how the application is kept pending for 4 years. Therefore, the deputy commissioner shall now pass necessary orders on the application within 2 weeks from the date of receipt of the copy of the order, if not already passed.
Your lordship, may I make one
WP
submission?
number 14849 of 2025, disposed on 10 June.
Dispose ಆಗಿದೆಯಂತಲ್ಲ.
ಅದು previous application.
ಇದಾಗಿಲ್ವಾ?
ಇದಾಗಿಲ್ಲ.
If not already disposed.
Your lordship, can there be?
4 ವರ್ಷ.
Can there be an addition in the direction, my lord? Because in a hurry, they'll pass an order, my lord. There are instances,
ಅಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ. The order shall be passed after hearing the petitioner.
not hearing, my lord, considering the materials on record, because already heard and the order is, they had to pass an order.
We do it like this, madam. It is needless to observe that the deputy commissioner shall pass necessary orders in accordance with law after considering all the material that is placed by the applicant before him.
Very well. I'm great.
Next.
20. I'm appearing on behalf of the petitioners, my lord. At the outset, the respondents, the landowners, have impleaded themselves and they have served copy upon us this morning. There is no objection to the impleading application. However, I would like to file my objections regarding the application.
If you have no objection, why do you want to file?
Impleading the parties, I don't have any objection, my lord.
Yes.
However, just the application, I want to file my objections.
Compensation may be sent, if both the parties are agreeing, compensation may be sent to under section 30 itself for civil court, my lord.
What do
No, I
you
will
want?
file my detailed objection in this matter, my lord, because there are 4 writ petitions and there are orders to relieve the compensation in my favor. That is the reason why I am before this honorable court.
I will take it on first.
He is not a
You
party.
see what is to be done.
Please.
Yes, my lord.
We'll send it
Interim order to be extended.
and
my
that will be extended. Yes.
Next week, my lord.
That is first, sorry, next week, that is first allala?
But next week first.
24th, matter of compensation. Yes.
I'll let them survey copy to me, my lord. I will file as detailed.
Tell your
objection.
senior on 24th. Yes. List on 24th, interim order subsisting will continue to the next date of hearing.
Grateful, my lord.
Yes, Ketan.
Petitioner, my lord. Petitioner's land in survey numbers 128.
NHA ಎಲ್ಲ
Kindly see annexure J, my lord. They
Yes.
themselves admitted.
ಶೋಭಿತ್ ಶೆಟ್ಟಿಯ ಸರ್ವ್ ಮಾಡಿ.
I may put to serve.
Learned counsel Shobhit Shetty is directed to accept. NHAI, Shobhit Shetty is directed to accept notice for the respondent's petitioner to serve set of papers upon the aforesaid counsel. Look into it next week.
Yes. Date may be fixed, my lord. Same state,
List.
my lord.
ಎಲ್ಲರೂ ಹಂಗೆ ಕೇಳಿದ್ರೆ ಏನ್ ಮಾಡ್ಲಿ? List on 3rd July, sorry, 1st July.
Preliminary stage itself, my lord.
Don't worry, yes, next.
22.
Betterment tax,
Betterment charges, interest on the betterment charge.
BDA.
Challenging only interest.
Ajay Kumar is here. Counsel Ajay Kumar is directed to accept notice for the respondent. Petitioner to serve set of papers upon the aforesaid counsel. ಏನ್ ಇಂಟರ್ ಮಾಡಕ್ ಹೇಳಿದ್ರೆ
ಹೌದು ಡಿಮಾಂಡ್ ಇದೆ, therefore annexure K.
The respondents are restrained from precipitating the demand till the next date of hearing. List on 3rd July.
23.
The respondent BDA, my lord.
Not to allot.
Not to allot.
Yeah, not to allot.
My lord, there is pendency of suit, my lord, and also earlier, my lord, writ petition is filed, my lord, seeking the continuity of
That
land.
order
Annexure
will
V.
not grant. Yes.
My lord, kindly see Annexure V, my lord.
BDA ಯಾರಿದ್ದಾರೆ? ಯಾರು? Nobody list ಕೊಟ್ರಲ್ಲ. B. Vachan is directed to accept notice for the respondent. Emergent notice to the second respondent returnable by the 8th of July. List on 8th of July.
I'll let them not allot, my lord, because my lord, the suit is pending, my lord.
The allotment,
Kindly
if any, to the second respondent will remain subject to the result of the
see-
petition.
Kindly see Annexure V, my lord. My lord,
Yes.
earlier, my lord, writ petition is
ಆ
dismissed,
ತರ
my lord.
mandamus you can't seek not to allot to second petition
My lord, I
respondent.
sought, my lord, till the disposal of the OS, my lord.
No problem.
It is here before the civil suit, my lord.
No, sir.
Kindly see Annexure V, my lord.
I have seen, ಅದಕ್ಕೆ. It will be subject to the result, yes.
24.
That the petitioners.
Reference.
Covered.
ಕೊಡಿ.
Actually, Annexure
page number
D,
15.
Annexure D.
Annexure D, same order.
I will take instruction, my lord.
Pass award ಅಷ್ಟೇ.
I'll take instruction, my lord.
approached this honorable
What
court.
is
It's been
this?
already acquired, my lord. It is
Award
already.
pass ಮಾಡಕ್ ಒಂದು mandamus ಆ?
Hello. My lord, I will take instruction.
Yes,
my lord.
learned AGA is directed to accept notice for the respondents. List the matter on 1st July. Sorry, 24th.
My lord, not it first, my lord.
No, 24th, yes.
Lord, first, my lord, because.
No, sir.
School ಕಟ್ಟಿದ್ದಾರೆ ಅದಕ್ಕೆ.
24th, yes. General award covered, ah? ಕೊಡಿ. Same order, ತೊಗೊಳ್ಳಿ. Both councils, yes.
The conditions are incomplete.
Same order, same order, same conditions. ಅವ್ರು ಏನಾದ್ರು ಹೇಳಿದ್ರೆ ಚಂದ್ರಚೂಡ ಅವ್ರು ಬಿಡೋದೇ ಇಲ್ಲ. Will grant stay for now.
That's identical.
Correct.
Dharwad bench also has
ಹೌದು,
given.
ಕೊಡಿ. We can't draw that here, but same order will pass. ಅದ್ ನಾನೇ ಮಾಡಿದ್ದಲ್ವಾ ಅಲ್ಲಿ?
ಇಲ್ಲ, this is.
ಆಮೇಲೆ, yes, yes. The
That
heard
was
the
another
learned
issue.
counsel Nitin Ramesh appearing for the petitioner. The learned counsel submits that in identical cases, the bench at Dharwad. ನಾನು ಒಂದು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದೆ ನಿಮ್ಮ.
That was a comprehensive disposal, Bilal.
Or
But
disposal.
here the facts are slightly different. Though it's the license issue, here it's on a different footing.
The coordinate bench has held as follows.
Not in this.
Earlier ಯಾವ್ದೋ ಒಂದು ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತಾರೆ, ಯಾವ್ದದು?
ಹೌದು, that is in a, my lord,
That is
that's the same-
disposal.
ಇಲ್ಲ, ಇದು ಇನ್ನು ಪೆಂಡಿಂಗ್ ಇದೆ. Both in Kalburgi bench as well as Dharwad bench. Totally, they conducted inspection in 3 different places at the same time, the same team, around the same time. And the illegalities that were committed are identical in all these 3 matters by the team, because the persons who constituted the team are not competent to conduct the search itself. Number 1. Number 2, my lords, they issue a show cause notice. We give a tender reply to that. After that, behind the back, they get one more inspection conducted, of which the report is not given to us, making that the basis of the final impugned order, they cancel the license. So that is the natural justice.
Will pass an independent order. ಇದು ಬೇಡ. This was following another order.
ಇಲ್ಲ, this was following the same thing. ಅದರಲ್ಲೂ ಇದೇ ಆಗಿದೆ.
Heard the learned counsel Nitin Ramesh appearing for the petitioner. The petitioner is before the court calling in question cancellation of the license in terms of an order dated 9/5/2025. The issue, the learned counsel would project that the basis of the cancellation is the inspection conducted by the respondents.
Joint director.
The inspection conducted is contrary to section 28C, is the submission of the learned counsel. 28C of what is that?
Fertilizer control.
Fertilizer control order. 28C of the fertilizer control order. The learned counsel would further submit, the learned counsel would submit that the team which conducted an inspection was incompetent to do so, as it was not in consonance with section 28C. The learned counsel would next submit that the show cause notice was issued on
7/3/2025.
On 7/3/2025.
To which reply was given on
The
11th.
petitioner replies to the said notice. After the said notice, it transpires that another inspection is conducted, which the inspection is conducted and a report is drawn. The show cause notice is based upon a report, capital A report, and the impugned order is based upon B report, which the petitioner is not even made aware of. In that light, there shall be an interim order of stay as prayed for till the next date of hearing.
One indulgence, which I got in both the honorable benches. Specifically, if your lordship had to come to my interim order, which is also reflected in the.
ಕೇಳಿಲ್ವಾ? ಏನ್ ಕೇಳಿದಿರಾ ಅದು?
ಅದರಲ್ಲಿ ಹೌದು, ಅದೊಂದು ಮೆನ್ಷನ್ ಮಾಡ್ಬಿಟ್ಟೆ ಸ್ವಾಮಿ, because in practical terms.
Interim order as prayed for, it is made clear the business operations of the petitioner shall continue unhindered till the next day.
In that portal, my lord, a subsidy is being granted.
Through the use of IFMS portal.
My lord,
Through the
portal
use
there-
of,
IFMS, that is the
through the use of
fertilizer
integrated
management.
fertilizer management system
Yes,
portal.
If,
Yes, that is the very order I got in both the courts. Nothing different.
my lord, they will get the subsidy with that also.
Yes. The allegation is not
ಯಾರು
that
ನಿಮಗ್ ಮಾಡಕ್ ಕೇಳ್ದವ್ರು ಹಿಂಗೆಲ್ಲ? Why do you commit harakiri in every case?
There is a, means,
ಏನು?
the qual-
ಅದಕ್ಕೆ ಹೇಳಿದ್ದು.
quantity itself is a very.
Show cause notice is issued on A report. You pass the impugned order on a B report, which is not even made
My
known.
lord, Let them do their business, my lord, but not in that portal,
We
because
cannot
they will
do a
get that.
business.
They
We have to
they will
do
get
it through
that
license.
subsidy, and we, the government has to give us a subsidy
ಕೊಡ್-
of that.
ಈ ತರ
Subject to this.
ಒಂದ್ ನಿಮಿಷ ಸರ್, ಈ ತರ ಕೆಲಸ ಮಾಡಿದ್ರೆ ಸಬ್ಸಿಡಿ ಕೊಡ್ಲೇಬೇಕು.
My lord,
And it
subject
is
to
not your
result
ballot.
of
May
this
make only
subsidy.
one submission, just
Subsidy
to be fair,
shall
to
be
be fair to my
subject to
learned.
result of this,
The-
result of the petition.
Nothing, yes. Nothing. Why are you giving concession? Wait. Nothing doing. This is the order. List the matter on 4th July. Objections idre haki, we'll close it on that day.
Great.
It's plain and simple. ಅದಕ್ಕೆ entry ಮಾಡ್ರಿ. ಇದೆ final order. Yes.
28.
Alternate site.
Yes, Lord. Mandamus.
ಅದು ನೋಟಿಸ್ ಆರು ಕೊಡ್ಬೇಕಲ್ಲ. ಮ್ಯಾಂಡಮಸ್ ಅಂದ್ರೆ ಕೊಡದೆ ಬಿಡ. ಬಿ ವಚನ್ ನೀವು ಬಿಡಿ. Learned counsel so and so undertakes to enter a is directed to accept notice. Petitioner to serve set of papers upon the council list on 1st July. We'll close it. Mandamus sir.
Much.
29.
General award.
General award.
Same. Covered.
Covered.
ಈಗ ಒಂದು ಕೊಟ್ನಲ್ಲ ಮೇಡಮ್. ಚಂದ್ರಚೂಡ್ ಅವರ
Even
ಪೇರ
29 also.
26 ಏನ್ ಆರ್ಡರ್ ಮಾಡಿದೀರಾ ಅದೇನೆ 29 ಜನರಲ್ ಅವಾರ್ಡ್.
Copy.
ಕೊಡಿ ಕಾಪಿ ಕೊಡಿ. ಸೇಮ್ ಹೆಸರೆಲ್ಲ ತೋರಿಸ್ಬಿಡಿ.
Notice.
Learned counsel Pradeep Kumar is directed to accept notice for the KIDB. Learned AGA for the state. ಅದು ಹಾಕ್ಬಿಟ್ಟು ಆಮೇಲೆ ಸಪರೇಟ್ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಇದು ಮಾಡಿ. Heard sounds. Next.
Grateful.
30.
I will take notice for respond number 1.
30 and 32 same.
Issue.
2006 preliminary notification.
Yes, but they have to be, Muda has to be served, my lord, or else name of.
TP Vivekanand is, Learned AGA is directed to accept notice for the first respondent. Learned counsel TP Vivekanand is directed to accept notice for respondents 2 and 3.
Annexure D, my lord.
Petitioner to serve set of papers upon the aforesaid counsel. I think this requires an interim order.
Annexure D, my lord.
Annexure D, ಅದೇ ತಾನೇ ಕೇಳಿರೋದು.
Same annexure D, is it covered matter?
ಅಲ್ಲ ಬರಲಿ.
Barli.
ವಿವೇಕಾನಂದ್ ಬರಲಿ.
Yes.
31.
Annexure D ಅಲ್ಲಿದೆ. ಸೇಮ್ ಮಾಡಿ. ಇದು ನಾಡಿದ್ದು ಹಾಕಿ ಮಾಡಿ. ಇವತ್ತೇ ಕಾಪೀಸ್ ಯಾರು ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ. 1st Julyಗೆ ಹಾಕಿ.
31.
For the
Allotment,
petitioner.
representation.
The petitioner is seeking for a reallotment.
Yes,
or
madam. Learned AG ಅಲ್ಲ.
HCGP.
Learned HCGP 1, 2 and 3. So and so accepts notice petitioner to serve set of papers upon the aforesaid counsel.
My lord,
Next.
interim order may be granted till the next hearing date.
Interim order ಬೇಕಾ? Why madam? ಇದರಲ್ಲಿ ಏನು ಪ್ರಾಬ್ಲಮ್ ಇದೆ?
Prayed for an interim order.
Status quo where the property be maintained till the next date of hearing. Yes.
Grateful.
Copy ಇವತ್ತೇ ಕೊಡಿ ಅವ್ರಿಗೆ. 32 same as 30.
Oh, TP Vivekananda.
Tip same as 30. 30 ಏನ್ ಮಾಡಿದೆ ಅದೇ.
33.
33, I will take notice
Learned
for
AGA.
R134, my lord. 2,
Learned AGA is directed to accept notice for
R134, my lord, and 2, 3 and 2, AV Gangadharappa, my lord.
Urban Development Authority. Shivamogga Bhadravati.
Yes.
Learned counsel AV Gangadharappa is directed to accept notice
Annexure F.
for the respondent.
Annexure F.
covered ಇದನ್ನು.
Page number 52.
I have sought for interim order.
Yeah, that I'll grant. The learned counsel for the petitioner submits that the issue in the list stands answered by the coordinate judgment of the coordinate bench annexure FL ಇದೆ madam. In that light, till the next date of hearing, there shall be an interim order as prayed for. List the matter on 3rd July. We'll close it on that.
Yes.
Copy serve ಮಾಡ್ಬಿಡಿ ಇವತ್ತು.
Yes.
Yes. Next.
34.
My lord, in this petition, I have questioned the legality of the endorsement.
Which order of the High Court? You said some order of the High
Yes,
Court.
my lord. It
Where
is
is
annexure
that?
C, my lord. Annexure C at page number 31.
My order.
Yes, ma'am.
Oh, that is in crime is stayed.
Yeah, this is a petition filed by my vendor questioning the legality of the proceedings before the magistrate. And this honorable court has granted interim order of stay.
All right.
So I have purchased this property from my vendor through the registered sale deed. Prior to my
Criminal case
purchase-
ಗೂ ಇದಕ್ಕೂ ಏನ್ ಸಂಬಂಧ?
ಅದಕ್ಕೆ ಏನು ಸಂಬಂಧ ಇಲ್ಲ.
ಮತ್ತೆ?
But the respondent number 2 has issued the endorsement stating that because of the pendency of the petition before the honorable court, they cannot change the kata.
We'll see. Ajay Kumar is directed to accept notice for the respondents petitioner to serve set of papers upon the aforesaid counsel forthwith. List on 3rd July. Interim order ಖಾತಾ ಕೊಡಕ್ಕಾಗಲ್ಲ. Yes, ಬರ್ಲಿ ಅವ್ರು.
55.
Next. What happened yesterday?
Yes, bro, we have given a copy to my friend, my learned friend representing the first defendant.
ಯಾರದು? Yes. You confirm?
Mr. Dhruv Patwari appears for the original first defendant.
Correct. You confirm
Friend
the email.
appears not for Union Bank.
You confirm the communication. That's all I want. Amele, tomorrow he should not say I was not
Please,
heard in the matter.
I bought.
ನೆನ್ನೆ ಡಿಕ್ಟೇಷನ್ ಕೊಟ್ಟಿದ್ದೆ. ಯಾರು ಕೊಟ್ಟೆ? ನೆನ್ನೆ ಶುರು ಮಾಡಿದೆ ಕೊಡೋದು. ಯಾರಿಗೆ ಕೊಟ್ಟೆ? MV ನಾ? MV. Yes, madam, ಅದೇನ್ ಟೈಪ್ ಮಾಡಿದರೆ ಅದು ಕೊಡಕ್ಕೆ ಹೇಳಿ. ಅದನ್ನ ಕಂಪ್ಲೀಟ್ ಮಾಡಿ. We'll dispose it on that ground. Yes, I'll separate ಮಾಡ್ಬಿಡ್ಲ. Substantially I have dictated yesterday. It is only after coming to know that he was not represented. No, see this clause, 4 clauses here. Who filed this memo?
I filed it.
You have filed it. So these 4 clauses are here. One is may be bound by the memo and documents, not obstruct any point delivery of the entire suit subject goods. That you have accepted because of the mail communication. Take the mic.
I had sold the goods to him in November 24. He had sold it to a third party.
No, that's a separate cause of action. If you want damages or that's
I'll take
always
it.
open. Now, I am not answering anything on that. Now, this is, you have seen that memo?
Yes.
Now, clause 1, yes, you have communicated. So unhindered delivery of goods. Now, 2 and 3, it pertains to, yes, Nandakumar sir.
Lord, yes, this
2
is
and
what
3
I want.
ನಿಮಗೆ.
That's what I want.
Has no objection? Payment so and so. Yes, we'll record this and.
I'm sorry.
Then I dictate ಮಾಡಿದ್ದೀನಿ.
ತಾವು ಮಾಡಿದ್ರಿ.
I'll continue that ಅಷ್ಟೇ. Yes.
I undertake to appear for defendant number 3, respond number 3. Union
Number,
Bank.
yeah, ಬರ್ದ್ ಕೊಟ್ಬಿಡಿ ಯಾರ್ಯಾರು appear ಆಗ್ತಿದೆ.
I have filed my wakalat.
I served them yesterday, but
We'll upload the order tomorrow.
so great.
Because let him bring Union Bank of India under NPA.
ಅಲ್ಲ ಇದ್ದಾರೆ.
ಅದಕ್ಕೆ ನಾಳೆ ಅಪ್ಲೋಡ್. All right, yes. ಸರಿ ಬ್ಯಾಂಕ್ ಬರ್ಲಿ ಅದರಲ್ಲಿ.
ಅವ್ರು ಬಂದಿದ್ದಾರೆ ಅದಕ್ಕೆ. My learned friend appears for Union Bank of India.
Who appears? Union Bank.
He appears.
I appear.
You should be declared NPA once. Later ways, yes.
Let's appearing for the petitioner in this
Compensation
matter.
deposit.
Let's seeking for a direction to not to disperse the compensation.
Correct.
Because
Why?
Because a suit for partition and separate position is pending, my lords.
How can you stop? Yes. We'll see till the next. Here, new. Part 4. Who is that?
Private parties.
Well, it's respondent number 4 to 13.
Sir, by way of hand summons.
Please.
Respondents, council so and so, AGA 1,
1 state, 2 and 3 KD.
1 state, 2 and 3 KID Biniva,
Yes, Lord.
so and so. 5, 6, 7, 8. ಏನು ಇಷ್ಟೊಂದಿದ್ದಾರೆ?
They are the defendants in the suit, my lord.
Serve. The petitioner shall serve the defendants, sorry, the private respondents by way of hand summons and file an acknowledgement. Compensation disperse ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀರಾ?
We'll check it out. Next date also.
List the matter on first.
They are making hectic efforts to disperse the compensation, my lord.
The
Let there be a
respondent shall not disperse compensation till the next date of hearing. Objection ಇದೆ ಹಾಕಿ ತೊಂದರೆ ಇಲ್ಲ. Yes. List on 3rd July.
Grateful.
Next.
37.
Betterment tax.
Betterment tax, my lords. My lords, only a request and a suggestion on the interim, my lords. Now, my lords, this is a case, my lords, where the preliminary notification under section 17 was in 2008. Admittedly, my lands were sought to be acquired, dropped in the final notification in 2010. Thereafter, my lords, in 2023, they issue a fresh section 17(1) notification seeking to levy betterment tax. My lords, this honorable court has time and again said this is impermissible because it would not form part of the scheme, original scheme itself.
Which order?
My lords, partly. My lords, Carle follows my lords ex-servicemen. I'll just give both ex-service. Madam. My lords, may kindly see page 22, my lords, of Carle infrastructure. Similar facts, my lords. It is also relevant to state that BDA has not placed any material to establish that the subject lands which are undisputedly not compromised in the remodified scheme are required for execution of the remodified scheme. Under these circumstances, in the absence of dual or twin requirement contemplated under 20 of the BDA Act being complied with or fulfilled, BDA does not have jurisdiction or authority in law to issue the interim notification. Now, my lords, the scheme of the BDA Act is very clear, my lords. The scheme of the BDA Act is this, that a scheme is proposed under section 15(16), which is followed by a section 17 notification. Now, my lords, if I may just place 17 for a moment. 17 actually very interestingly has two components. The first component of 17.
Now, BDA has to answer.
My lords, in this case, my lords, BDA has approved in 2021 in its meeting, it has approved my modified layout plan. But my lords, withholds giving the modified plan only on the ground that I have not paid betterment tax. And my lords, in 23, they issue annexure A. If my lords may kindly have annexure A for a moment, my lords.
Yes.
My lords may kindly see annexure A is, my lords, published in the official gazette on 20th April 2023. It is dated 3/7/2018.
Yes.
Tracing back to a preliminary notification of 21/5/2008. My lords, in the 21/5/2008 notification, admittedly, lands were for acquisition, not for the purpose of betterment tax. In the final notification under 19, it is dropped in 2010. Now, my lords, kindly see what they do at page 51. My lords, without any authority in law, they say you have to pay a total amount of so and so, which is on the last column. My lords will kindly see. And interestingly, they say the first column 2.75 is towards the principal.
How do you reconcile 17, 1 and 5?
My lords, I'll show that. My lords. If my lords may kindly see 17 for a moment.
BDA Act.
My lords, actually what 17 says is, my lords, at the time of issuance of the 17 notification, the notification should either specify the land is for acquisition or for the purpose of betterment tax. Now here, my lords, my lands were originally for the purpose of acquisition. not for the purpose of betterment tax, dropped in the section 19 notification. A new section 17 is issued in 2023 for the first time. And my lords, kindly see, even under that, principles of natural justice are to be complied.
Serve on,
My lords, may I
counsel for the BDA.
make one request, my lords, because I understand the difficulty here for the purpose of interim. My lords, on such terms, my lords, whatever terms my lords deems fit.
No, because your main prayer and the interim are the
No,
same.
my lords, I will deposit the amount, my lords, without prejudice to my rights in this petition. Let them go ahead and issue the modified sanction plan, because my lords, I have avowed in para 12. If and my lords may kindly see para 12 and 13.
No, let the counsel for the BDA come, will pass that order. They will take it day after tomorrow.
My lords,
Or on 1st,
my
or
lords,
on 25th, 24th,
25th.
24th. Tuesday.
Yeah,
Tuesday or Thursday, let me know which.
Thursday, my lords, 26th.
26th. List, counsel Ajay Kumar is directed to accept notice for the respondent BDA. The learned HCGP 1, 2 and 3. 1 HCGP, 2,
All other
3,
BDA, my lords.
2, 3, 4 Ajay Kumar. Counsel for the petitioner to serve set of papers upon the aforesaid counsel forthwith. List the matter on 26th
In the fresh matter.
for the consideration of interim prayer. Yes.
Admission 38.
Jagdish ಇದ್ರಲ್ಲ ಇಲ್ಲಿ. Accused, ನಾಲ್ಕೈದಿದೆ ಮುಗಿಸ್ಬೋದು.
My lord, petitioner was working as SDA, my lord.
ಕವರ್ಡಾ ಇಲ್ವಾ? ಮೈಕ್
Covered illa.
ಇಂಟರ್ ಮಾಡಕ್ ಕೊಟ್ಟು.
Gave interim order is there.
The learned counsel objections ಹಾಕಿದ್ದೀರಾ?
Objections ಹಾಕಿದ್ದೀವಿ.
ಮತ್ತೇನು ಯಾವಾಗ submission?
25th March.
List the matter on 25th at the request of the council appearing for the Lokayukta B.B. Patil. The learned counsel for the petitioner submits that the issue in the list stands answered by a criminal petition 5793 of 2023. This has become final?
It has become final. 5793.
5793 of 2023 disposed on 6th October 2023. The learned counsel for the respondent submits that the issue does not, the issue in the case at hand is not answered by this court in the aforesaid criminal petition. Therefore, as a last chance, list this matter on 27th.
It is published. Even the
Interim order subsisting will continue till the next date of hearing.
published. A2 is also retired or RI published.
Yes.
39.
39, 306. Parents was making an allegation that investigation not been done properly, and they are making, that's a case for 302 has been converted into 306.
306, correct. Is the complainants, the?
This is, he is an accused.
I am appearing for respond number 2, my lord.
Complainant.
Yes, my lord.
Yes, sir. ಹೇಳಿ.
My lords, offense under 306 and 66E and 67A of the IT Act, my lords.
Interim order ಕೊಟ್ಟಿಲ್ಲ ಅಲ್ಲ?
Interim order is there, my lords.
Yes.
306 ಅಂತ ಕೊಟ್ಬಿಟ್ಟು.
Yes, sir.
The
Tell me.
allegation is that, my lords, column number 17.
Come to page 13. Yes. 13 of what is filed memo along with documents. What is the relationship between you and the deceased?
My lords, they were in a relationship, my lords, boyfriend.
Oh, relationship is the relationship. All right.
Love relationship. My lords, the entire, even the FIR, my lords, I would like to take your lordships to the FIR complaint, my lords. This FIR is only registered only on the base of the, only to acquire monetary benefits, my lords.
Who wants monetary benefits now?
The second respondent, my lords. 40 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ವಿ, 40 ಲಕ್ಷ ಇದ್ ಮಾಡ್ಕೊಡಿ ಅಂತ. Even in the last petition, my lords, while disposing, the respondent suggested the already charge sheet is filed, my lords. But the charge sheet is comes to be filed only after the next day, my lords. After disposal. While disposing the petition, earlier petition, my lords, I would like to place.
In fact, the entire charge sheet was not filed.
You're ready? Rudresh.
This for 1 week time.
First, they issued two notices, my lords. Seeking urgency, I move a memo and get the matter posted, my lords.
ಯಾಕೆ ಮಾಡಕ್ ಹೋದ್ರಿ?
And then after that, before this honorable court, they come and they say the charge sheet is already filed, my lord. So then this honorable court directs me to challenge the charge sheet, my lord.
One moment. Recommendable. Why is that ಅವ್ರನ್ನ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ? ಯಾವ ಕೇಸಿಗೆ ಕೇಳಿ? Who asked ಕರ್ಕೊಂಬರಕ್ಕೆ ಯಾರು ಹೇಳಿದ್ರು? Yes.
Serial number 43. Serial number 43.
Why? Who called?
Warrant against, the last time, serial number 43.
Warrant against whom?
Petitioner to be, if she has to pay 1 lakh or she has to be arrested and produced before. There was a direction.
And she is the one?
Please.
My order.
No.
Writ petition came to be dismissed on the cost of 1 lakh. That cost is not paid, and then bailable warrant was issued. Last date, your lordship had directed them to look into it.
To comply the said order,
They not paid the cost, then the order to arrest.
So it was earlier ordered by the previous bench.
Coordinate. As against that, my lord, appeal is, writ appeal is pending, my lord. 341 of 23, my lord.
ಇವ್ರನ್ನ ಕರ್ಕೊಂಡ್ಬರ್ರಿ. 1 ಲಕ್ಷ ಅವ್ರ ಹತ್ರ ಇದೆ. Had I known, I would never have asked, what is this? Did you not tell the coordinate bench with the condition of the petitioner or the age? ಹೇಳಿಲ್ವಾ?
ಹೇಳಿದ್ರು, you urged the ground also, writ appeal also.
Non-bailable warrant was issued, none of them was present for petition.
They are unable to pay the amount.
That's all right. Cost was imposed on what?
Petition came to be dismissed.
Now I can't set that aside.
Yes, madam.
Only division bench can do it.
Till that statement, you are kept in abeyance.
Yes, sir. What 1 lakh will you extract from? Cut off procedure. The coordinate bench, I'll just pass the order in this
Yes,
and continue with that. The coordinate bench has while dismissing the petition, directed payment of costs of rupees 1 lakh for having filed a frivolous case. The amount was directed to be paid by the petitioner to the Karnataka State Legal Service Authority.
At 500 rupees for each day.
And delay of every day would incur 500 rupees day on day. Therefore, the cost was not paid. The matter was placed before the same coordinate bench. The coordinate bench on 17/4/25 had passed the following order directing issuance of non-bailable warrant to be executed by the jurisdictional police. The police have now, in execution of the earlier order, kept the petitioner present kept before the court. The petitioner is on wheelchair and is ಎಷ್ಟು ವರ್ಷ ಅವ್ರಿಗೆ?
ಅವರಿಗೆ 92 ವರ್ಷ ಆಗಿದೆ.
And is 92.
Health is also not.
And 92 years old, and she was the sole petitioner challenging the acquisition. In the light of the said circumstance, I deem it appropriate to ಏನಾರು ಹಾಕಿದ್ದೀರಾ? ಏನ್ ಹಾಕಿದ್ದೀರಾ?
ಅಲ್ಲ ಐ ಹಾಕಿದ ಐಯನ್ನು ಹಾಕಿದ್ವಿ, ಗ್ರೌಂಡ್ಸ್ ತಗೊಂಡಿದ್ದೆ.
ಅಲ್ಲಪ್ಪ, ಇಲ್ಲಿ ಏನಾದ್ರೂ ಹಾಕ್ಬೇಕಲ್ಲ?
ಇಲ್ಲಿ ಏನು ಹಾಕಿಲ್ಲ.
ರೀಕಾಲಿಂಗ್ ಹಾಕಿದ್ದೀರಾ? ಏನ್ ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ ಹಾಕಿಲ್ಲ.
ಏನಾರು ಒಂದು ಹಾಕ್ಬೇಕಲ್ಲ?
Sorry.
ಏನು ಹಾಕ್ದೆ ಇಫ್ ಐ ಡು ಮತ್ತೆ ಅದನ್ನ ಅಪೀಲ್ ಇವ್ರು ಹಾಕಿದ್ರ ಮೇಲೆ
ಅಲ್ಲ, appropriately they will, ನಮಿಗೂ ಗೊತ್ತಿಲ್ಲ, they will brought.
ಎಸ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಯಾರಿದ್ದಾರೆ ಸ್ಟೇಟ್
State and KDB.
KDB
Please.
ನೀವೇನು ಅಪೀಲ್ ಹಾಕಲ್ಲಲ್ವಾ ಎಸ್ ಇನ್ ದಟ್ ಲೈಟ್ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಏನೋ ಹಾಕಿ in that light I deem it appropriate to keep the order so and so in abeyance till the next date of hearing. I list it on first or second. The warrant so directed to be executed stands discharged. Karkono hogi mane.
Much of it.
Yes. And on the application haki, seeking recall of that at least. Is there what is this? 92-year-old na karkom bandil wheelchair alli. Yes. When was this order passed? 17/4, before the vacation. All right, yes. Hey, Gadis.
My lords, page number 29 of the petition, my lords. The complaint copy.
Page number?
29 of petition. Complaint copy. Typed copy of the complaint, my lords. Please.
ಎಷ್ಟು ವರ್ಷದ ರಿಲೇಶನ್ಶಿಪ್?
2 years, my lord.
ಡೆತ್ ನೋಟ್ ಇದೆಯಾ?
No, no death note, my lords.
You did not get married to her?
No, my lords.
Why?
Still they were working, my lords. So
Still they were working. What working?
no marriage prospects, sir. ಮನೇಲಿ ಯಾರಿಗೂ ಗೊತ್ತಿರಲಿಲ್ಲ. 29, page number 29, the complaint, my lords.
306 again ground, Satish.
No, their contention is it is not 306, it's 302.
Murder? Well, further investigation ಆಗಿದೆಯಾ?
What they were asking.
Further investigation is required. You are not satisfied with this charge sheet. Therefore, we will challenge it.
How are you saying that it is a case of 302?
He has instigated the
Instigation ಗೆ 306.
seizure. So therefore, she has committed a suicide.
ಅದಕ್ಕೆ 306 ಬರೋದು, 302 ಆಗಲ್ಲ.
So they were in love since 3 years.
All right.
Thereafter, when he promised to marry her, he did not marry her.
All right.
Then he has collected more than 40 lakhs from her. Then later that deceased father came to know that he has transferred so much money to her. So that completely that he has instigated. Therefore, completely she was under loss.
The instigation ಗೆ 306 ಬಂದಿರೋದು.
All complete bad allegations,
Wait,
my
sir.
lords.
302 ಹೆಂಗಾಗುತ್ತೆ ಹೇಳಿ? What, Rudresh?
Another date of incident that Varun, that picture was in the spot.
ಆಯ್ತು. Spot 306 fine.
Let them face the file.
For 306. That we'll see.
Entire charge sheet is filed on based on only upon the voluntary statement of the accused, my lords, first. All the last statement.
Corroboration ಇದೆ sir, death.
There is a transaction, so there are many materials to show.
All the material is there, my lords. All the losses occurred in her account itself. Nothing has been transferred. In fact, she has obtained loans from the petitioner itself.
Page 245, my lord, kind of photograph which is extracted and then.
That's, you have extracted money not just like that.
No, my lords, no money is, where is the bank account? Details are also placed, my lords. I have transferred money, my lords, to her.
ಯಾರಿಗೆ ಕಳಿಸಿರೋದು ಇದೆಲ್ಲ?
No materials to send, my lords. Only they have obtained some photos, that's it. No materials to show that it has been sent to somebody or it has been transferred to somewhere. Deleted photos, they have recovered in FSL. That's all, my lords.
Deleted photos, ಯಾವ್ದ್ರಲ್ಲಿ delete ಮಾಡಿದ್ರಿ?
Mobile ಅಲ್ಲಿ delete ಆಗಿರೋ photos they have recovered in during in the FSL, my lords. That's all. There is no.
ಅಲ್ಲ ಯಾರಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಕಳ್ಸಕ್ಕೆನಾ?
Captured it and then blackmailed her and then that's how he extracted money from her. And our case is, my lord, that is where he drove her to commit suicide. It is not that just go and die case of suicide.
My lords,
so these are the
if
circumstances
he has transferred money, my lords, there should be some account statements, my lords. But here in the account statements, it shows that he himself has given loan to the deceased. Even the additional document, my lords, my lordship may look into, my lords.
Ready. Three not two ಆಗಲ್ಲ. ಇಲ್ಲ 302 ಅಂತೂ ಆಗಲ್ಲ ಡೆಫಿನೆಟ್. ಮರ್ಡರ್ ಆಗಲ್ಲ.
Therefore, my lord, my humble submission that father of the deceased is not satisfied with the final report.
ಏನ್ ಫೈನಲ್ ರಿಪೋರ್ಟ್ ಏನ್ ಹಾಕಿದ್ದಾರೆ? 306 ಹಾಕಿದ್ದಾರೆ. ಮತ್ತೆ
Instead of registering 302.
302 ಹೆಂಗ್ ಬರುತ್ತೆ? ಸುಮ್ನೆ 302 ಹಾಕಿ ನೀವು ಕೇಳಿದ ತಕ್ಷಣ.
He has not produced the entire charge sheet.
ಇಲ್ಲ ಇದೆ. How is it 302? Tell me. Yes, may have blackmailed or whatever it is. That's a different thing. But how is it 302?
Further investigation is very much required.
On what ground, my lords?
And the fight also happened on the terrace.
No, you are in relationship.
Please,
who else can instigate? Only you.
My lord, she has lost 51 lakhs, my lords.
ಯಾರಿಗೆ?
She has lost in shared business.
ಪರವಾಗಿಲ್ಲ. Yes.
My lord, senior is engaged in this matter.
Senior?
Yes, my lord.
ಇಷ್ಟೊತ್ತು ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಮತ್ತೆ?
My lord, senior is
get him.
My lord, he is unwell, my lords, next week.
ಯಾರು?
Ravi Binayak, my lords. Senior counsel.
ಮಾಡಿ. Yes.
My lords, it's unwell, my lords. So, my lords.
How did we grant a stay in this?
Initially it was said that 306 only abatement.
Entire charge sheet allegation is the only that much, my lords. Go and die.
There is no go and die.
Oh, intention was to grant an interim order, so ಅಂತ ಆಮೇಲೆ ಕೊಟ್ಟಿದ್ದೀನಿ. Go and die or do whatever you want.
Please, my lords.
That is not even a case. That is not the case of the prosecution.
If that is the only thing.
No, that is not the case of the prosecution. That's what is submission. The allegation is that, my lord, he had an intimate photograph with him.
Correct.
Second, the fight happened and both of them were fighting on the terrace with respect to financial transaction. He extracted money and made it
on the date of death.
On the date of death. On the date of death, both of them are fighting on the terrace.
No material.
ಆವಾಗ go and die ಅಂತ ಹೇಳಿರ್ತಾರೆ.
That is not even, that is the case. That's not the case. There.
My lords, entire chats has been extracted in the charge sheet, my lords. Anywhere blackmailing is there, I will withdraw the petition myself, my lord. Entire chats, WhatsApp chat has been placed, my lords. And all the call records between the deceased and the petitioner has been placed.
The FSL report, ನೀವು ಹಾಕಿರೋದು. ಅದರಲ್ಲಿ ಏನಾದ್ರು ಕಮ್ಯುನಿಕೇಶನ್ಸ್ ಇದೆಯಾ?
ಅಲ್ಲ, ಇದರಲ್ಲಿ we have extracted entire mobile phone data which discloses conversations and then the photograph which he has.
If it's go and die, we will see.
It is not go and die case. It's not simple go and die case. That is the case.
Simple go and die, but go and die.
No, it's not.
They are saying blackmailing, my lords. Entire chats have been placed before this honorable court, my lords. It's part of the charge sheet itself, my lords.
Will answer. Heard reserved.
My lords, one opportunity next.
ಯಾವ opportunity? ಎಲ್ಲ argument ಆಗೋಗಿದೆ. Next. If it's a go and die case, we will answer it. Yes.
40.
My lords, one more submission, my lords. If the photos are been looked into, it is majority of the photos have been taken by the deceased.
Your photographer, who is going to look into, sir? That is for the, if at all it is to be looked into, it is for the trial court, not this court. Yes. Yes, we'll see.
40.
Entry order ಕೊಟ್ಟಿದ್ದೀನಿ ನಾನೇ. Entry order subsisting will continue till the disposal of the petition.
Page 33, my lords, on the last occasion, lordship had heard this matter, my lords. However, the respondent, my lords, number 2 was not present. Notice was issued, my lord, they were being served, my lord, and represented.
Yes, Jagdish.
This is a case where, my lords, the pet, my lords, dog of the petitioners had, my lords, gone to the house, my lords, of the respondent number 2, my lords.
So the
Page
dog,
33.
Dog
Page
pet, my
33.
lords.
who let the dogs out? Yes. Page?
Page 33, my lord.
33, my lord. In fact, there is a complaint, my lord, which is filed by the petitioners also, my lord, against the family members, my lord, of respondent
No,
number 2.
that was the only allegation, then it's a different thing. If you come to the charge sheet, Kuttige hididu, nighty haridu.
Lords, in the first sentence, they say, my lord, ಕಡೆಯವರೆಗೂ ಸುಮಾರು ಬಾರಿ ಗಲಾಟೆ ಆಗಿದ್ದು ರಾಜಿ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. Lords, there are several fights, my lord, which have taken place, my lord, between the family members of the petitioners and the respondent number 2.
And there are eyewitnesses to the entire incident. PW 2, 3, CW 2, 3, and 4 are eyewitnesses to the incident. They
I
witnessed about
is one of the instance, but there are other things here. And there is no representation, this man doesn't come at all. There was no representation on behalf of the second respondent on 10/6/2025. Awaiting his appearance, the matter was posted to this date, 17/6/2025. The counsel for the second respondent even today remains absent. In that light, the petitioner and the learned additional SPP are heard. As a last chance, the matter be listed on 24th. In the event the petitioner counsel for the second respondent would not be present, appropriate orders would be passed on hearing the counsel for the petitioner and the learned additional SPP. Interim order subsisting will continue. Ilva? Sir, yes. Our next.
41.
Any very first, any date, my lords?
For the petitioner, my lords.
Yes, sir.
Allegation of breach of trust and forgery, my lords. My lords, the.
Wait, one ನಿಮಿಷ. ಏನ್ wait, sir, ಇನ್ನೂ ಏನ್ ಕೇಳೇ ಇಲ್ಲ ಅವ್ರನ್ನ.
My lords, the petitioners have availed.
Interim order ಇದೆ ಇಲ್ಲಲ್ಲ?
There is no interim order. Today they have filed their statement of objections.
What's the stage of the proceeding?
Framing of charges. Matter is posted for framing of charges.
Is issuance of non-bailable warrant.
ಅಲ್ಲ, ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆಯಾ?
ಆಗಿಲ್ಲ, ಇನ್ನೂ ಆಗಿಲ್ಲ. Charges are not.
ಪರವಾಗಿಲ್ಲ, it's a 2017 order challenging now after 8 years. I will not interfere.
Well, if it could be relisted in the next week.
No, sir.
Now the allegation, the allegation in the charge sheet.
File discharge.
Is that,
if you want file discharge.
For a moment, if I can submit,
You are challenging an order of taking of cognizance or the proceedings in CC 2017.
Well, it's one submission.
And the petition is filed in 2025.
Well, I have one submission. The allegation in the complaint by the respondent number 2 is that the property which is mortgaged to secure the loans which are availed by the petitioner are on the basis of forged and fabricated documents.
KSFC is the complainant.
KSFC is the complainant. And the allegation is as far as the accused number 4 is concerned. Accused number 4 stands as a guarantor for the loans which are availed by the petitioner. Now, KSFC has initiated recovery proceedings before the debt recovery tribunal, and they already have a recovery certificate. It is purely civil in nature, and my lordships have already.
Why the complaint is registered?
Well, its complaint is registered merely because they are unable to execute the recovery certificate on the property. They are unable to.
Property ilve ilva?
Property illa. Person, the person whom they have brought before the financial corporation, that said person in herself is not there, and they have not made her as a party before this.
How did you grant loan?
Well, it's in this honorable court.
At that moment of time,
how did you grant loan?
At the time of granting of the loan, these people have brought somebody in the name of Parvatama.
How?
Even my lords, even they have executed debenture agreement. The debenture agreement clearly shows they have given this property through fourth accused.
For a moment, if I can submit my lords, they would have verified all the credentials of the respondent number 4.
Anyway, it's 2017 cognizance order, sir. I will not.
My lords, they have already initiated surface action and have those records.
Surface action is for recovery. So as
the property is available, my lords. The allegation in the charge sheet, property is available.
Wait, Vinay Kumar. Wait, sir.
They have invoked surface, my lords. Surface invoking of surface would be by obtaining a valuation report. Property is available. They have initiated surface.
Now, where is the proceedings before the DRT?
My lords, those records I will immediately secure and I will file it, my lords. Those
Yes,
I could.
have you filed? Other Lydia.
Today he has filed.
DRT proceedings idea. On what basis? On what basis did the DRT grant recovery certificate?
Recovery certificate, my lords, granted by Honorable DRT, basing on the properties which are given by the fourth accused, she has also been made as a party. At that moment of time, your lordship may kindly take to.
No, what have you done to the officers of the case if you granted loan without looking at
Well,
anything?
we had made them also parties before the honorable court. Those proceedings came to be quashed by this honorable court. And these two petitioners who have come before this honorable court are the principal borrowers. Principal borrowers. They brought her before the officials and they had shown these properties at that moment of time to those officials.
It's property
And
never.
believing that that property belongs to her.
So ನೀವು ಯಾರು ಕರ್ಕೊಂಡ್ ಬಂದ್ರು ಕೊಟ್ಬಿಡ್ತೀರಾ? You believe everything.
Your lordship may kindly.
ಅಲ್ಲ, your officers believe everything.
There is a provision available for everybody. A principal borrower has got that kind of a right to bring in some third party collateral security. At that moment of time, basing on the documents, my lords, there are several documents what they have produced before the authorities. Kata extract
Well,
and
right,
also.
you look into the objections.
I look into the objections and I will submit on that.
But it's 2017, I will not interfere.
My lords, they have invoked surface and they have
Whatever.
recovered their money. my lords.
File discharge.
They have recovered their money.
We have not recovered any, not even a single penny we have recovered.
Learned counsel for the respondent files a statement of, complainant files a statement of objections. The same is taken on record. Counsel for the petitioner seeks a week's time.
And also objection to IA notice.
Seeks a week's time to go through the objections and make his submissions. List the matter on 4th July.
Great.
Yes.
4th July.
42. Ticket number 42 for respondent to senior is engaged in this matter, my lord.
So,
I kindly seek pass over, my lords.
wait, pass over.
Illegality.
Earlier order I had passed.
Yes, earlier. ಈಗ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ.
Earlier order, what happened again?
Well, again, ಇಲ್ಲಿ major illegality, may I request your lordship to kindly turn to the operative portion of the order which my lord gets at page
108.
38.
38.
38. CRPC ಅಪ್ಲೈ ಆಗುತ್ತೆ. ಇವರು.
ಅಲ್ಲ 38.
ಹೌದು. Operative portion of the order. Impugn. He records the sworn statement. Sworn statement record ಮಾಡಿದ್ಮೇಲೆ 156.
Before BNSS.
ಹೌದು, ಅದು ತಪ್ಪೆ. ಇದು ಏಪ್ರಿಲ್ 2024 ಕೇಸು.
BNSS ಅಪ್ಲೈ ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಅಪ್ಲೈ ಮಾಡಕ್ಕಾಗಲ್ಲ.
The FI was filed before March of 2024, my lords.
Correct.
BNSS
1/7/2024. 1/7/2024 is the date on which.
BNSS from 1/7/2024.
My lords, kindly pass over, my lords. We will address the court in this matter, my lords.
Pass over.
Please, my lords.
Today may not be possible because 4 o'clock reference is the 2:30 on parted matter there.
Lords, a date may be given, my lords.
Tomorrow, a day after tomorrow.
An interim order mechanism.
List, day after tomorrow.
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಇನ್ನೂ ಒಂದು.
My lords, I have serious
Wait, sir.
Apparent illegality, how can he order for reinvestigation? Investigation ಇಲ್ಲ. Cognizance is quashed.
Where is the order?
38. And the court has no powers. It is only the constitutional court that has got the powers of reinvestigation, not the magistrate.
My lords, so we have.
Wait.
Apologies.
Have I issued notice?
Please.
Senior counsel is submitting, you have to wait.
Please.
38. The matter is referred to the SHO Rajgopal for further investigation under section 1.
ನೋಡಿದ್ದೀರಾ?
Apparent illegality.
Further investigation, where does he have the power?
And reinvestigation is only the constitution.
Both reinvestigation or further investigation is there.
Investigation, they have the power.
Further investigation by the same agencies, yes.
ಅಲ್ಲ, cognizance is set aside ಆದ್ಮೇಲೆ for investigation, entire thing goes. Where is the question of further investigation? My lord's order is.
Wordings may be wrong.
Cognizance itself is bad.
That's the problem.
You should have said the investigation.
Further investigation is permissible, no doubt.
But where is the investigation? No further investigation.
No, cognizance order was set aside.
ಹೌದು. Page 108.
No, set aside and matter was remitted to redo the exercise.
ಹೌದು.
That is 156(3) did not bear application of mind ಅಂತ ಕಳಿಸಿದ್ದು.
ಹೌದು, ಅದು office is directed to register case and investigate ಅಂತ.
To office is directed, that was also a word was wrong.
When the FIR itself stands obliterated.
FIR is not quashed.
ಮಾಡಿ ಇದೆ.
ಹೌದಾ?
109 ನಲ್ಲಿ ಇದೆ. D.
The order dated 34/20/24, what was that?
Well, that is the order of reference
I
by,
perused
to
the
the office
contents.
to register case and to investigate.
Correct. 156(3) order was set aside, sir.
Then it is investigation.
It is investigation.
Goes.
Now,
Further
he has used the
investigation.
word further, en bekella use ma.
Probably can.
Apparent illegality.
No, we will tweak
Remand
this
and
order.
set
We
aside
will
and
only
remand it
permit
back.
investigation. Investigation nadili.
Under the BNS.
That we will answer.
Assessed.
We will, investigation should go on.
No, when my lord
Yes.
hears me, let me see what needs to be.
Because this is only an illegality which I will cure under 482 and send it back for investigation.
ಒಂದು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗಲ್ಲ ಯಾತಕ್ಕೆ ಅಂದ್ರೆ ಮೇಲೆ the legal position is after recording the sworn statement there is no question of reference under 156(3). When once he
Then he
chooses.
has to go on the 200 route.
ಹೌದು
202 route.
ಹೌದು that is the
There is-
settled legal
there
position.
is one judgment which
ಯಾವ judgment ಇಲ್ಲ
which says that even after taking cognizance, there can be reference in that one.
156(3) ಅಲ್ಲ
We will rely on
Yes,
That is there, yes.
there is a judgment.
no
That is the latest judgment.
Yes, yes.
we'll your lordship may examine it. We'll make our submissions and lordship may examine. ಅದೊಂದು ಆಯ್ತಲ್ಲ ಇವರು ಮಿಕ್ಸ್ಚರ್ PNS CLPC
Yes, generated obfuscation which was not needed. But investigation should go on. Earlier also it was quashed on a technical ground of non-application of mind. Is over application of mind agide ashte. Yes. We'll take it on Thursday.
Please, my lords.
let there be an interim order.
Again, Thursday we'll grant, we'll set it aside and do whatever is to be done. List on Thursday in preliminary and admission, yes.
ಇದು ಪೊಲೀಸ್ ತೋರು ಏನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ
Heard the learned,
notice
senior,
after notice they are issuing asking us to appear before.
don't precipitate. The learned, heard the learned senior counsel, Shri C.V. Nagesh appearing for the petitioner. Counsel for the complainant seeks 2 days' time to make his submissions.
ಅವ್ರ ನೋಟಿಸ್ ಕೂಡ ಆಗಿಲ್ಲ voluntarily he is appearing before the court.
Emergency, learned counsel so and so undertakes to enter appearance for,
My lords, we have filed wakalat.
how did you file, sir?
My lords, we saw the.
How did you file wakalat?
My lords, in fact, on the.
The court is over application of mind, you are over indulgent. Yes, unnecessary over indulgence. The learned counsel so and so undertakes to enter appearance for the second respondent, complainant, registry to print the name of so and so is appearing for the second respondent. The learned additional SPP, B.N. Jagdish for the first respondent. State, list day after tomorrow in admission. The state shall not precipitate the matter to the next date of hearing.
Please.
Orders 43 and 44.
It's 44, my lords, I appear for the petitioner. Lords, there's an office note, my lords, with regard to non-filing of LR application.
ಹಾಕಿದ್ದೀರಾ ಈಗ?
Lords, ಅದರಲ್ಲಿ R3 and R4, they are my vendors. Lords, they are not necessary parties.
Memo ಕೊಡಿ.
Lords, they may be deleted, my lords, because I've already said that in the cost title. Your lordship will see
ಹಾಕಿದ್ದೀರಾ?
page 7.
R3 and R4.
R4 and R5.
R4 and 5. The learned counsel Sriraj Gowda submits that R4 and R5 are not necessary parties, and as no relief is claimed against them, and as the said averment is already in the petition. In that light, notice to R4 and R5 stands dispensed office. The indication in the office. R4 ಇದರಲ್ಲ ಕೌನ್ಸಿಲ್ ಇಬ್ರಿಗೂ.
R4, R5 ಇದಾರೆ. ಆದ್ರೆ
ಮತ್ತೆ?
LR application ಹಾಕ್ಬೇಕು, ಅವ್ರು ತೀರೋಗಿದ್ದಾರೆ ಅಂತ ಬಂದಿದೆ. So
ಹಾಕಿ
lords,
ಮತ್ತೆ.
ಅಲ್ಲ, LR application, they won't be necessary, my lords, because they are the original landowners.
Then you file a memo, because they've already represented, you file a memo.
I'll file a memo.
When do you want?
Next week, my lords, Tuesday.
First, sorry, 24th. List on 24th. Yes, next.
45.
May I seek a short pass over, my lords, 2:30, my lords, kindly.
45. I appear for respondent 213.
Again, what are these matters?
My lords, there is some rectification on the office objection, my lords. We'll
The application is served on us today, my lord.
Learned counsel for the petitioner submits office objections have been complied with.
No, my lords, we'll look into
Inno
it.
idea?
We'll look into it and comply.
Look
my
into it. Learned
And
counsel,
one submission.
2 weeks'
IA
time
1
is,
of 25 is
My
first
lords.
day after 8 years of filing petition. It can be, mine matter can be disposed of.
which matter, sir?
45, my lord. serial.
ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಬರಲಿ, yes.
My lords, the date may be fixed. My
Lest the
lords.
matter on 27th, office objections be complied with in the meantime. In the event the stand complied, post the matter in B group.
Date film.
Obliged.
46.
I'm appealed for the petitioner. Amended petition already filed, my lordship, week's time you granted, my lordship.
Learned counsel seeks a week's time to do the needful.
Office may be directed to show the name of Manu K for R1 and
Harige.
R2. R1 and R2.
Registry to delete the name of H.G. Vasant Kumar is appearing for R1 and R2 and print the name of Manu K. Yes, next.
47.
My lords, I appear for R5 in this
Filed
matter.
their objections in this matter, my lord.
ಯಾವಾಗ? ಏನಾಯ್ತು?
ಅದು ಇನ್ನೂ ಹಾಕಿಲ್ಲ ಅವರು. Very
Lord,
short question, my
Lord,
lord.
47.1, my lord, I entered appearance, my name is not shown.
ಯಾರ ಜಾಗದಲ್ಲಿ?
Chennaigoda, C. Chennaigoda.
ಅದು registry to 47.1 ಅಲ್ಲಿ madam. Registry to delete the name of C. Chennaigoda as appearing for the fourth respondent and print the name of H.L. Pradeep Kumar. Next, learned counsel submits that objections, petitioner submits that the objections are not filed despite passage of 3 years. Therefore, finally, 2 weeks' time is granted to file statement of objections. List the matter on 3rd July. In the event objections would not come about, it would be construed that there are no objections to be filed.
One request, my lord, if they can serve a copy a
Advance
couple of
copy
days before
ಕೊಡ್ತಾರೆ,
that,
yes.
so then we can rejoinder avate ಆಗ್ಬಿಟ್ಟು.
The
ಅಲ್ಲ ಅದರಲ್ಲಿ ರೀಸೆಂಟ್ ಆಗಿ ನೋಟಿಸ್ ಆಗಿದೆ 20.
ಹಾಗಾದ್ರೆ we'll take it on, yes, Pradeep Kumar, one ನಿಮಿಷ. We'll take it on 10th July.
Lord, the first matter, my lord, last week, my lord, 1 month back, my lord, notice has been ordered.
10th July and 3 weeks alda.
24.
3 weeks, yes, 10th July, same order.
48.
Why is this here?
My lord, interim orders.
Interim, madam, interim order ಎಲ್ಲಿ ಹೇಳಿಲ್ಲ, ಅದು ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬಿಡಿ. ಏನಿದು? ಇಲ್ಲಾಕ್ ಬಂತು?
There is an order passed, my lordship. There's an interim order passed, my lordship, my lords. I have filed a right
Set aside sale.
clarification, my lords.
Clarification. Clarification ಇಲ್ಲೇ ಬರ್ಬೇಕು.
Last week goes to Mudya Bandito. Lord, kindly see the order.
At that time, IA was not put up ಆಗಿರ್ಲಿಲ್ಲ.
The honorable court passed an order.
ಏನ್ order?
To extend it. Lord, 9/6/2025 the order also. In fact, my lord, roaster judge here heard the matter.
No, my lords.
You know, it's a fact.
My lords, matter was adjourned, my lords, for the, on the request of the respondent. My lords, there was no IA which was put up. IA put up ಆಗಿರ್ಲಿಲ್ಲ. IA was not put up, my lords.
Now what clarification you want in this?
Maybe passed over, my lord. Senior counsel is on his election of the court, my lords.
Earlier order is mine, is it?
Please, my lord.
Interim order to, in fact, my lord, first petition, my lord, there is no interim order. In fact, my lord, from the 2024 classification NP has been before the honorable court. Wherein, my lord, we filed a judgment on the last date of hearing before the learned, my lord, roaster judge. My lord, he's fully satisfied, said that he has to take the condition before the DRT. Wherein, my lord, they are already before the DRT.
My lords, may I make a submission, my lords? My lord, last date of hearing, the respondent counsel, in fact, took an adjournment, my lords,
No, no,
nothing
it's
else
not so.
happened.
I argued the matter. I filed the judgment before the honorable court. Matter heard fully.
My lords, in fact, my lords, the
Hello,
respondent was
what
directed-
clarification are you seeking, sir?
My lords, they are supposed to produce the documents, my lords, which directed by this honorable court.
One
They failed
moment,
to
one
produce.
moment, sir.
My lord, there are 3 petitions. The first petition, my lord, assailing, my lord, my classification of NPA. And second 2 petitions, my lord, in respect of, my lord, handing over certain documents.
No, sir, no clarification.
Please make,
ಅಲ್ಲೇ
my lords, may kindly
and
pass over, my lords.
last week it ಬಂದಿರೋದ್ರಿಂದ I will not, this is nothing to clarify.
But today they said.
My lords,
this
my
is the
lords,
matter.
there was a specific order, my lords.
ಇವತ್ತಿತ್ತ ಡೇಟ್ ಇತ್ತಾ?
This, you said, my lord, the specifically.
Released on 16/6/2025.
Dismissal. Today, my lord.
My lord, this is a
dismissal
wrong
ಅಂತಿಲ್ಲ,
submission,
ನೀವೇ-
not for
I'll
dismissal.
dismiss the matter next date of.
My lords, there are other 2 petitions, my lord, which is filed. My lords, they were supposed to produce the documents which they have not produced. They are precipitating
That
with the
does not
matter.
amount to clarifications.
My lord, they are precipitating before
Sir,
DRT and
ಅಲ್ಲೇ
NCLT, my
ಕೇಳಿ
lord.
sir, yes. The no representation we have the petition, the matter is called out. Representative ಮಾಡಿಲ್ಲ ಅಲ್ಲಿ. The coordinate bench ಹಿಂಗ್ ಮಾಡಿ, this court had passed certain orders, after which the coordinate bench holding the roster had passed an order on 9/6/2025. The order reads as follows. The bank had submitted that the petition was not entertainable as The proceedings were pending before proceedings are pending in SA 07 of 2025, having a field day. Yes, 2025. Therefore, the court had passed the aforesaid order. An application is now filed seeking clarification of the order dated, what date is that?
8/4.
Yes, Vignesh.
8/4, my lord.
Dated 8/4/2025. A perusal of the application would clearly indicate there is nothing to be clarified in the said order. In that light, the application stands disposed. Matter be posted before the bench having roster.
Date ಕೊಟ್ಬಿಡಿ sir.
ನಾನು ಕೊಡಲ್ಲ. ಅಲ್ಲಿ ಹೆಂಗು ಮೂವ್ ಮಾಡ್ತೀರಲ್ಲ alternate remedy ಅಂತ ಮಾಡಿ ಅದನ್ನ ಮತ್ತೆ now petitioners are not moving. Yes.
My lord, they have not produced the documents, my lord. They are
Yeah,
precipitating every.
Tell the court, sir.
My lord, we have, my lord. That is my lord's lordship was.
Hey,
supposed to
tell
pass
the
an
court,
interim-
sir. Tell the court, where should I clarify that?
My lords, they come before DRT, they say that there is no specific order passed, like,
Hey, you
directing the DRT, my lord.
take an order, sir. I am not holding GM. There is nothing to be clarified there. Now Vignesh will clarify everything there. Yes.
Grateful.
49.
Let the mandamus to register kata.
Non-payment of court fees, sir.
Yeah, that is paid.
ಅದು important. Mandamus ಗೂ ಮತ್ತೆ
It was not
court fee
necessary.
ಕಟ್ಬೇಕಲ್ಲ.
It was not necessary because
Mandamus ಬೇಕಾಗಿಲ್ವಾ?
ಅಲ್ಲ court fee ಬೇಕಿರಲಿಲ್ಲ ಆದ್ರೂ I paid ಮೇಲೆ 12,600.
Court fee ಬೇಕಾಗಿಲ್ವಾ?
ಕೊಟ್ಟಿದ್ದೀನಿ ಒಂದ್ ಸೆಟ್ ಎರಡ್ ಸೆಟ್ ಬೇಕಿರ್ಲಿಲ್ಲ. Anyway, I paid that also.
ಆಯ್ತು. List day after tomorrow in preliminary hearing. Counsel for the petitioner submits needful has been done. Yes.
ಅಲ್ಲ ಇದು only mandamus.
Only ನಾಡಿದ್ದು.
Notice ಮಾಡ್ಬೋದು.
Learned counsel B. Vachan is directed, BD ತಾನೆ?
ಯಾವುದು?
Vachan is directed to accept notice for the respondent petitioner to serve set of papers upon the aforesaid counsel forthwith list on
Next week.
24th.
Hearing on IA 50.
The acquisition proceedings initiated in the year 1961, my lord.
Ready?
Appearing for the respondent number 5 with this case. I'm the beneficiary of the acquisition proceedings. This is the case where acquisition proceedings has been concluded 44 years ago.
All right.
Challenged before this honorable court thrice.
ಮತ್ತೆ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಏನು ಕೊಟ್ಟಿದ್ದಾರೆ?
There was a delay in representation.
Deputy Commissioner, my lord.
Shall not take into law hands status quo maintain. Yes, sir.
And
You want time?
no, my lord, I want to make my submission.
Yes, sir.
Yes. The acquisition, my lord, the preliminary notification under section 4(1) of Land Acquisition Act dated 13/3/61, presented on 8/6/61, my lord. Final notification 1/10/1961. And the government order, as per the government order, the deputy commissioner was directed the Tahsildar to inspect the spot matter, and it was found that the high power tension wire is passing across the road. So the purpose for which the land was acquired for playground matter. So it is not feasible. Therefore, the Tahsildar has recommended.
What happened to that recommendation?
The recommendation was taken into consideration by the deputy commissioner.
Any order is passed?
Thereafter, my lord, it was ordered to take 1/3 of the acquired land, my lord. And thereafter, the matter was, the acquisition was challenged by the predecessor of the petitioners before this honorable court. In WP number 22,290 of 87, which was dismissed on 27/6/88, my lord. And against which appeal was filed and 1302 of 88. That was also dismissed, my lord. That was challenged on the ground that, my lord, though no award was passed. And thereafter, my lord, the petitioner has also, one of the petitioner has filed WP number 10180 of 2007 before this honorable court, annexure F, my lord, page number 20. There, this honorable court has observed, my lord, page number 21, my lord, saying that the learned counsel for the petitioner seeks leave of the court to withdraw the writ petition with liberty to approach the court if they are not successful in getting the compensation from the civil court. 21. Thereafter, my lord, meanwhile, my lord, the new act of 2013, it came into force, my lord. Thereafter, the present petition is filed on the ground that the possession of the land is not taken and the compensation is also not paid. Therefore, the entire acquisition in respect of the properties in which possession was not taken is lapsed. And I am relying upon the judgment of the Honorable Supreme Court, my lord, where the possession and the compensation is not, both are not complied. Then the entire acquisition initiated under the provisions of 94 Act will lapse.
Kodi. 1894 Act. ಆಮೇಲೆ.
So on that ground, my lord, the present petition is filed. That.
Yes, sir. Who is the contesting respondent?
Respondent number 5, my lord. It's a hostel, prematic hostel in the name of Dalit. I was impleaded in this case.
All right.
I filed my statement of objection. If I may request your lordship to kindly see annexure R5 to the statement.
That you have filed.
Yes.
Annexure R?
R5, page number 19. That is the previous round of.
ಸರ್ವೆ ಮಾಡಕ್ ಹೇಳಿದ್ರು.
Survey ಮಾಡಕ್ಕೂ ಹೇಳಿದ್ರು. ಇದರಲ್ಲಿ, if I may read this paragraph number 2 at page number 21. The records reveal that the petition, before I start, the total extent is 2 acres 8 guntas. Out of 2 acres 8 guntas, 1 acre 18 gunta was acquired in my favor. And the possession was handed over to me in the year 1981. So I'll just continue, my lord. I'll just. The records reveal that the petitioner's property bearing survey number 36/1 of Irangere village, Kasba Hubli, Mysore Taluk, extent of 1 acre 18 gunta was acquired out of the total extent of 2 acre 8 guntas. The preliminary notification was issued on 13/3/1961 and the final notification was issued on 31/10/1961. Thereafter, the possession was taken and the same is handed over to the beneficiary, that is me, respondent number 3, on 20th March 1981. Long after the said period, the petitioners have questioned the land acquisition notification by filing writ petition number 22290 of 87. The same came to be dismissed on 26/6/1988. The petitioner filed writ appeal number 1302 of 1988, questioning the orders dated 26/6/1988, passed by the learned single judge. The writ appeal also came to be dismissed on 3/10/1988. Thus, it is clear that the acquisition in so far as 1 acre 18 guntas by the respondent 1 and 2 has attained finality. That is in favor of me. This is a case where award has been passed, compensation has also been tendered. I will, if your lordship may permit, I'll just produce the copy. So this was acquired for the purpose of playground. So we are in possession of this acquired land for almost 44 years now. They have also challenged the revenue entries and before the AC and deputy commissioner, and the same also has been dismissed. And the petitioners are the great grandchildren. It is not even acquired from Sanjeevaya, which they claim in this writ petition. It was acquired from Mr. Sanjeev Nayaka. But what has happened, my lord? I'm running a hostel since 1954. It is situated in 2 different survey numbers. The building is very old, so I'm aided by social welfare department. We have started renovation work. When the renovation work has started, we have opened up one area of the land called in question before your lordship for the trucks and the construction material to come in. Since then, more particularly, petition number 3 and 4 have been creating nuisance. With respect to the same, there have been multiple criminal cases registered.
Charge sheet is filed.
Charge sheets also have been filed. But in this case, I was impleaded. I was not. There was some delay from the management to file wakalat. I filed my NOC wakalat also. on this ground, I think they have misrepresented the true facts before this honorable court, caused for an interim order. And thereafter, what has happened? Now they have a monetary demand. I am unable to, now my academic year has commenced. The construction is stalled. I am dependent on government funds. And all of a sudden, after 44 years, somebody comes and does this.
Yes, Vivekanand.
That's,
Adella correct, ah?
But the facts are correct. Let's see.
Hmm.
In fact, the petitioner has not spelled out the earlier proceedings before this honorable court where the challenge to the acquisition has been negated. And this, in the subsequent writ petition, the direction was to conduct the survey and identify the land which according to the petitioner is in his possession. But the survey was conducted pursuant to lordship's direction. That survey report is at page 32 of the statement of objection filed by my learned.
Justice Mohan Shantan Gowda order.
Pursuant to that order.
Adralli page 32 is the report.
Survey report.
There's a type copy.
Yes.
Kindly see the report. The first serial number 1 is 36/1. Link raste adu hogiruvodu 6 gunte. 36/1 ಜಮೀನು ಸ್ಥಿತಿಯಂತೆ ಕುಲ್ಲ ಇರುವ ಪ್ರದೇಶ 1 acre 12 ಗುಂಟೆ. ದಟ್ ಈಸ್ ದಲಿತ ವಿದ್ಯಾರ್ಥಿ ನಿಲಯಕ್ಕೆ 1 acre 18 ಗುಂಟೆ ಭೂಸ್ವಾಧೀನವಾಗಿರುವ ಪೈಕಿ 6 ಗುಂಟೆ ಲಿಂಕ್ ರಸ್ತೆಗೆ ಹೋಗಿರುತ್ತದೆ. ಹೈ ಟೆನ್ಷನ್ ಲೈನ್ 8 ಗುಂಟೆ ಪ್ರದೇಶದಲ್ಲಿ ಅದು ಹೋಗಿರುತ್ತದೆ. ನೆಕ್ಸ್ಟ್ ರಿಟರ್ಜಿದಾರರು ಬೇರೆಯವರಿಗೆ ಸರ್ವೆ ನಂಬರ್ 37/2 ಎಂದು ಕ್ರಯ ಮಾಡಿ ಕ್ರಯದಾರರಿಗೆ ಸರ್ವೆ ನಂಬರ್ 36/1 ಅನಧಿಕೃತವಾಗಿ ಸ್ವಾಧೀನಕ್ಕೆ ಕೊಟ್ಟಿರುವುದು. ಈ ಜಮೀನಿನಲ್ಲಿ ಮೂಡಕ್ಕೆ 19 ಗುಂಟೆ ಭೂಸ್ವಾಧೀನವಾಗಿತ್ತು. ಉಳಿಕೆ 9 ಗುಂಟೆ ಖರಾಬು ಬಿಟ್ಟು ಮಾತ್ರ ರಿಟರ್ಜಿದಾರರಿಗೆ ಸೇರಬೇಕಾಗಿದ್ದು ಇವರು ಈ ಸರ್ವೆ ನಂಬರ್ನಲ್ಲಿ ಹೆಚ್ಚುವರಿಯಾಗಿ ಸರ್ವೆ ನಂಬರ್ 37/2 ಮತ್ತು 36/1 ಕ್ರಯ ಮಾಡಿ ಅನಧಿಕೃತವಾಗಿ ಸರ್ವೆ ನಂಬರ್ 36/1 ಸ್ವಾಧೀನಕ್ಕೆ ಕೊಟ್ಟಿರುತ್ತಾರೆ. ಈ ಪೈಕಿ 3 ಗುಂಟೆ ಎಟೆನ್ಷನ್ ಲೈನ್ ಹಾದು ಹೋಗಿದೆ ಮತ್ತು 1905 ಚದರ ಅಡಿಯಲ್ಲಿ ಹಳೆ ಹೆಂಚಿನ ಮನೆ ಮತ್ತು ಪಂಪ್ ಸೆಟ್ ಇರುತ್ತದೆ. As per this report, the petitioner does not hold any property in that survey number. And moreover, stating that survey number 36/1, that he has conveyed 37/2, about 36 guntas. The purchaser has constructed a commercial building in a land belongs to the Urban Development Authority. That we have initiated proceedings challenging that the purchaser has filed another writ petition before this one. Therefore, the petitioner do not have any locus to approach this honorable court. And
anything else, sir?
Yes.
Richard. Interim order subsisting will continue to the disposal of the petition.
Also filed counter.
Yes, I've seen. Yes. Heard LR the Hesra.
Please.
Next.
I have a submission. Filed NOC Wakalat in the name of V.S. Sanjay.
Ilva illi?
Illa. Srinivas DC name to be deleted.
And print the name of?
V.S. Sanjay.
Registry to delete the name of Srinivas DC as appearing for the 5th respondent and print the name of?
V.S. Sanjay.
V.S. Sanjay, yes. Next.
P1.
My lord, I had filed an amendment application.
Week's time. Amendment ಏನು?
ಅದರಲ್ಲಿ ಒಂದು additional prayer ಹಾಕಿದ್ದೇನೆ ಅಷ್ಟೇ. ಅದರಲ್ಲಿ ಏನಾಗಿದೆ 78 ಅಲ್ಲಿ acquisition ಮಾಡಿರ್ತಾರೆ.
IA 1 of 2025 to be heard along with the main matter.
If it is that only prayer that I have sought.
ಪರವಾಗಿಲ್ಲ, we'll hear it. ಅವಾಗ ಬೇಕು ಅಂದ್ರೆ ಅಲ್ಲೇ permit ಮಾಡ್ತೇನೆ. Yes.
P2.
Early hearing.
The pleadings are ready, merits on merits.
Where is the early hearing if rule is not issued?
No, early hearing not being pressed. That is not being pressed. On merits, my lord, acquisition being questioned on 3 grounds. 10th February.
What is the 2023 matter?
10th February, my lord, this court had passed an order directing KIDB to disclose place on certain information on record. Not yet complied.
Yes.
10th
I
February.
received, my lord, only direction, my lord, to secure the record and the layout map. Both are with me only, my lord.
All right.
Date may be fixed so that final disposal.
No, basically 3 grounds.
Not in this stage.
Very.
Heard the learned senior counsel Dhananjay Joshi appearing for the petitioner. The learned senior counsel submits that the issue lies in a narrow compass. Due to paucity of time, list this matter on 26th.
Grateful.
Afternoon, there is one matter remitted from the
Well,
Supreme
and
Court.
then there is-
Apex Court has directed disposal immediately.
Sir, 26th, my lord, any other day.
Okay.
Or some other.
Records ಇದೆಯಲ್ಲ?
I'll record them, my personal.
24th.
Please.
Grateful.
Yes.
P3.
Early hearing.
1969 preliminary notification.
ಅದಕ್ಕೆ early hearing ಹಾಕ್ಬೇಕು ಅಂತನಾ?
ಅಲ್ಲ, 75 ವರ್ಷ ಆಯ್ತು ಅದಕ್ಕೋಸ್ಕರ.
ಆಯ್ತು. List the matter on 24th. 1969.
69. 2019, Facts 11 are entirely guntas different, ಗೆ my lord. Your lordship may give the date, my lord. that time.
26th ಅವರೇನೋ ಇರಲ್ಲ ಅಂದ್ರು. We'll take it on first,
ಆಗ್ಬೋದು.
list on first and preliminary hearing.
Please.
ಅದು 69 notification ಅಂತ ಇಲ್ಲ 23 matter ಅದು. Yes, Jagdish. Silent. ತುಂಬಾ silence.
Just telling him before he becomes violent, I have to seek time because.
That's 399 402 invoked when I'm in
ಅಲ್ಲ
the very same
interim order ಕೊಟ್ಟಿದ್ದೇನಿಲ್ಲ.
Lord, there is an interim order saying.
ಅಲ್ಲ
charge
ನಿಮ್
limit.
police station ಲೇ ಇರ್ಬೇಕಾರೆ ಎಲ್ಲಿಂದ 399 402? He was arrested and in your custody. How can he go elsewhere and commit dacoity?
Lighter note, my lords, I was just explaining to Jagdish sir. My lord, this is a person. Even if he wants to reform, the system does not permit him to reform.
Correct, yes.
And there is another instance, my lord, that it is not one case that has been foisted against him. 13 cases of false implication. 13 cases, all set aside by this honorable court.
One of which latest I have done.
Silent ಆಗಿದ್ದಾರಲ್ಲ ಅದಕ್ಕೆ ಕೇಸ್ ಹಾಕ್ತೀವಿ. Violent ಆಗಿದ್ರೆ
We have to become against the state now. Time ಬೇಕಾ?
ಅದನ್ನ ಇವತ್ತು ಫೈಲ್ ಇರ್ಲಿಲ್ಲ ಇವ್ರು ಕೊಟ್ರು ಅಂತ ಈಗ
Next week, ಯಾವತ್ತು ನೀವು ಫ್ರೀ?
ನೆಕ್ಸ್ಟ್ ವೀಕ್.
Next Tuesday ಹಾಕ್ಲಾ?
Lord, probably that one ground which I had urged on last day, 24
That
one will
competent
not apply
person, that-
because the person who has granted the permission is someone of an IG rank.
Then
So that will not
Tolerable.
survive.
But the other two grounds, my lord, which
we'll
are
see, don't worry, I'll hear
already
you.
covered by your lordship's
Yes.
order, my lords.
List the matter on 24th at the request of the 24th ಸಾಕು.
But preliminary hearing probably.
ಅದು ಅಡ್ಮಿಷನ್ ಬರ್ಬೇಕು. ಅಡ್ಮಿಷನ್ ಏನಿದು?
Hearing on IA.
Why interlocutory?
My lord, because the order of your lordships is not produced by the earlier council on record.
ಅಲ್ಲ ಅವಾಗ
All applications will be heard along, ಇಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ. All applications will be heard along with the main matter. Post the matter on for preliminary hearing.
ಅಲ್ಲ ಅವಾಗ ತಮ್ಮಂದ ರೀಚ್ ಆಗ್ತಿರ್ಲಿಲ್ಲ ಅಂತ ಅಯ್ಯ ಹಾಕಿದ್ದಾರೆ.
Obliged.
Yes, yes. 55.
Extension. Today is the last day.
ಯಾರು ಕೊಟ್ಟಿದ್ ಪರೋಲ್?
ನೀವೇ.
My order.
Now pending before the honorable governor for approval.
ಓ ಇದು 20 years ಆಗಿದೆಯಾ?
14 years.
Recommendation is pending?
Now pending before the honorable governor. Last day.
ಒಂದು ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಪರೋಲ್ ಫಾರ್ಮ್ಯಾಟ್ ಇದೆ. ಚೇಂಬರ್ ಕೇಳಿಕೊಡ್ತಾರೆ. ಸೇಮ್ ಆರ್ಡರ್ ಮಾಡ್ಬಿಡಿ. Another 90 days because it is already recommended, sir. Yes. Nitin sir.
Lord, this honorable court, while an interim order has given protection against encashment of the bank guarantee in the same matter. In a peculiar circumstance, because this is one of those government projects where 70% of the money is put by the government and 30% is contributed by myself, that is the service provider. Considering this fact, this honorable court said this is one of those peculiar cases where though normally we will not interfere or interdict bank guarantee being encashed by the government, here we intend to do that. Now, what happens, annexure A may be taken. A reference is made to the same impugned communication which was stated by this honorable court. Kindly see annexure A, page 15. The seriatim 3, my lord, serial number 3 after the subject. In that communication, this
moment.
office letter so and so dated 15/6/2023. The lordship sees 15/6. Kindly now come to the interim order at page
74,
74.
15/6/23 you find in the last line.
Yes.
Yes.
Same thing is referred again and says for others also similar projects, you do the encashment of the bank guarantee. Another fact, my lords, I must point it out.
Where is the impugned order now?
Impugned order is at page 70.
Forfeiting bank guarantee.
That is
What is the
annexure A,
office
annexure A.
letter is 15/6/23.
Yes, my lord.
Even that has
That has been
number
stayed.
3. Hello, 1 minute. Bank 36 centers reference.
And one more aspect, it clearly says that this is an issue for arbitration. We have been asking for arbitration. The agreement itself talks out of it. Entire thing
That will
arises from.
answer in the
Now
final
they
order.
cannot.
Now that petition is pending.
No, my lords, arbitration
Disposed.
petition, it is still in the communication saying appoint an arbitrator, so on and so forth.
ಅಲ್ಲ ಈ writ petition pending ಇದೆಯಾ?
Pending. This very petition is pending. While it is pending.
ಅಲ್ಲಿ you are appearing there also.
Please.
Shall we tag it with that
Please,
and
please.
pass out?
Please. Same interim
ನೀವು
order.
ಸುಮ್ಮನೆ ಇರಲ್ಲ ಇಲ್ದರೆ.
They
ಇನ್ನೊಂದು
have
order
violated,
ಮಾಡ್ತೀರಾ?
my lord.
What violated, sir?
They have not established.
15/6/2023 order stay ಆಗಿದೆಯೋ ಇಲ್ವೋ? How do you refer to that and pass another order of the same kind?
That reference has to not be.
Then
Some other letter has to be
he
sent.
heard the learned counsel, Shri Nitin Ramesh, appearing for the petitioner. A coordinate bench of this court
My lord, instead of that.
on
other tag may be-
3rd July 2023 had passed the following order, page 74, madam. ಅಲ್ಲೊಂದು note ಇದೆ, ಆ note ನು extract ಮಾಡಬೇಕು. The note appended to the order, appended ಅಲ್ಲ, as a postscript, the note is mentioned in the order. The note clearly indicates that what is stayed is all further proceedings pursuant to a communication dated 15/6/2023. 2 years pass by. Springs the same communication again in the impugned order dated 24/4/2025. Basing the order on the same communication which is already stayed, now an amount, now the bank guarantee is sought to be, bank guarantee ಅಲ್ಲ ಅದು?
ಹೌದು, forfeited.
The bank guarantee is sought to be forfeited. Tag the petition along with a number tag, along with so and so, there shall be an interim order of stay as spread for till the next date of hearing. ಅದು ಹೌದು ಅಲ್ಲೇ ಇಲ್ಲಿಗೆ ಬರುತ್ತೆ because disabled ಅಂತ. There also you are appearing. Yes. So, yes.
Great.
ಇಲ್ಲರೆ ಎರಡು ಅಲ್ಲಿಗೆ ಹೋಗುತ್ತೆ ಅದಕ್ಕೆ. ಅಲ್ಲಿ ಡಿಸೇಬಲ್ ಆಗಿರೋದು ಇಲ್ಲೇ ಬರುತ್ತೆ. List on, we'll fix a date. Yes, Spurti.
24th itself.
ನೀವು ಪೂರ್ತಿ ರೆಡಿ ಆಗೋದು ಯಾವಾಗ ಹೇಳಿ ಮೇಡಮ್?
My lord, here, 24th itself.
24th, all right.
24th or 27th.
24th ಬೇಡ, we'll have it on 27th.
27.
List on
First, my
27th.
lord, first.
ಯಾಕೆ 27th ಇರಲ್ವಾ?
Like,
27th,
21st.
yes.
B group part is 57. 57.
ಮೇಡಮ್ ಬಿ ಗ್ರೂಪ್ ಎಲ್ಲ ವಿಲ್ ಟೇಕ್ ಇಟ್ ಆನ್ ಸುರೇಂದ್ರ ಅವರೇ, ಮಧ್ಯಾಹ್ನ ಒಂದು ಪಾರ್ಟ್ ಹೇಳಿದೆ ವಿಚ್ ಹ್ಯಾವ್ ಟು ಕಂಪ್ಲೀಟ್ ಪರ್ಸೂಯೆಂಟ್ ಟು ದ ಡೈರೆಕ್ಷನ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್.
Yes.
ಸೊ ವಿಲ್ ಅಂಡ್ 4 o'clock ರೆಫರೆನ್ಸ್ ಇದೆ. ಬಿ ಗ್ರೂಪ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಗಿವ್ ಅ ಡೇಟ್ ಸರ್.
66 big row.
ಆಲ್.
But in that, the appeal is allowed.
Huh?
The writ appeal was dismissed.
Huh.
The WP was allowed quashing the
Which
acquisition.
serial number?
66, my lord.
This can be disposed on that ground.
No, my lord, there is one, when there is an interim order, possession was only to that
Dates ಮಾಡಿ
extent.
1 minute. Dates ಇದು ಮಾಡಿಲ್ವಾ? 24th. ಅದೇ ಏನು ಜಾಸ್ತಿ ಇಲ್ಲಲ್ಲ. We'll have it on 24th, next week.
Please, please.
And 24th and 26th we will divide 2 days, big group matters.
Serial number 65.
ಅವ್ರು ಹೇಳ್ತಾ ಇದಾರಲ್ಲ.
I appear for petition.
ಅದ್ರಲ್ಲೇನಾ?
I appear for
yes.
petitioner. Kindly have it on 23rd of this month.
20 ಅಲ್ಲ, 24th.
26th.
24th or 26th, 2 days.
26th. It may be have it on
26th.
26th.
Wait.
26th.
Acquisition of 1970, I'm an option purchaser from BDA.
ಆಯ್ತು, 26th we'll close it.
26th, kindly have it on 26th.
List on 26th.
And the interim order
65.
may be extended.
Interim order stands extended till the next date of hearing.
Obliged.
B group ಅಲ್ಲಿ ಇದೆಯಾ ಅದು? All right, yes.
Serial number 61.
24th or 26th, sir, don't make separate mention.
57 on 26th. Interim order to be extended.
What, however small the matter is, it is 24th or 26th, B group cases. Wait, I'll come to that, wait.
Serial number 61 is very small matter.
Maybe, madam. It is 24th or 26th,
My lords, the interim order to be extended in.
wherever is the interim order release the action, madam.
My lords, 57, my lords.
57 B group,
57 B group, 26, my lord, 24th, I'm not in.
24th or 26th?
26, my lord.
68, my lord, 26, serial number 68.
Yes. Which one, madam? ನನ್ನ ಏನ್ ಮೆನ್ಷನ್ ಮಾಡಿದಿರ ಕೊಡಿ ಇಲ್ಲಿ. You can't take orders misleading the court. You have filed IA 2 for 20 or 2 of 2025 seeking extension. IA, where is Sirajuddin? Get him. Don't take orders misleading the court. That IA is already rejected. That is withdrawn. IA is withdrawn. Justice Pandit Auru, it has rejected parole by a detailed order. You suppress all that and take an order of extension here? No, madam. Yes, pass over. I'll dismiss it with costs now. Next time parole sigbardu. No, whatever it is. You should, nothing doing. You approach the regular court and take parole. No extension in this because IA2 is already rejected. Nothing doing. IA2 is already rejected. Go before the same court which had granted you that parole. Yes, yes.
Serial number
Serial
59,
number
my lord.
67, my lord. Serial number 67, B group, my lord.
Ella 24th or 26th?
27th, my lord.
Yeah, there's
No,
a construction.
27th. 24th or 26th?
It's 24.
Emergency? GMCPC? ಏನು?
23 years, my lord. Amendment in appellate court, my lord.
ಸರ್ ಇದು ಏನು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಏನು ಹೇಳಿ
Jurisdiction ಬರಲ್ಲ.
ಈಗಲೇ
Jurisdiction ಇಲ್ಲ ಮಾಡಿ.
ಈಗಲೇ ಮಾಡಿ. Yes. 7, the learned counsel submits office objections would be complied in the course of the day. In the event they stand complied, list tomorrow. ಆಮೇಲೆ 3 ಏನು?
Amendment carry out ಮಾಡಿದ್ರೆ ಆಯ್ತು.
ಮಾಡಿ ಸರ್, ಈಗ ತಗೊಳಕ್ಕಾಗತ್ತಾ? ಎಸ್, ನಾಳೆ.
Serial number 3 ಅಲ್ಲಿ they have asked for the better copy of the award passed by the KTB, my lord. It is at page number 25.
3 office objections overruled. List the matter on Thursday in preliminary hearing. Others, 2 weeks time is granted to comply with the office objections. In the event they stand complied, list the matter on the ensuing Tuesday.
My lord, in one matter, slum clearance board matter is remitted back from the apex court. I am told, my lord, in one matter it is listed in other courts. But I think Chidananda has, it seems, argued the matter before your lordships. They made a statement.
Okay.
Same connected matter.
All right.
I am furnishing the memo. It may be listed. It can be taken as
ಅಲ್ಲ ಅಲ್ಲಿ ಕಳಿಸ್ಬೇಕಲ್ಲ ಇಲ್ಲಿಗೆ
land acquisition.
ಎಲ್ಲೇನಾ? ನಮ್ ಮೆಮೊ ಕೊಡಿ.
Slum clearance.
ಅದು ಗೊತ್ತಾಯ್ತು, ಮೆಮೊ ಕೊಡಿ. ಎಸ್, ಅಡ್ವೊಕೇಟ್ ಮೇಡಮ್, ಅದು ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ.
One submission, my lord. Serial number 58, my lord.
B group.
B group. My name is not shown.
ವಾಟ್ಸ್ 58 ಏನು?
58.
ಒಂದು ನಿಮಿಷ ತಾಳಿ, ಮುಗಿಸ್ತೀನಿ, ಮಧ್ಯದಲ್ಲಿ ಹೇಳ್ಬಿಡಿ.
Second time matters like 8 to 12.
Second time, 10 days time is finally granted to comply with the office objections. In the event they stand complied, same, list the matter on the ensuing Thursday.
Third time matters.
Same 1 week, failing which the petitions would be dismissed for non-prosecution. 4th and 5th time, same order. ಈಗ ಹೇಳಿ 58 ಏನದು?
I filed NOC wakalat, my lord. Vipin Hegde may be shown.
58 ಅಲ್ಲ?
58.
Petitioner ಈಗ?
Petitioners.
Registry to delete the name of BN Vinod Kumar and Shamant Nayak as appearing for the petitioners and print the name of Vipin Hegde.
Please, my lord.
Yes. ಅದಲ್ಲ ಮೇಡಮ್, ಇನ್ನು ಫೈನಲ್ ಹಿಯರಿಂಗ್ ವಿಲ್ ಸಿ ಲೇಟರ್. ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಅದೇ 24th or 26th ಹಾಕ್ಬಿಡಿ. ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಇರಲಿ ಅಲ್ಲ.
Court officer.
Camera on.
Court officer. Court officer. Court officer.
ಮೇಡಮ್ ಹೇಳಿ. ಮೇಡಮ್ ಬರ್ತಾ ಇಲ್ಲ, ಕೇಳಿಸ್ತಾ ಇದೆನಾ?
Court officer.
ಹೇಳಿ ಮೇಡಮ್.
HCGP ಗಿರಿಜಾ ಹಿರೇಮಠ್ ಧಾರವಾಡ ಬೆಂಚ್ ಮೇಡಮ್.
ಎಸ್ ಮ್ಯಾಮ್.
ಮೇಡಮ್ ಫಸ್ಟ್ ನಮ್ದೇ ತೋಡ್ಬಿಟ್ರಿ ಪ್ಲೀಸ್.
ಆಯ್ತು ಮ್ಯಾಮ್.
ಅದು ಫೈಲ್ ಕೊಡಿ. 230 ಧಾರವಾಡ.
Matters pertaining to Dharwad bench. Number 1, Sheikh Sipat.
Yes, yes, sir. Yes. So he should continue, is it? Yes. Yes, yes, sir. Yes, Nikhil sir, you will do it or? Yes. Anything, whatever you say, sir. Yes, I have heard. Yes, that is. It's here, sir. It's here. Both volumes 1 and 2. Yes. You can refresh and then Nikhil sir can start. Yes. Yes. Yes.
Yes, they procured, transported, and then exported certain quantity of iron ore without proper permission.
Yes, that's.
And then Millers, they zeroed in on, my lords may kindly remember that there was one other matter that
that kinetic.
Kineta Global, exactly the same, identical, except the changes
That
of the
I have reserved it.
change of that's been reserved by your lordships, Millets. It goes on the same lines, Millets. And I must say that it's a bit of a better footing as well, because the tenuous allegation, earlier it was quashed by your lordships, it went over, then it has come back on a technicality. That's how we are once again with your
Yes.
lordships, Millets. Then Millets, I was an exporter, and then more than 3 lakh tons of iron ore I exported. And then I did not face any sort of an allegation vis-a-vis most of it, Millets. And to draw a line between these two, part of it I mined in my own mines, and I had it, and there I got a clean sheet. And then Millets again, the remaining one, to an extent of say about 1.5 lakh tons, I again procured from others in the port, and I exported. There again, to an extent of about 1.2 lakh tons Millets, I did not have an allegation. About
Yes.
39 metric tons Millets, I faced an allegation. This is how we are before your lordships, Millets.
Yes.
The offense my lords have seen, and thereafterwards, Millets, when it comes to FIR, it was on 24/10/2013, my lords could see at page 33.
Yes.
Thereafterwards, Millets, there are 3 charge sheets. My lords could see them at 38,
Yes.
and that was dated 1st February 2022.
Yes.
My lords could see the time, that's 9 years later.
Yes.
So is the case with another one that's at 106,
Yes.
and eventually at 168.
Yes.
Millets, from 92 onwards, my lords, at 92, 158, 224, 228, 232, 236, they're all cognizance orders
Cognizance
for the sake of record.
Yes.
I've just bring to your lordships, my lords. Then, my lords, if your lordships come to the volume 2, I believe that's in the part of
Yes, it's
compilation.
Yes, yes,
My lords could see at page 240,
yes,
the purchase order. To be precise, my lords could come to page 241. 240 it begins, my lords, the purchase order.
yes,
Kindly come to 241.
yes,
My lords could see para 7.
yes,
Permits, valid DMG and forest permits to be furnished equal
Yes.
to the quantity of so and so supplied. It's
Yes.
the obligation cost on the supplier to me. This is where, my lords, it's been said. Then comes the next one. This is dated 3/11/2009. My lords may kindly turn to 244. That's
Yes.
24/12/2009.
yes,
That's condition incorporated at 245.
yes,
My lords could see, my lords.
yes,
Then comes 248. This is 28/12/2009.
yes.
That's again 249. My lords could see the condition.
I'm at the same, yes.
Yes, my lords. So these are the three supplies essentially that they say are the offending ones.
Yes,
Then my lords could come to page 250.
yes,
250, my lords.
Yes.
They are the invoices.
yes,
3/11/2009. My lords could see the whole thing.
yes.
Why I say that, my lords, the rate and other things, no cutting corners. It's clean and straight transaction
Yes,
as per the prevailing market rate and the practice. My lords could see the next one at 251. That is 29/12/2009,
yes,
corresponding to these invoices, my lords.
yes,
And then 252. That's at 18, on 18 March 2010,
Mm.
another one. Now, my lords may kindly see, we have also compiled the list of witnesses.
Where do I get that?
My lords, it begins to be at, my lords, see 281.
Yes,
My lords could see that one.
yes.
And actually, the testimonies begin at 307. 307.
Yes,
My lords could see CW1.
yes, yes,
Before my taking your lordship to them, my lords, kindly see the index of this volume. Volume 2, my lords could see the index.
yes,
And here, the index at page 307 could show. I wonder, well, let's say whether I'm
CW1. It's-
307.
Yes, on the
It
same
says
page.
document number 26.
Correct.
That's the testimony of CW6,
Yes,
CW1 rather,
Oh, CW1.
who is a geologist.
yes,
Now the next one my lords could see, he is additional director, DMG office,
that is CW2.
CW11.
11.
11 minutes. Only material witnesses were included.
All right.
CW12, that's director, DMG office. Then comes assistant commissioner, customs. Thereafter, inspector of customs at 353. Then comes again inspector of customs, 374, deputy conservator of ports, Karwar port. 379, this is deputy port conservator at Bellekeri port from where we have exported. Then comes Millets, 384, assisting the port office, Karwar, some officer. 399, I may stop here for a while, Millets, kindly
Yes.
come to 399. This is deputy port conservator, Bellekeri.
Yes.
May I request your lordships come to 399 Millets?
I'm there.
Here, 399 Millets. Your
CW,
lordships could see his testimony.
CW22. Yes,
CW22.
Mm.
Why I zeroed in on in this Millets? Here, he describes the procedure that's been adopted
yes,
by the port authorities, etc. That's why, Millets, I have come to this part. 399 Millets. May I just read, Millets?
yes. Yes, sir.
Yes, Millets. Instead, kindly come to page 399. apart from the first two paragraphs, my lords, the last bottom paragraph of 399.
For handling goods.
Yes, my lords.
Yes.
Here he speaks about the procedure. For handling the goods, Ballakeri Port land was leased to stevedores, Messrs. So-and-so, on long lease basis by the government of Karnataka. The stevedores have been registered as per the provisions of Rule 16(1) of the Karnataka Ports rules. They are responsible for receipt and stacking of iron ore and loading onto vessel for exports. After that export order is given by Superintendent Customs. As per agreement, the stevedore has to create the required infrastructure for handling the cargo and loading of the cargo. The said registered port operator, my lords, may kindly mark minutes.
Now, who is the port operator here?
That is Messrs. Adani's.
Measures?
Adani, just above I just read minutes. For handling the goods, Ballakeri
Yes.
Port was leased to stevedores,
Leased
Messrs.
to,
Adani
correct.
Export Private Limited.
Correct.
My lords, may kindly come here. Now I say, the said registered port operator, my lords got it? At page 400, they are responsible for receipt and stacking of iron ore and loading onto vessel for exports after export order is given by Superintendent Customs. As per agreement, the stevedores has to create the required infrastructure for handling the cargo and loading of cargo. Then comes their role. Page 400.
One clarification.
Yes, minutes.
Now, the allegation against you
Yes, minutes.
is you had no license or clearance certificate from the port authorities.
Minutes,
What is the direct allegation against you?
The only allegation against me is when the ore was transported into the port
Yes,
and there was no proper transport permission.
correct. That
Not
is-
with regard to the
that
port.
That is the onus of the port authority.
Yes.
Now, if you come to page 400,
Yes,
in
minutes.
the first paragraph, last 5 lines,
Yes, minutes.
that is, they are the first point of contact with the
Yes, minutes.
exporters.
Yes,
When iron ore was bought inside the port contact, further, the said port operators are liable to obtain the required permission, no objection, clearance, from the concerned for all activities as per applicable laws.
Yes, minutes.
So where do you figure in this?
I don't figure at all, unfortunately, Millet, that the whole gravamen of that and your lordships got by the scruff of it. And I have no role to play at all at any
So
stage.
if that is the allegation against you.
Yes, my
And
lords.
that allegation drives you nowhere because you have no role to play.
No role to
Even
play.
according to the deputy port conservator
Yes.
of Belkere Port, it is the onus of the port authorities to take all permissions
Yes.
from competent authorities. No, anyway. you
Much
continue.
worse is the
Yes.
position, Millets. To
Yes.
vindicate my stand, I write under RTI, saying that one, please provide all the documents and explain us the process, how you conduct yourself when it comes to the port, because I'm a bona fide purchaser
Yes.
at the port. And they reply, there has been an investigation going on. We are not going to give you any information.
As you said, you purchase it from the port.
Yes.
How it has come, it's port authorities.
Yes, Millets.
Port authority, how it has stacked the iron ore in its port.
Yes, Millets.
And it is the onus, even according to the conservator, is on the port authority.
Port authorities, Millets. And none of them has been made an accused.
These are not accused.
They are not accused at all.
Public servants are not accused.
No. And Millets, last time, my lords may kindly recollect, I've read one statement from the charge sheet saying that one, it is always usual for the officials to be negligent. May I just take your lordships to
Yes.
page 78?
Yes.
Quite a classic statement it is.
Yes, yes, sir.
Let me come to that, Millets. Kindly see Millets 15.45. Page 78.
Yes, yes. I have marked it, yes.
Millets, during the investigation, the role of public servant was not surfaced in the criminal act. The lapses on the part of public servants are of common in nature and used to be looked into ground reality. Worth its weight in gold.
Now, when there is a statement saying public servants negligence, you
Yes.
should ignore, then a person who has nothing to do will be hauled up into these proceedings.
Millets, to impress your lordships, we thought that we should argue at least 2 days, Millets. But the problem is, what is that we should argue?
No, this-
When I have
this is-
nothing against me. If there is something I need to point out and I have to explain, look, I'm innocent to your lordships. But that can't be here.
Right,
I have
these-
no role to play.
This-
And they don't allege. They say, in a what they call omnibus manner, I should have conspired with those people who had the license and who transported,
Where
who
is-
stacked in their stores
Where
and
is-
given it to me.
Where is the evidence for that?
Absolutely
Where
no.
is, where are the statements?
And
for
that's
that?
why Millets, I've annexed all the
That
statements
is
of
why
the
when
officers
when
concerned.
they bring in 120B here
Yes.
as an allegation,
Yes,
where is the meeting of minds? Who
no
has
meeting of
conspired?
minds.
Who has conspired? And anyway, they will have to answer all that.
Yes. Millets, once it has come into port, after all checks and balances, that enjoys the presumption
Yes.
in terms of section 114 of the old Evidence
Evidence
Act,
Act.
that it has passed through all these checks and balances and it has reached. There we purchased from those suppliers. And
Is it the duty of the purchaser from the port to go back to history and see the origin of this ore?
yes,
How did it emerge? Who transported it? How did it come to this port? How is it stacked? Is that you do due diligence by seeing all the history of the
going
iron-
back to the days of mine and all those things, I have to.
No,
Millets, that's
if-
what I said,
If
Millets.
what they say is accepted prima facie,
Yes, Millets.
it looks like where did you mine it?
Yes.
How did you get it?
Yes.
And all that a purchaser should see and then purchase it.
Inevitably, I may have to fall on my previous arguments, Millets. There
In
I've
that-
also
yes.
cited when it comes to Sony TV, that they
Yes, exactly.
manufacture in excess of the limit that's been given. And then that's been sold in the market and I purchased that one. Could I be accused of, under anti-competition law, that I purchased and I conspired with him so that he could produce more and give it to me?
We'll see.
Such far-fetched thing. And Millets, it's not the case of even a tortious liability to say that I've been negligent in my manner. It's per se criminal liability where my lords have rightly pointed out that there should be meeting of minds to fix me and to crucify me on the anvil of
If
120B.
they want to bring in 379 and 120B, which is
Yes.
the allegation against you.
Yes, Millets.
The allegation is thieving under 379 is for the purpose that you don't have the purchaser from whom you have, the seller from whom you have purchased does not have a valid license, permit, a permission,
Yes.
or whatever it is. So that is 371, you have taken the stolen property. That's the allegation. Yes. Wait.
Millets,
We'll get
that's a
back.
good
Yes.
point my friend has raised, Millets. Let me talk about this caveat emptor, Millets.
Yes.
Millets, when in the Middle Ages, the contract law got a shape,
Yes.
beginning from mid 1700s. Then, Millets, it's been in the grip of industrial revolution. Everything had been produced in abundance. It's been dumped on the people. Then the theory of laissez-faire has come into existence.
Yes.
The least governmental interference.
Interference.
So
That is
once there is
laissez-faire.
least governmental interference, that laissez-faire has led to the doctrine of caveat emptor. Saying that one, buyer beware, because we have given up. We are not going to regulate the whole thing. It is between you and them. If you want to buy, you buy that one. That caveat emptor later with the regulatory regime has been diluted and has been done away with. It's only for the textbook sake.
That's
we
all.
say
It's
that
it's
caveat
only in the
emptor.
books now.
Yes. Otherwise, there's no question of specific relief act. There's no question of section 19 of specific relief act saying that I am a bona fide purchaser. Then even the contract which has been existing earlier could not bind me. If caveat emptor is to be accepted, it's a common law doctrine which has given way to statute. Once statute is in place, it has nothing. It's only a maxim in Broom's Law Dictionary.
No.
And
Yes.
that's why, Millets, my humble submission to your lordship says, what criminality can be attributed to me? And it cannot be by way of far-fetched imagination that if there had to be some crime, it has to have its ripple. And Millets, that great doctrine of ripple effect. Should I ask my colleague just to clarify the
yes.
role of the company as well,
Yes,
Millets?
sir, yes.
Once they argue, we may get a chance just to
That's
throw
true,
light, more
but,
light on it.
he will not be doing it today, I guess. Yes.
One more.
Me too. First of all, very obliged for accommodating us today. I was not, there was some lag on the last time I.
The technical lag. Yes. Technical glitches are there in this. So like how it is in the case, sometimes
Lord,
there
in also. this case, there's more than technical. If I can, Lord.
Yes, sir.
Lords, 2 or 3 additional facts from the charge sheet, Lord, I want to point out.
Yes.
I will not repeat anything which Mr. Naidu has already informed your Lordship.
Yes.
Lords, this FIR, Lords, was registered, number 1, Lords, pursuant to a Supreme Court order, if your Lordship
Correct.
recalls. Lords. If your lordship sees that Supreme Court order, may not turn to it, I'll just give the page number. In the
Yes.
convenience compilation, it's at page 7.
Yes, it's page 7.
Lords, the check period, so as to say, Lords, as they say in a DE case, was 2009 and 10.
Yes.
And my lord, CBI had conducted a preliminary inquiry. Preliminary inquiry showed a particular state of affairs.
Yes.
And that state of affairs was allowed to be converted into an FIR under the order. Now, if your lordship sees the FIR from that perspective, my lords, at page 36, that's the first additional fact, my lords, I want to give, my lords,
Yes.
of volume 1.
Yes.
So after doing a preliminary inquiry for a year and a half, my lords, third paragraph,
Yes.
at page 36,
Yes.
MSPL represented by its directors A2 to A6. A5 is the one who has passed away. my lords.
Yes. So A2 to A5 is passed. Yes.
Illegally excavated iron ore in excess from the mine lease to them, illegally procured. So this is the first allegation. So I did illegal mining in my own field. That's the first allegation. Illegally procured from various suppliers. That's the second allegation. Exported 3,135,000 metric tons. So this is during that check period. And just come 2 lines below. Trespassing on the forest area, government land, procuring illegally excavated iron ore, receiving the stolen property. Please mark this 195,085. So this much inquiry, my lords, was already done as of 24th October 2013 and prior thereto, because Supreme Court order is prior thereto.
Yes.
In, my lords, about a decade which followed thereafter, which led to investigation in which I have no role to delay, my lords, and there is no allegation that I have delayed. Because delay will be one factor which I will be pressing, my lords. All they have done is that this 195 has reduced to 90,000, which is a simple arithmetic calculation by checking whether somebody had mineral dispatch permits or not. That's a solitary allegation.
Yes.
So in that solitary allegation, to decide whether this 195 was backed by proper mineral dispatch permits, it has taken them 10 years. Now, my lords, in the charge sheet, as it stands, my lords, from page 38,
Yes.
the lordship will find that one director has passed away, one is 85, one is 90 years old. That your lordship will get at
Yes,
page 40 and page 43 respectively, other than the one who has passed away.
Yes.
And again, if your lordship sees, my lords, paragraph 15.3 at page 58, they say that we again investigated whether the company itself did illegal excavation.
Yes.
Correct, my lords?
Yes, yes.
No.
57, 58.
Yes. Now, page 60, my lords, these are the 2 shipments which they ultimately found to be illegal. Of the 6 shipments we sent, my lords.
Yes.
Number 3 and number 4, Thai Honesty and Direct Spirit.
Yes.
Your lordship will see the quantity exported and just note it, keep it at the side, my lords. 53,000 and 50,000.
Huh. Yes.
Right. Now, my lords, why did they let off everybody else other than, my lords, those who sold to me? The first answer is in 15.9.
Yes.
Investigation revealed that based on the application submitted by MSPL, the Deputy Director, Department of Mines and Geology, issued mineral dispatch permits number so and so for transportation of so and so lumps, respectively, from mining lease, this is my own lease, my lords, to Belekari Port on payment of royalty. And so, moment they found that the mineral dispatch permits were verified by the Deputy Director, I was let off for the quantity which I extracted from my own leased mine and sent to the port. Similarly, my lords, your lordships will find that others have been let off because they were able to show that their mineral dispatch permits were verified. That's the only. Now, my lords, the third fact, my lords, additionally, which your lordships may permit me to place, is to be found in para 15.14.
Yes.
This is my contract, my lord. So we are A1 to A6. A1 is the company, 2 to 6 are directors, my lords.
Yes.
7 and 8, my lords, are a set of accused called Amalagiris, who is one of the suppliers.
Correct.
So just see 14. Investigation revealed that A1 placed purchase orders to A8, represented by A7, with a letter number so and so. So there are 2 purchase orders of 1 lakh and 1 lakh and 50,000 metric ton. So total of 1,50,000 metric ton is under a written contract. I receive 108. I export 108. The allegation out of 108 is 25,000. You know, I put all this in a one page chart if I can be.
Yes, yes, that's better. I'll put up through it.
Just give a copy. So, this is my entire supply. In the first column, your lordship will find this is the supply which came from my own mine. Correct, my lords? Now, please see second column. Second
So
column.
allegation is you've illegally mined in your own mine.
That was the allegation which they dropped by
Yes,
the time
yes.
charge sheet
So
was
initially
filed.
it began like that.
That's correct. That's
Yes.
correct. Which is why, my lords, I put these paragraph numbers that why it was dropped. The paragraphs in the bracket are paragraphs of the charge sheet.
Yes.
Now, please see the second column. That's the most important column. About 10,000 metric ton is supplied by one Raj Mahal Silks.
Yes.
3,502 is treated to be legal,
Legal.
because MDPs were verified.
Yes.
6,493 treated to be illegal because
MDP was not verified.
separate FIR registered. I am not an accused.
All right. Then second supply.
Supplied from Deccan
Mining.
Mining Syndicate found to be legal.
Legal, yes.
Now third becomes interesting. Lord, of the 1,50,000 metric ton contracted with Amalagiris under
Yes.
two contracts,
Yes.
1,08,643 were supplied,
Yes.
exported in two different shipments, third shipment and fifth shipment.
Hmm.
Third is illegal, part of third is illegal,
Hmm.
and fifth is legal.
Yes.
From the same supplier.
Same.
Look, this is in context of my duty to investigate.
Yes.
So if I'm supplied with a set of papers which says that they have a mineral dispatch permit, and port authorities independently are obliged and they independently verify it, for a part of a contractual obligation, my lords, as a purchaser, I can't be held criminally liable. This is the first proposition which Mr. Naidu argued. I'm only paraphrasing it in this manner, my lords. So therefore, third supply, my lords, part of the third supply held to be illegal because part of the NDPs could not be verified. And your lordship will find the quantity is 27,186. Even in DA cases, my lord, less than 10%, my lords, are not treated as a
Accused.
accused. In the fourth shipment, incidentally, my lords, I supplied about 50 odd thousand, which is 26 legal, 27 illegal, subject matter of some other RC. I'm not an accused. So from the same supplier.
So partial supply is legal, partial supply illegal.
Illegal. And for the partial illegal supply, I am not an accused. For the partial illegal supply, I am an accused.
Legal supply are accused.
No, my lord.
No,
The allegation is. I'm
that
sorry.
allegation.
The allegation. I'm saying for the allegation of partial illegal supply, I am not an accused in some other FIR.
That is what, yes.
And for the partial illegal allegation of supply, I am an accused in this.
Yes.
Now, my lords, this doesn't end here because Amalagiris don't, my lord, say that they actually extracted the iron ore and they gave it to me. They further say that they brought it from Samruddhi Enterprise. They have an independent contract with Samruddhi Enterprise. Adarsh Associates. Please see Shivani Associates. There's a third bullet, my lords. This Shivani Associate has also purchased it from two other people. To what extent will I go back, my lords?
That is exactly what I asked. Now this, they have purchased it from two other people.
Yes.
Who are alleged to have no permits to sell.
Correct.
Yes.
And they gave it to Shivani. Shivani gives it to Amalagiris. Amalagiris give it to me.
So there are four hands changed
Yes.
there. So you should go back to the first hand.
Correct. So, and all this is in their charge sheet, Lord. I'm not saying a single fact, Lord, which is not a part of the charge sheet. And Lord, then I receive it and handle at the cargo port, Lord, which Mr.
Yes, that is
Naidu read out.
That from the port authority there.
Correct.
Yes.
So, Lord, this is how, my lords, factually the disputed, my lord, so-called mineral has come to me.
Yes.
The last fact, my lord, which I want to additionally point out from the charge sheet is that if your lordship turns to 15.18 at 65.
Yes.
And Lord, these are supplies which I receive under a written contract.
Yes.
It is not the case in the charge sheet that the contract is sham. not the case in charge sheet, that I have a relation which is other than a contractual relationship with either Amalagiri or Priyanka. It's a contract at arm's length. And my lords, more importantly, I have paid full market price in through banking channel. Where is the question of theft? Please see 15.18. Investigation revealed that Amalagiri raised final invoice number so and so for 16 crores 8,69,000 against contract number so and so for after the export of so and so through vessel Thai Honesty. MSPL made first installment of advance payment of 19.20 crores so and so to the bank account of Amalagiri maintained at DCB Bank, Goa through their current account. Absolutely no allegation that the money transferred has come back. There's a separate relationship. The contract is sham. Moment, my lords, I purchase a good and money goes out of my pocket. That's the end of the matter insofar as I'm concerned.
So the allegation perhaps is in 15.21.
Yes, I will come. 15.21 minutes. Investigation revealed that Raj Mahal Silk, one more supplier, has raised invoice dated so and so in favor of so.
Insofar as that supplier is.
Yes. And I took from 13 suppliers.
Yes, that's what.
15.22 says I took from 13 suppliers. There's a table appended to 15.22. Lord, I'm so obliged since your lordship pointed out, lords. Out of about 300,000 or 3 lakh metric ton, lords, this is about 12% or 13% of allegation. The lordships have already seen those 7 cases in 15.24 where I'm not a.
Yes.
Now the last thing, lords, is 15.42. After the entire charge sheet is drawn up, my lords, at page 77.
Yes.
This is the first time I come in.
Yes.
Simply by adding a line that I connived. Absolutely no material to support it in the charge sheet or in the statements. It's impossible to show the negative. My learned friend on the other side may be able to show it.
Yes.
But 15.42 is what I want to place. Investigation revealed that A7, managing partner of A8, with the criminal intention to cheat government of Karnataka, conspired with other accused person, I've still not come, A9 to A18, in furtherance of criminal conspiracy. He illegally procured, dishonestly received stolen property through A9 to 18 without DMG permit or trip sheets and supplied to MSPL by producing false mineral dispatch permits in connivance with A2 to A6.
15.47 is where they draw up all the names and
That's
the
right.
allegation.
That's only
At page 79.
I'm so deeply obliged. But there is no substantiation, justification, documentation, material which can be proved in trial, Lord, as and when the trial is to go on, which will justify my connivance. They must say that 2 people met, they knew each other, there was a contract, the contract was sham. There's absolutely nothing in the entire charge sheet. So, Lord, this is as far as, Lord, the main issue that I am a purchaser. Except for mentioning me in one line, there's absolutely no role attributed to me. Point number 3, my lords, just paraphrasing what Mr. Naidu has already argued, is that they have adopted a pick and choose policy, both in terms of, my lords, registering FIR. In some cases they'll register, in some cases they'll not register. No public servants, my lords. Now, my lords, last 2 points, my lords, which are sort of shared between me and Mr. Naidu, my lords, is 1, no conspiracy, my lords, and 2nd, delay. My lords, on facts, my lords, there is nothing else for me to add, my lords, other than showing the charge sheet which we have shown. Just 2 judgments, if your lordships can, my lords, take note of.
On delay?
Lords. No, my lords, on conspiracy. Lords, traditional judgments, your lordships are aware, my lords, I am not repeating them.
Yes.
There are 2 recent decisions, my lords, and in 2 lines each, my lords, I just want to place them. First is 2025 SCC Online 21, my lords have that.
Yes, I have.
Lords, kindly turn to, my lords, paragraph, end of paragraph 12 or para 13, my lords, as it pleases my lords. It should be, my lords, the SCC page 13. The last line of
paragraph 13, is it?
Yes, the 2 lines above that as well, my lords.
Yes.
Section, when put into a charge sheet, cannot be based on a bald assertion of connivance. There must be substance which is allegedly lacking in the present case. And then 13 is, my lord, something new which, my lord, I thought I have seen.
Yes.
If the intent on the face of it is absent for one of the offences in the same transaction, it is absent in respect of the other offence as well. This is very broad, but this is for the first time something, my lord.
There's a new
There's a
thing and
new
a broad one.
proposition which perhaps Supreme Court has laid down.
If one fish stings.
No, this is in context of conspiracy.
That's what. that
So
is
if
where-
I have not conspired, my lords, to steal, no question of, my lords, possessing stolen goods, no question of theft. This is perhaps, my lords, how it has to be understood in my most. The second judgment, my lords, is a slightly old judgment in the sense 2022 judgment, my lords. And the principle which the Supreme Court, my lord, I'll just read, lordship may not turn to it, it's the next, my lords. It says that for the offense of conspiracy, some kind of physical manifestation of agreement is required to be established. This is the proposition. Now, where is the physical manifestation except for inserting one line that in connivance with, you delete these three words, we are out of the charge sheet.
No, it is the imaginary manifestation of the prosecution.
No, it has to be physical and not imaginary.
If you manifest it, will happen. So that's the prosecution's
It
manifestation.
has to be physical, and that's why Supreme Court had to clarify
So
that you-
physical manifestation.
physical and not imaginary manifestation.
Yes, yes.
Lords. Lords, this is my additional 2 points, Lords. My 2 cents to already what Mr. Naidu has presented.
Yes, sir.
Very deep.
Yes. So, yes, Rahul. Senior Matara. 28th. Saturday, working day na ado.
Is it a working day?
I doubt. Illa, that's for the district courts. Not this. So 27th? 27th. You can appear online, so no problem.
Great.
So we will take your submissions are complete. Only in rejoinder if you want to
Yes,
submit
yes.
something.
We wanted to add
Yes.
anything, we
Yes.
great.
Very deep.
Heard the learned senior counsel, Rama Sheshadri Naidu, and learned senior counsel, Nikhil Goyal, appearing for the petitioners in these cases. The learned senior counsel have completed their submissions and would submit that if necessary, rejoinder submissions after the submission of the counsel for the CBI would be should be granted. Yes, the said submissions in the. Yes, that's what. So the learned counsel, Prasanna Kumar Niva. Learned counsel Rahul S. Reddy, representing P. Prasanna Kumar, counsel for the CBI, submits that they would meet the contentions on 27th, list the matter on 27th at 2:30 p.m.
If it's not inconvenient for your lordships and to my friend, could it be an earlier date? Let's.
I don't know. He asked for it.
We have not troubled them with long arguments. They should be happy on that count.
Of course, see,
So that we can
this
focus on.
arguments are precise. The points are there. Finish.
So
No,
my
that's
lords
it.
could accommodate and they could accept.
When do you want? When? We'll take it on 26th then, sir. Thursday.
So that
26th.
anything spilling over, we could finish.
Yes, 26th. Anything spilling over or rejoinder submissions on the next day itself, you can finish and we'll close it. Because Apex Court has directed expeditious
Exactly,
disposal, it is not
expeditiously
correct.
minutes. So it can't be tarried.
Yes, that's why I'm, other matters I've adjourned only for this.
That was the indication.
Yes,
It's already
yes.
decades.
Yes, that's what.
Great.
Dispose it. You have gone, it's your SLP,
26.
26th at 2:30 p.m.
Great.
Yes, for the hearing. Yes.
Admission cell number 2.
Srinath, what is this?
Minutes, this is a successive petition, minutes 465 and 420 minutes.
Huh?
Minutes, this is a successive petition. Your lordship's order would find at page 206, minutes, an earlier order. It was withdrawn with liberty, minutes. Then we approached the district court. But the
You're accused number 1.
Yeah, accused number 1, minutes.
Yes, sir.
This charge is 465 and 420 minutes. The offense is on 2/7/2014. Charge sheet came to be filed on 17/7/21 minutes after a delay of 7 years. Cognizance is taken on 3/8/2021. Insofar as first offense is concerned, 465 minutes, it bars under section 468 of CRPC. The limitation minutes does not. And insofar charge is concerned, minutes, you ought to put the few minutes, column number 17, page 75.
420, 465.
Yes, minutes.
We'll see, we'll issue notice.
That's now 2/7, my lords, it is being posted for
Huh?
2/7.
You're not audible, sir.
I'm sorry, my lords. For 2/7, my lords, it is posted for
No, no,
filing of
I'll
charge.
post it on 27th. List the matter on 27th. The learned additional SPP, B.N. Jagdish, is directed to accept notice for the first respondent.
Your Lordship,
Oh, Dharwad matter. Yes, madam.
Dharwad, please,
sorry.
Your Lordship, I'll take notice.
Learned counsel, Srimati Girija Hirimat, is directed to accept notice for the first respondent. Petitioner to, both the respondents, sorry.
Both
The respondents. The petitioner is directed to serve set of papers upon the aforesaid counsel forthwith. List on 27th. Madam, be ready on that day.
Please, Your Lordship.
Yes, madam. Intermod ಇದೆಯಾ ಇಲ್ಲ
ಇಲ್ಲ ಫಸ್ಟ್ ಟೈಮ್
ಫಸ್ಟ್ ನಂಬರ್ ಮೇಡಮ್ ಇದು ಆರ್ಡರ್ ಶೀಟ್ ಅದ್ರ ಎಸ್
List 2, giving on IA, seal number 1, Sirajuddin Ahmad.
ಅದಕ್ಕೆ ಕೊಡಿ ಮೇಡಮ್ ಎಲ್ಲ ನಿಮಿಷ ಲಿಸ್ಟ್ 2 ಅಲ್ಲ I8. What is the application?
That's for extension.
Question ಕೇಳ್ಬಿಡಿ. Yes. IA2 of 2025 is the application. IA2 of 2025 you have withdrawn.
Yes, Manoj.
Where?
In the Dharwad court, Manoj.
Before whom?
Before Justice.
SG Pandit ಸಾಹೇಬ್ರ ಮುಂದೆ ಬಂದಿತ್ತು.
Before Honorable SG.
ಕರೆಕ್ಟಾ?
Yes, Manoj.
ಅದೇ ಅಲ್ಲ ಮೇಡಮ್? ಮೇಡಮ್.
Accused number 8. As an instance of accused number 8.
Yes, sir.
It is dismissed as not pressed, my lords.
Before whom?
Before Honorable SG Pandit, my lord.
IA1 I have granted.
Yes, my lord.
IA2 and 3 come before Justice SG Pandit.
Yes, my lord.
IA3 he rejects.
Yes, my lord.
Correct?
Yes, my lord. He
IA2
rejects,
you
with
one minute, you withdraw. Then you IA4 you file.
Yes, my lord.
It comes before Justice Sachin Magdum. All right. There the learned judge says you have to go before the same judge who has granted extension or who has rejected the petition. It had to go before Justice SG Pandit. How did you move an IA that you have already withdrawn before me and ask for an
It
order?
is not written before your lordship.
No,
my
no,
lords.
withdrawn before other court.
Yeah,
IA2 is already
it is-
withdrawn as not pressed.
Yeah, it
1
is
minute,
withdrawn.
it is withdrawn as not pressed.
Yes, ma'am.
How did you again bring this before this court saying IA2 of 2025? IA2 is already withdrawn.
It is not IA, my lord. It is IA4, my lords.
Where is IA4? It has to go before the same judge. IA4 was what Justice Sachin Magdum has answered, that it has to go before the same judge.
Either rejected or which has granted, my lords.
Whatever. ಅಲ್ಲೇ ಹೋಗ್ಬೇಕು.
No, my lords,
No,
because your
no, not
lordship has
before.
granted, my lords.
Don't bring all this parole before
No,
me.
my
ಅಲ್ಲೇ
lords, because your
ಈಗ
lordship-
ಧಾರವಾಡದಲ್ಲಿ GM ಅಲ್ಲಿ ಯಾರಿದ್ದಾರೆ ಅವ್ರ ಮುಂದೆ ಹೋಗುತ್ತೆ ಅಷ್ಟೇ.
According to the
See,
order, my lords.
I said order on IA1.
Hmm.
I granted extension.
Yes, my lord.
Correct? One extension is over.
Over.
Now IA2 you file, you withdraw. IA3 you file, that Justice SG Pandit ಅವರು ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
With the liberty, my lords, because
IA3 favorably, accordingly is rejected, it's open for the seek parole of our son producing appropriate documents, nothing else. IA2 is dismissed as not pressed.
because the writ
So
petition.
go
number
before the same honorable judge. Yes. The order on Ivaten IA2 for extent, the order on IA2 for extension. IA1, or on IA1, this court had granted an order of extension of parole. IA2 and 3 later was preferred before the coordinate bench. The bench at Dharwad rejects the application IA3 of 2025 and holds and dismisses IA-2 of 2025 as not pressed. IA-4 of 2025 is preferred again before before another learned judge, who directs the matter be posted before the same honorable judge who had rejected IA-3 of 2025. IA-3 of 2025 is not rejected by this court. Not rejected by this court, and in the same order, IA-2 of 2025 is dismissed as not pressed. Now the council has moved the matter in IA-2 of 2025, which had been dismissed as not pressed, and the matter has to be placed before the honorable judge who had rejected IA-3 of 2024. Registry is directed to do the needful. Hmm.
230 more matters. Orders, seal number 1, Jyoti SK.
This is
Hmm.
defendant's petition, my lord. I'm challenging the rejection of my recall application, which I sought for further
Recall of which witness and why?
PW1, my lord, further cross.
When? At what stage did you file?
It was posted for defense evidence, my lord. Prior to, it was rejected only on the basis of a couple of adjournments sought by me.
How many adjournments?
My lord, maybe placed to the order sheet, my lord. The dates have been given very short, every 2-3 days. Now Friday also the matter was listed.
Madam,
Monday-
come to paragraph 7 at page 17.
Please, my lord.
Alla ide ella. A plain reading of the affidavit PW1 on 2 basic grounds. First, recording of defendant's evidence. 10/3/2025, no cross-examination. 24/2/25, no cross-examination. 10/3, again, it is posted on 15/3/25, no cross-examination.
15/3 same day ne ಮಾಡಿದೀವಿ. We filed on a recall, and on the same day, it was on a condition that the same day the cross to be done. So on same day now 15/3 ಗೆ ಮಾಡಿದೀವಿ. Then immediately it was posted for a defense, my lord, and 2 days ಒಳಗಡೆ ನಮ್ಗೆ there is one consent deed which has come into the knowledge. So hence a request for further cross.
What is the next date?
Tomorrow, my lord. Friday to Monday to yesterday it was there again.
Test the
it is-
matter on Friday. Petitioner to serve on the counsel who represents the plaintiff and file an acknowledgement by the evening of tomorrow. The concerned court shall defer its proceedings till the 23rd of June 2025.
Grateful, my lord.
Next.
But 2, Arvind Vichara.
My lord, in this matter, the petitioner has challenged annexure D, that is the notice issued by the respondent BDA.
Allotment.
Huh?
Allotment.
Allotment. In this matter, the notice has been issued by the BDA saying
Eviction
that,
notice.
there is partial encroachment of the site number 428, 475. In fact, BDA does not have jurisdiction to issue this notice because site number 428 and 475 is already sold in the year 2004 and 2003. I am the adjoining site owner having 11 guntas of land where I am running a school, my lord.
BDA in yaridar, madam? Hello, list it.
I have produced the sale deeds to the Kraya Patra of both the sale deeds, my lord, where the BDA has executed the sale deeds in favor of both private parties in the year 2003 and 2004.
Counsel Murugesh Vicharati is directed to accept notice for the respondents. Petitioner to serve set of papers upon the aforesaid counsel. The learned counsel for the petitioner, taking this court through the documents appended to the petition, would seek to demonstrate that the BDA has no jurisdiction whatsoever to issue the impugned notices. The learned counsel would submit that both the sites on which The BDA is now seeking to bank the notices are sold years ago, and the petitioners are adjacent landowners who have nothing to do with site number
428 and 475.
428 and 475. In that light, there shall be an interim order as prayed for till the next date of hearing. List the matter on 3rd July.
Please.
Serve a copy on him.
Please.
Number 3.
For the petition. In 2009, my lord, the acquisition proceedings was initiated for.
ಇದೆಲ್ಲ ತಗೊಂಡ್ಬಿಟ್ಟಿರ್ತೀರಾ?
ಅಲ್ಲ ಅಲ್ಲ sir, ಇದರಲ್ಲಿ ನಮ್ಮ ಮನೆ ಇದೆ. RTC 8 gunters, other acquisition I have not challenged, my lord. In 8 gunters of land, I have a house, my lord. And now three days ಒಳಗಡೆ ನಮಗೆ ತೆರವು ಮಾಡಬೇಕು ಅಂತ. I am having a dwelling house, my lord. I considering my objection.
ಆಯ್ತು, ಯಾವಾಗ ಖಾಲಿ ಮಾಡ್ತೀರಾ?
ಅಲ್ಲ ಖಾಲಿ ಮಾಡಕ್ಕಿಲ್ಲ ಸ್ವಾಮಿ. That it is in my own land. Other lands 27.5 gunters and 10 gunters I have given for formation
Auction of the property.
ಕಾಲುವೆ ಅಲ್ಲ ಆಕ್ಷನ್ ಅಲ್ಲ ಸ್ವಾಮಿ, ಎವಿಕ್ಷನ್ ಗೆ ನಾವು ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಮಾಡಿ ನಮ್ಮ ಜಾಗನ ನಾವೇ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಮಾಡಿದ್ದು ಅಂತ ಹೇಳ್ತಾರೆ. RTC ಪ್ರೊಡ್ಯೂಸ್ annexure C.
We'll see. Learned AGA is directed to accept notice for the respondent 192. Counsel KS Bhimaya is directed to accept notice for the third respondent. Registry to print the name of so and so is appearing for the third respondent. List the matter on 1st July. The respondent shall not, the petitioner shall not be evicted from the subject premises. Yes. Till the next date of hearing.
ಅಲ್ಲ ಪ್ರಾಜೆಕ್ಟ್ ಆಗಿ
List on 24th. All right. Sir ಮಾಡಿ ಇವತ್ತು.
Number 4, the period charge.
ಏನ್ ಕೊಡಿ ಅದು ಮೂವ್ ಮಾಡಿ. Petitioner shall serve on the counsel who represents the contesting respondents before the concerned court. And file an acknowledgement by in the next 2 days. List the matter on 25th July. Till such time, further proceedings before the concerned interim order. Till such time, there shall be an interim order. Oh, compromise 28. One ನಿಮಿಷ. Till such time, the further proceedings in miscellaneous 116 of 2025 before the so and so court has happened, before so and so court shall remain stayed. Next. ಸಲ ಮೇಡಮ್ ಏನಿದೆ ಮೇನ್ ಲಿಸ್ಟಲ್ಲಿ ಕರೆದು ಬಿಡಿ ಅನ್ಸರ್.
Further hearing. 2:30 PM 78.
ಇನ್ನು 10 minutes ಅಲ್ಲಿ ಏನಾಗಲ್ಲ. ಹೆಗ್ಡೆ ಸರ್.
Please, ma'am.
We have to raise at 3:45. Nothing is going to happen.
Yes.
We'll fix it again on Friday. Friday ಆಗ್ಬೋದಾ? Monday ಅಲ್ಲ, Tuesday? Monday ಆಗ್ಬೋದು. Monday, yes. 78 Monday ಹಾಕಿ. You are free on Monday? All right, yes. Monday.
79.
2:30 at Monday.
2:30ಗೆ ಇರೋದು 2:30, yes.
Please.
79.
23rd to 26th, I have some personal inquiries, my lords.
Friday is 20th.
Friday.
ಹಾ.
ಆಗ್ಬೋದು. Friday is
ಯಾವ್ದ್ರಲ್ಲಿ ಸ್ಟೀಲ್ ಹೈಪರ್ ಮಾರ್ಟ್ ಅಲ್ಲ?
79.
ನೀವು ಅಪೇರ್ ಆಗ್ತಿದ್ದೀರಾ?
My lords, I beg to appear online for petitioner number 3 in the matter. I'm unfortunately.
Yes, this is 20th. This will be 20th because Supreme Court has directed expeditious disposal. Yes,
ಆಗ್ಬೋದು ಸರ್.
80,
20th. ಅಲ್ಲ 80 post it on. Jagdish sir, ಯಾವತ್ತು? ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ನೀವಿಲ್ಲ, ತೊಂದರೆ ಇಲ್ಲ. CBI ಇರೋದು, ಅದಕ್ಕೆ 20th ಹಾಕ್ತೆ. ಇದ್ರಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ ಹಾಕಿರ್ತೀನಿ. 81 ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ.
82,
The 82 interim order ಎಲ್ಲಿ ಅವರು? ಅಷ್ಟೇ, will close it. The interim order is the final order. ಆಯ್ತು 20th ಬೇಡ. ಸ್ಟೇಟ್ ಇಸ್ ಅ ಪಾರ್ಟಿ ಅಲ್ವಾ? ಮಂಡೇ.
84, sorry, 83,
For the petitioner, request for tomorrow or day after tomorrow. Request for tomorrow or day after tomorrow.
ಫ್ರೈಡೆ. ಮಿಕ್ಕಿದೆಲ್ಲ ಫ್ರೈಡೆ ಹಾಕಿರಿ ಮೇಡಮ್. 20th.
My lord, serial number 85, my lord. There's a case of a para.
84 ಫ್ರೈಡೆ ಬೇಡ, ಅರ್ಜೆನ್ಸಿ ಇದೆ.
Wednesday, my lord.
ಕರೆಕ್ಟ್. ಅದು ಯಾವತ್ತು ಬೇಕು? ಮಂಡೇ. 84 ಮಂಡೇ.
85,
Wednesday, my lord. Can it be
Wednesday,
Wednesday?
84 Wednesday.
ವೆಡ್ನೆಸ್ಡೇ ಆಗಲ್ಲ. ಎಸ್.
I appear for the petitioner on 85, my lord. The lordships are directed that by today they're supposed to make the remaining payment, failing which for the
ಎಲ್ಲಿ
para
ಅದು?
swimmer,
ಒಂದ್
failing
ನಿಮಿಷ.
which.
ಮಿಕ್ಕಿದ್ದು 1 ಲಕ್ಷ ಕೊಡ್ಬೇಕಾಗಿತ್ತಲ್ಲ.
ನೆನ್ನೆನೆ ಹೇಳಿದ್ರು ಕೊಡ್ತೀವಿ ಅಂತ.
ಬೆಸ್ಟ್ ಆಫ್ 2.
No, my lord, they're reading the notification wrongly, my lord. In fact, before your lordships, this matter was argued vehemently by the state government, and your lordships are taken into account. There's absolutely no
ಈಗ
stance that they have,
ಕಾಸ್ಟ್ ಎಲ್ಲ ಇಂಪೋಸ್ ಮಾಡ್ಬೇಕಾ?
as well as interest, my lord.
ಇದೊಂದು ಮಾತ್ರ, ಇದು ಲಿಸ್ಟ್ ಮೇಡಮ್. 85 ಲಿಸ್ಟ್ ಟುಮಾರೋ.
Much obliged.
ಎಸ್.
86,
ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಮ್ಯಾಟ್ರಾ? ಸ್ಪೆಷಲ್
86,
86 ಏನು? ಎಸ್ ಜಗದೀಶ್ ಸರ್? ಮಂಡೇ ಆಗ್ಬೋದಲ್ಲ? ಮಂಡೇ, ಎಸ್.
87,
For the petitioner.
ಏನಿದು? ಓ ಕರೆಕ್ಟ್. ಓ ಅರುಣ್ ಗೋವಿಂದರಾಜ್. ಎಸ್ ಸರ್, ಮಾಡ್ಲಿ. ಎಷ್ಟು? ಹೌ ಮಚ್ ಸರ್? 5 lakhs. ಈಗ ಲಿಸ್ಟ್ ವಿಲ್ ಡಿಸ್ಮಿಸ್ ಇಟ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ, ಫ್ರೈಡೆ. ಬೈ ದೆನ್ ಎಷ್ಟು? another 25 lakhs. ಈಗ ಫ್ರೈಡೆ ಒಳಗೆ ಎಷ್ಟು ಪೇ ಮಾಡ್ತೀರಾ? ಸಬ್ಮಿಷನ್ ಬೇಕಾಗಿಲ್ಲ, ಪೇಮೆಂಟ್. ನೋ, ಸ್ಟಾರ್ಟ್ ಪೇಯಿಂಗ್. ಫ್ರೈಡೆ ಒಳಗೆ ಎಷ್ಟು ಪೇ ಮಾಡ್ತೀರಾ? ಹೌ ಮಚ್ ಆರ್ ಗೋಯಿಂಗ್ ಟು ಪೇ? Nothing doing. Yes. List, the interim order stands extended subject to the condition of payment of rupees 10 lakhs by 20th of June 2025. In the event payment would not come about, the petition would be, the interim order would stand automatically vacated. No, sir. Enough you have dragged till now. Yes. No. 10 lakhs, yes. Interim order is extended, sir.
Some more time than 20th.
Yes, then New Horizon.
I appear for the petitioner in this matter.
88 ಏನಿದೆ? Then close ಮಾಡಿ.
I need to seek
The learned
instructions.
counsel for the learned additional
Friday, my
SPP on instructions would submit that no charge sheet has been filed against the college. Idana? The submission is placed on record. In the light of no charge sheet being filed against this petitioner, the petition stands disposed, reserving liberty to the petitioner to knock at the doors of the court in the event of need. Yes, ಯಾಕೆ ಓಡ್ ಬಂದ್ರಿ?
Serial number 83.
ಮಂಡೇಗೆ ಹಾಕಿದ್ದೀನಿ. ಇವಾಗ 3:45 ಹೇಳ್ಬೇಕಲ್ಲ ಅಂತ.
Please.
89,
ಹಾ. 10 minutes ಇಲ್ಲಪ್ಪ. 3:45 you have to be there.
I just gave judgments today.
ಇಲ್ಲ, ಬಂಡ್ಲ್ ತಂದ್ಕೊಡ್ತಾ ಇದಾರೆ, ಅದು ಹೇಳ್ತಾ ಇಲ್ಲ. ಡೋಂಟ್ ವರಿ.
If My lord, if my learned friend will be heard for 2 minutes, my lord, this matter would be discussed.
ಟೈಮ್ ಇಲ್ಲ, ನಾಳೆ ಹಾಕ್ತೇನೆ.
Great. My lord, 2:30, my lord, tomorrow, kindly.
ಆಯ್ತು, then we'll, ನಾಳೆ 2:30 GMCPC ಇದೆ, I know. Time permits, we'll take it tomorrow. It will be at 2:30.
Kindly, my lord.
Yes. ನಾಳೆನೆ. ನಾಳೆ 2:30 ಎಲ್ಲ ಕೆಲಸ ಮುಗಿಸ್ಕೊಂಡ್ ಬನ್ನಿ.
Faithful, my lord.
Yes.
Lords, that serial number 4230 list, Lords, I'm sorry, I missed out the matter. Lordships have granted interim stay
ಕೊಟ್ನಲ್ಲ.
but stay of further proceedings is a matter where the matter is already disposed of.
Why have you sought that prayer?
Lords, interim order is sought, if your Lordships is
Interim order.
granting, Lords, interim prayer is to
ಯಾವ್ದು
stay.
1998 compromise stay ಕೇಳ್ತಾ
Therefore, Lords, I will not
ಹೆಂಗ
say
ಅದು?
that. Lords,
98
further
compromise
proceedings,
stay ಹೆಂಗ?
there is nothing for your Lordships to stay the further
Correct.
proceedings because it's closed.
ಅಲ್ಲ 98 compromise petition you are seeking stay of, how can I grant?
Lords, can I suggest this, my Lords? Before issuance of the notice, only on the ground that continuation of delay application is not filed.
11/6 ಗೆ ಹಾಕಿದ್ದೀರಾ, 10/6 ಗೊತ್ತಾಯ್ತು ಅಂತ ಹೇಳಿದ್ದೀರಾ, that's all right.
Now it is held maintainable. Lords,
Correct.
now in view of the latest judgment of the Supreme Court which says continuation of delay is not necessary.
You leave that, sir.
Yes.
Now you are seeking stay of the operation 23/6/1998.
Lords, that is the reason why I said, my Lords. Instead of that, my Lords, I will go before the trial court. The trial court dismisses the petition only on the ground that continuation of delay
Then we'll
application is
take it
not filed.
tomorrow in
Tomorrow,
preliminary
my Lords,
hearing.
so please,
See,
so
you
great.
urgent ಅಲ್ಲಿ ಕೇಳೋದು ಬೇಡ. Just tomorrow in preliminary hearing.
Please.
My lord,
Hand delivery, ಕೊಡಿ.
My lord, hand delivery.
Give that. ಹಾ. ಏನ್ ಬೇಕು?
ಅಲ್ಲ, ಡೇಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 75.
ಮಂಡೇ or ವೆಡ್ನೆಸ್ಡೇ ಬರ. ಯಾವುದು? 24th and 26th ಹಾಕಿದೆ ಅಷ್ಟೇ. ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಕೊಡಿ, ಸೈನ್ ಮಾಡ್ಬೇಕು. ಇಲ್ಲ ಮಾಡಿ.
Madam, 81 Monday, 81.
2 weeks.